Yeah. Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes. I lost all feeling from my head to my toes. You said some shit that I can't let go, so just stay tuned for the rest of the show. So have you ever felt betrayed? Switches how you see things, realize something needs change. Cause I know you got me fucked up, let me show you what's up. Cause enough is enough. I'll take a face full of pavement just to make a statement. I know there's no turning back. Oh God, adrenaline wasted, so mad I can taste it. I know there's no turning back.
All right, everybody. So welcome to our vertical live here. The deposition of Penny Phelps, exposing the frame up of Franklin Tyrone Tucker. So this is also, if you prefer to have a larger, more aesthetically pleasing view, you can view this on the featured live that we have going on. That would be the black background thumbnail. The red thumbnail trailer or thumbnail is for the vertical live here. So this case, as some of you who might be coming through here may have seen the deposition of Matthew Pitcher, the deposition of Paula Belmont. This is a series we're doing because Franklin Tucker goes on trial again in September. He's going to be on trial once again for charges that he is innocent of. The state of Florida knows he's innocent, and this is going to continue. We are going to continue to be exposing documents, exposing testimony, exposing this entire corrupt scheme to lock this man up. And you may ask, well, why? Why are they doing this? And it really comes down to they don't want to admit they're wrong, and they just don't like Franklin Tucker. And Penny Phelps just flat out doesn't like Franklin Tucker. And you're going to see that here in this deposition, how she feels about him. This deposition emanated from a wrongful termination lawsuit she filed and a defamation of character lawsuit she filed against Franklin Tucker, his wife, his attorneys, basically saying that because they were alleging that she had corruptly attempted to frame him, she had that they were defaming her character, that they were guilty of defamation of character. So this ended up, she filed a civil suit, and the judge, there were depositions, there was pleadings, and ultimately it didn't make it past summary judgment, which is a stage of a civil suit where basically after a certain point of evidentiary collection and hearings and depositions, it can be filed by either side. They can ask for summary judgment, basically saying a summary judgment from the defense throwing this out, or summary judgment by the plaintiff saying, hey, the evidence is so overwhelming that you don't even need a trial. Well, the judge looked at the case and said, this case is so weak. When he looked at the case, he looked at the evidence, he looked at the depositions, he looked at everything that happened and said, it's undeniable that she was involved in corruption, involved in covering up, involved in framing Franklin Tucker. And he issued a summary judgment, basically throwing out our lawsuit. It went to the Federal Court of Appeals recently, and it was affirmed. So this is the deposition that came out of that, where it discusses certain aspects of, it basically gets into her history, her background, and helps you better understand Penny Phelps and who she is, and the fact that, yes, she came to the Key West Police Department because she was fired from a previous police department. This is the detective that was involved in the investigation of this case. She was fired from a previous police department. She had a long history of problems and problematic behavior. So all of that comes out in this deposition. So anyways, with that said, without further ado, we're going to jump into it. Let's get started. Let's get watching and get listening. And please interact. Hit that like button. the goal here is to get this story out. We need to get this story out, and we need to let people know what is happening here, because an innocent man's life absolutely depends on it in the first week of next month. Because what's happened in this case, guys, you won't believe it. He had a mistrial, and I'm going to be re-airing that trial. So it's coming this week. We're going to be re-airing that trial over the next 10 days. I will be releasing a day of trial, and it will be entitled, it's going to be watching for it. And Hunter Paul, sorry guys, my son's decided to come into the studio and sit next to me. But it's coming out. I'm getting it prepared. It'll either be, I'll probably, it's a little late in the day to be dropping an episode like that, but we're going to start that tomorrow evening. So you will be able to watch that trial. I will be airing it both vertical. I will stream it live vertically and watch it with you guys, as well as I will be dropping it on an on-demand version so that you can come out and watch it in a full-throated, full way and see it fully. We'll be releasing it as a live stream and releasing it as a video drop, live premiere. But stop. Sorry, guys. But it's very important, because all of this is going to lead up to everything you've seen is going to give you some great background. If you go back and watch the previous lives I've done, the deposition of Matt Pitcher, and you look at what they actually present and what they bring to the jury. And essentially what they bring to the jury is John Travis Johnson, a witness that you're going to see and be able to assess and say, do you believe him? Do you think this guy is credible? Or, knowing all of the facts, circumstances, and things that you've learned through the deposition of Matt Pitcher, the deposition of Paula Belmont, now the deposition of Penny Phelps. Soon I'm going to be airing the motion to dismiss hearing from last July 2023 that has basically fully vets out, and you'll get to hear the fully vetted arguments of Ty's attorneys as to why the case should be dismissed, and they fully lay out all the problems. So anyways, with all of that backdrop coming in, you'll be able to see and rewatch that trial. Give me one moment. Anyways, apologize for the interruption, guys. But it's going to give us the opportunity, give you guys the opportunity to have all of this going in. And then, of course, once we get done with all of this over the next 2 weeks, 3 weeks, it's going to lead right into Ty Tucker's second trial. Now, I hope you will have armed, if you want to bring people in and start a conversation with people, you will be able to start that conversation and come over and say, hey, yeah, Christine, you can absolutely do that. That would be fantastic. But you air it. We want to get it out there for certain. But this should give you the ability to talk to people about this case. Send someone somewhere and say, educate yourself. You're going to be able to see the framing of Ty Tucker, exposing the framing of Ty Tucker and the important documents, the important depositions. You're going to be able to see important documentaries I've done breaking down discovery evidence, videos, the Todd O'Quinn videos. On top of that, you can go see raw footage for yourself, not without my commentary on Free Franklin Tucker. You can then also come and watch a clean version of the first trials. It's going to be clean with all the breaks out, it's going to be able to be streamlined, where some days are only an hour and a half, some days no more than about 4 hours of trial testimony because of the way it went. But you'll be able to see everything that happened, all of the witnesses, all of the evidence. And then that's going to lead us up, like I said, for the grand finale. What we hope is watching Ty Tucker defend himself yet again and beat corruption. We have to hope that happens, because Ty Tucker is innocent. He's absolutely innocent. And if he gets convicted in this case, it's going to be a tremendous injustice. Hold on one second, guys. All right. Apologize, guys. had to clear the little one out. But anyways, this is, this would be a monumental injustice for our justice system to allow this to happen to Ty Tucker. And we have to do everything we can to bring attention to it. We have to make the Florida authorities not feel comfortable doing this. And we have to tune in, watch, and do anything we can to try to bring attention to this situation, to make sure that Ty knows he's not forgotten in the absolutely horrible event that he would be convicted and sent to the Florida penitentiary for the rest of his life, because that's what he's facing. Anyways, with that said, guys, let's jump into this deposition. Let's get watching, and we'll go from there. So give me one moment. All right, guys. So I'm here. I'm not going to be here the whole time, but here it is. The deposition of Penny Phelps, Captain Penny Phelps. That's Penny up there. And we're going to go ahead and hit play.
Marco Jr. All right. So for the record, and I don't know if we were on the record when I talked about the protective order or the confidentiality agreement that Luke's document is called. My understanding is we are all in agreement that we are going to enter Luke's agreement that he sent to us back on Friday of last week. Mr. Savage, okay. Mr. Catanzaro, that's fine. Mr. Mastro Marco, Jr., okay. As far as there was, Mark sent to me about 2 days ago, I think it was Monday, might have been Friday, alright, Mark sent me the notebook that, or a copy I should say of the notebook that Judge Jones had ordered be produced in the criminal matter. We did not receive the original of the notebook back, which is, I believe the judge ordered that it be returned to Ms. Phelps after it had been copied, alright. I don't know where it is, okay, but I know that we did. The court reporter, who knows, she may still have it, I don't know. But I know it hadn't been returned. It's hard for me to read a lot of the notebook that it's not Mark's fault, it's just that, whatever copies we got weren't very good. So I'd like, to make a note of that. And I want to further make a note that we intend to bring a motion pursuant to Rule 501 and 502 of the Federal Rules of Evidence over this notebook, which we do not believe that the state court has the ability to bind a federal judge on whether this information is protected by attorney-client privilege or otherwise. My reading of the rule suggests otherwise. I'm not asking you guys to stipulate. I just want you to know that at this point, I just want you to know that we intend to bring a protective order on this document. All right? And as such I assume that you are going to all object to that because you did before in the state court, okay. So just for the record, we are going to seek a protective order over that document. And I'm not going, if I'm granted a continuing objection, all right, regarding the questioning over that document, if there is any document, questioning over the document, I'm not going to get, Mark, I won't interrupt you, but if I could get a continuing objection on that in light of what I'm representing to you at this time as far as, my intentions. Mr. Catanzaro, that's fine with me. Mr. Savage, are we ready to proceed? Mr. Mastro Marco, Jr., Mr. Savage, do you have any objection to that? Mr. Savage, it's not for me to object to. I don't have any dog in the hunt on that, Mr. Mastro Marco. I don't intend on using that in this deposition. So I'd like to move forward with your client's deposition at this time. Mr. Mastro Marco, Jr., all right. Okay. I'll hold you on that too. Mr. Savage, you can do that. Thereupon, Penny Phelps was called as a witness and, having been duly sworn, was examined and testified as follows. The witness, yes, I do. Direct examination, by Mr. Savage, Q. Good morning, Ms. Phelps. How are you? A. I'm fine. Thank you. Q. My name is Luke Savage with the law firm of Allen, Norton, and Blue, and I represent Sheriff Ramsey with respect to the claims that you've brought in this litigation. You've had your deposition taken before, correct? A. Hold on a second, Mr. Savage. We are having trouble with my sound, so just stand by. You are very low. Q. You've had your deposition taken before, correct? A. Yes, I have. Q. Okay. If you don't understand a question that I ask, please ask me to rephrase it and I'll be happy to do that. Please answer all questions verbally and try to refrain from nodding your head or saying uh-huh. Is there anything that would prevent you from truthfully answering any of the questions I'm going to ask you today? A. No, sir. Q. Okay. Are you taking any medications today that you think might prevent you from truthfully answering any of my questions? A. No, sir. Q. Did you speak with anybody other than your attorneys in preparation for this deposition? A. No, sir. Q. Okay. Did you review any documents in preparation for this deposition? A. Yes, I did. Q. Okay. Do you have any of those documents in front of you today? A. No, sir. Q. Okay. No notes or anything like that? A. No, sir. Q. Okay. Have you ever, Mr. Mastro Marco, Jr., Luke, she's, like, kind of talking over you. You have to wait for him to get his question out, Penny, before you start answering. The witness, okay. Thank you. By Mr. Savage, Q. Have you ever been a party to an employment lawsuit similar to this? A. Yes, I have. Q. Okay. Can you tell me the nature of that action, what the claims were? A. It was with the Bay City Police Department in Michigan. Q. Were you bringing a lawsuit against your employer? A. Yes. Q. What were the claims that you were bringing? A. It was for unlawful discharge. Q. You were fired by the Bay City Police Department? A. I was allowed to resign. Q. Okay. What were the charges? A. That I had been involved with a intimate relationship with a subordinate. Q. Had you been involved in an intimate relationship with a subordinate? A. Yes, sir, I was. Q. Okay. And the court that this was this in state court in Michigan or federal court? A. Federal court. Q. Okay. And when was it resolved, if it was? A. 2003 or 2004. Q. Okay. So after your employment began with the Monroe County Sheriff's Office? A. That is correct. Q. Okay. And when were you hired by the Monroe County Sheriff's Office? A. February 26, 2002. Q. At the time of your hire, who was the sheriff? A. Sheriff Richard Roth. Q. Okay. And your date of separation was December 19, 2019, correct? A. That is correct. Q. Okay. And the sheriff at the time was Rick Ramsey? A. That is correct. Q. Okay. You mentioned I think before that, before you were hired by the sheriff's office, you were employed by the Bay City Police Department. Is that correct? A. That's correct. Q. When did you start your employment with Bay City PD? A. July of 2000, 1982. Q. Okay. And then your last day of employment with them was approximately? A. December of 2001. Q. Okay. And what was your rank at the time of your separation from the police department? A. Deputy Chief of Police. Q. How long had you been the Deputy Chief of Police prior to your separation? A. 4 or 5 years. Q. Is that the second in command at the Bay City PD? A. Yes, it is. Q. And in your complaint you state that you are openly homosexual female. Is that correct? A. That is correct. Q. Okay. Has that been true since the date of your hire with the Monroe County Sheriff's Office? A. Yes, it has. Q. Okay. Was Rick Ramsey employed by the Sheriff's Office at the time you were hired? A. Yes, he was. Q. And what was his rank or title at the time of your hire, if you can recall? A. He was a captain and was overseeing the Bureau of Corrections. Q. To your knowledge, was Rick Ramsey aware that you were homosexual at that time? Mr. Mastro Marco, Jr., objection as to foundation, but go ahead. The witness, I don't know if he knew. I wouldn't know that. By Mr. Savage, Q. Okay. To your knowledge, when did he become aware? A. I knew he was aware of it in 2003, 2004. Q. Okay. When you were hired by the Monroe County Sheriff's Office, at what rank were you hired? A. As a captain. Q. Okay. What was your initial assignment? A. The Bureau of Corrections. Q. Okay. And were you assigned to the Key West Jail Support Services? A. No. I started out as the operations captain and my office was in Key West, but I oversaw the Key West Jail, the Marathon Jail, and the Plantation Key Jail. Q. Okay. And were you subsequently given additional assignments or different assignments? A. Yes. I eventually moved into the support services captain role. Q. Okay. Was that in 2005 approximately? A. I'm sorry, sir, you cut out. Can you repeat? Q. We all froze, I think. I was asking you, when you said you went over to support services, I was asking you if that was about 2005. Mr. Catanzaro, Luke, I'm fine. It must be on their end. Mr. Savage, I'm fine too. Yeah, they keep freezing. All right. Are you back? Can you hear me, Ms. Phelps? The witness, I am. By Mr. Savage, Q. We lost you there. You were in the middle of getting the word out and everybody froze, so I'll ask again. When you went to the support services area with corrections, was that approximately 2005? A. I don't recall. Q. Okay. Were you tasked with supervising subordinate officers or deputies when you were the support services captain? A. Yes. Q. Okay. And about how many people did you supervise at that time? A. I could take a guess. I don't know, sir. Q. Approximate. 10? 20? 2. A. Probably 50 or more. Q. Okay. And how long did you work in corrections for the sheriff's office? A. 7 to 8 years. Q. I think we've established your areas of responsibility changed while you were within the Bureau of Corrections. You went from operations to support. Did you do anything else besides that for the Corrections Bureau? A. Not that I can recall. Q. Okay. Were you at one point assigned to the Planning and Research Division? A. Yes, I was. Q. And the Professional Standards Division as well? A. That was all one unit. Planning and Research, Professional Standards, and Internal Affairs all came under one umbrella. Q. Okay. How about the Corrections Accreditation Division? A. I'm sorry, sir. You have to repeat your question. You cut out again. Q. Okay. I think the internet on your end may be a little bit lagging. Were you also assigned to Corrections Accreditation Division? A. That was part of my ancillary duties when I was with the Bureau of Corrections. Mr. Mastro Marco, Jr. All right. I'm back. Mr. Savage, are we ready to proceed? Mr. Mastro Marco, Jr. Yes. By Mr. Savage. Q. Ms. Phelps, were you subsequently removed from supervision of those divisions by Sheriff Parham? A. The supervision of what divisions, sir? Q. Professional Standards. A. Can you repeat it? Q. Sure. Sure. Definitely. Professional Standards, Planning and Research, Accreditation. A. Yes. Q. After this reassignment by Sheriff Parham, did you continue supervision of the Training Division? A. Yes, I did. Q. Had you held that assignment prior to the reassignment of the other divisions? A. When I moved from the Bureau of Corrections and took on the responsibilities of all those teams that you just talked about, I also had training as a responsibility. Q. So that was the only division that you were then going forward continuing responsibility for, correct? A. That is correct. Q. Okay. What was if you could describe for me your role or your responsibility as the director of the training division? A. I was responsible for training of new law enforcement and corrections recruits, as well as in-service training for our law enforcement and correctional sworn personnel, as well as training for our civilian staff. Q. Okay. And did you supervise anybody as the director of training? A. Yes, I did. Q. How many individuals? A. 3 trainers and an executive assistant. Q. Okay. After your reassignment to strictly training, were you subsequently promoted or given more responsibility by the sheriff? A. Yes, I was. Q. And that was Sheriff Ramsey that gave you that additional responsibility? A. Yes, he did. Q. When was the sheriff elected, Sheriff Ramsey, to your recollection? A. I believe in 2012. Q. Okay. In 2015 you were given the assignment over Special Operations, which I take it to include Major Crimes Unit and Narcotics Unit. Is that correct? A. That is correct. Q. Okay. And the sheriff at the time of this assignment was Sheriff Ramsey? A. Yes, it was. Q. He tasked you with that responsibility? A. Yes, he did. Q. Okay. What were your duties and responsibilities generally as the supervisor of Special Operations? A. I had a lieutenant that was between me and the day-to-day operational sergeants in both Major Crimes and Narcotics. Q. Okay. A. So I was responsible for the administrative reports for those units, responsible for the staffing, selection of people for those units, checking on the day-to-day operations through the lieutenant and the sergeant. Primarily administrative oversight of the 2 teams. Q. Did you have any investigative responsibilities? A. From time to time. Q. Would you consider that a promotion? A. I didn't receive any more money and I didn't receive an additional rank, so no. Q. Okay. But you would consider it additional responsibilities and duties? A. Yes. Q. Okay. And you also at that time retained your responsibilities as the director of training, correct? A. That's correct. Q. When was that assignment? Let me back up. If I say Special Operations, or Special Investigation, are those terms synonymous to you? A. Yes, they are. Q. Okay. I just want to make that clear for the record. So when you were assigned to MCU or Special Operations, Special Investigations, do you remember about what year that was? A. I believe it was 2015, 2016. I'm not certain. I'm not looking at my resume. Q. And you said you supervised a lieutenant and a sergeant, but approximately how many people did you supervise as the director or supervisor of Special Operations? A. Okay. Let me ask you a point of clarification so you and I are not speaking in 2 different venues. Q. Sure. A. I was the captain in charge of Support Services. Support Services head is part of my responsibilities Special Operations. So when you are referring to Special Operations and Special Investigations, are you merely referring to Major Crimes and the Narcotics Unit or are you referring to Special Operations as Support Services? Q. I'm not. The latter is not what I was doing, so thank you for clarifying, Ms. Phelps. So you were over support services for the sheriff's office? A. That's correct. Q. Okay. And as I take it that encompassed MCU and narcotics or special operations? A. That is correct. Q. What else did it encompass? A. I had the training division, I had the communications center, which is the dispatch center. I had criminal intelligence, school resource officers, the traffic division, the civil deputies, the court deputies, the school resource officers if I hadn't already said that, the bomb team, the dive team, the crisis negotiators, and aviation team. Q. What was that last one? I'm sorry. A. Aviation. Q. Aviation, okay. And that support services assignment that was given to you by Sheriff Ramsey? A. It was. Q. Okay. In support services, as supervising that entire list of areas, how many people did you approximately supervise for the sheriff? A. About 1/3 of the law enforcement bureau. Q. Okay. How many people is that, approximately? A. Probably 100 or more. Q. I'm sorry, you broke up a little bit. A. 100 or more. Q. Okay. Who was your direct supervisor over support services? A. It changed throughout the time that I was the captain in support services. Q. Okay. Who was your first one? A. Major Ken Duggar. Q. Who was the next one, subsequent one? A. Major Lou Caputo. Q. After Major Caputo? A. Major Chad Sibilia. Q. Okay. About what year was Major Caputo a supervisor of yours? A. Through part of Periam's last couple of years and then into Ramsey's first couple of years, so 2011 and I'm guessing, I really don't know. 2011 to probably 2013. Q. And then Major Sibilia was for the duration after that? A. Yes. Q. Okay. So around 13, approximately, to your separation? A. Correct. Q. Okay. After your assignment to support services by Sheriff Ramsey, were you subsequently given additional responsibility by Sheriff Ramsey? A. Originally I did not have major crimes and narcotics unit. I had those other teams but not major crimes and narcotics. After I had that assignment he then gave me those 2 additional teams. Q. What year was that, if you can recall? A. 2016, 2015, 2016. Q. When were you put over support services then? A. When Ramsey became the sheriff, so 2012. Q. So after you were given the additional responsibilities of MCU and narcotics, were you subsequently given additional responsibilities by the sheriff? A. Not that I recall. Q. Were you ever in charge of the construction of a range? A.O. The ancillary duties, and I did eventually also get placed in charge of HIDTA, which is the high-intensity drug trafficking area team, like in 2018, 17 or 18. Then as the ancillary duties Sheriff Ramsey did task me with the project of designing and getting the firearm range constructed. Q. Okay. Ms. Phelps, I'd like to transition a little bit to the topic of the Treehouse murder. Okay. A. Okay. Q. In November of 2017 you were in command of the Special Operations or Special Investigations Division, correct? A. Correct. Q. And as a part of that you were responsible for the supervision of the major crimes units, obviously, right? A. Correct. Q. Okay. In November of 2017, Matthew Bonnet was murdered. Is that correct? A. That's correct. Q. Okay. And was this murder kind of colloquially referred to as the Treehouse murder? A. Yes, it was. Q. Okay. In your role over major crimes you were responsible for investigating the Treehouse murder. Is that correct? A. I had shifting roles during the Treehouse murder. So you have to give me a time frame of when you are referring to. Q. Like maybe the initial, after the initial crime was committed and the next month or two. A. The night of the murder we had a Detective Sergeant Kellenberger respond to the scene, Detective Matt Pitcher responded to the scene, and Detective Danielle Malone responded to the scene, and Malone had only been with the major crimes unit for about a month. So because we had very few detectives and a lot to do, Kellenberger assigned Pitcher as the lead investigator and I was taking my direction from Pitcher. Q. Okay. A. As an extra pair of hands. Q. Okay. In your complaint in this matter, when I refer to that I'm going to refer to the first amended complaint. Okay. A. Okay. Q. You state in there that on or about November 20th, 2017, plaintiff discussed investigative strategy in the Sheriff's Office Criminal Investigation Office. Is that correct? A. That is correct. Q. Okay. Who were you discussing this strategy with at that time? A. Detectives Pitcher, Malone, and Sergeant Kellenberger. I believe throughout the conversation Detective Sergeant Smith was in and out of the room and Detective Fernandez was in and out of the room. Q. Okay. And on that date you recall that you spoke with the Deputy Lee Malone regarding devising a plan to obtain an identification for an individual by the name of Rory Detroit Wilson? A. I talked to Lee Malone by telephone Q. And it was regarding devising a plan to get an ID on Detroit? A. That is correct. Q. Okay. And your conversation in that investigation office was recorded, correct? A. Surreptitiously recorded, yes. Q. Okay. That office has recording equipment installed in it, correct? A. Negative, sir. Q. Okay. How was it recorded? A. The interview room has recording equipment in it. The offices do not have any recording equipment in it. I was sitting in the office. Q. Okay. Is the interview room adjacent to the office? A. Yes, it is. Q. And it can obviously pick up statements that are made in the office inside the interview room, correct? A. It picked up some of the statements that were made in the office, correct? Q. Okay. And explain to me what the equipment is typically used for? A. Conducting interviews or interrogation of people that are involved in criminal activity, either witnesses, victims, suspects. Q. Okay. And, to your knowledge, was major crimes using recording equipment that day for investigative interviews? A. The 20th? Q. Yes. A. I don't recall if the room was used on the 20th. Q. Do you know who was normally responsible for turning the recording equipment on and off? A. In this case, that interrogation room is located in the Sheriff's Office headquarters building located within the District 1 Criminal Investigations Unit office. The major crimes detective and I did not know how to operate the equipment. The only two people that were familiar with the equipment and capable of operating it were Detective Sergeant David Smith and Detective David Fernandez. So they would have been responsible for turning it on and turning it off. Q. Okay. To your knowledge, were Detective Smith or Detective Fernandez conducting interviews in that room previous to your investigative strategy meeting? A. There had been interviews conducted on that Saturday, November 18th. Q. You said on that Saturday, November 18th. Is that correct? A. Correct. Q. Okay. And so, to your knowledge, was the recording equipment left on by accident? A. I don't know, sir. I wasn't part of the interviews conducted on the 18th of November. Q. Do you know who was involved in conducting those interviews? A. Detective Pitcher, Detective Malone, and I believe it was Detective Fernandez. Q. Okay. And my question earlier was, is there somebody that is normally responsible for turning that equipment on or off, or is it this person that's conducting the interview? A. It's the person from the Criminal Investigations Unit's office responsibility to handle the recording equipment because they are familiar with how it turns on, how it turns off, how it uploads, how to store the video. Q. Okay. You allege in your complaint that Detective Sergeant David Smith and or Detective David Fernandez had neglected to turn off recording equipment used to record an interview in a nearby room within the Criminal Investigations office. Is that correct? A. That is correct. Q. Okay. So that's your understanding of how the recording equipment captured your conversations on November 20th? A. Correct. Q. Okay. Had Detective Matt Pitcher and Detective Danielle Malone used the recording equipment that day to conduct an interview in the Treehouse murder case? A. I don't recall. Are you talking about on November 20th? Q. Yeah. A. I don't recall. Q. Okay. If I told you that's what you allege in your complaint, would that help refresh your recollection? A. If I said that they used the room on the 20th? Again, sir, I don't recall. There might have been interviews conducted on November 20th, but they would have been later in the day prior to the discussion of the investigative strategy. Q. Okay. Is it possible that Detective Pitcher and or Detective Malone neglected to turn off the recording equipment? A. They weren't familiar with the equipment. They weren't using the equipment. It was Fernandez and Smith that were operating that equipment. Q. You are certain? You were there for them when they were, at the time they were operating it? A. No, I was not. Q. Okay. You allege in your complaint that, quote, the failure to turn off the microphone device allowed a portion of Plaintiff and Deputy Malone's telephone conversation to be surreptitiously recorded. That's correct, right? A. That is correct. Q. So someone either failed to turn it off or neglected to turn it off, correct? A. Or intentionally left it on. I don't know. Q. Do you have any evidence of it, that anybody intentionally left it on? A. I don't have anything to refute it. I just know it was left on. Q. I know, but my question is a little bit different. Do you have any knowledge, any facts to support that contention that somebody intentionally left it on? A. No, I don't. Q. Okay. Do you allege that Detective Smith or Detective Fernandez intentionally recorded the investigative strategy discussion on November 20th? A. I don't know if they did. I don't have anything to say they did or didn't. Q. Okay. Is it your understanding that this recording that we are referencing on November 20th was provided to the state attorney's office in the Treehouse murder case? A. Yes. Q. Okay. Is it your contention that a member of Major Crimes Unit provided this recording to the State Attorney's Office? A. Sir, I don't know who provided it to the State Attorney's Office. I know it got provided to the State Attorney's Office from someone from the Sheriff's Office. Q. Okay. Who normally has access to those recordings? The Major Crimes Investigative Room, Interview Room recordings. A. Again, let me be very clear, that room is not the Major Crimes Interview Room. That room belongs to the District 1 Criminal Investigation Unit, so that detectives that use that room and use that office are familiar and responsible for that equipment. The Major Crimes Unit wouldn't use that room and thus have no familiarity with the equipment. Q. Okay. Was Detective Smith and Detective Fernandez under your supervision as the Supervisor of Special Operations? A. Detective Fernandez had been temporarily assigned to assist us with the Treehouse murder. Q. Okay. So was he under your supervision at that time? A. Yes. Q. Okay. And Detective Pitcher and Detective Malone were both under your supervision at that time? A. Yes. Q. Okay. So during your employment, who, if anybody, was assigned responsibility for reviewing recordings before they are sent to the State Attorney's Office in a criminal case? A. It would be the lead investigator that's involved in the case and or the person that is uploading the videos from the system that they are recording on. Q. Okay. So in this case, with respect to this recording, or this, I guess with respect to the Treehouse murder case, that this time who was the lead detective? Was that Detective Matt Pitcher? A. Yes, it was. Q. So it would either be his responsibility to upload the video to the State Attorney, or it would be, review the video, or it would be who else? A. Fernandez or Smith would have been familiar with the equipment. Q. Okay. Do you know whether anybody reviewed this recording before it was sent to the State Attorney's Office? A. I don't know. Q. Okay. Do you know why this recording was sent to the State Attorney's Office? A. It's a part of the criminal investigation from the Treehouse murder. Q. Do you know whether the person or persons that sent the recording to the State Attorney's Office knew that it contained your discussion with Detective Malone? A. I don't know. Q. Okay. Now, I'd like to shift to kind of the substance of that discussion, if you will. You allege in your complaint that you and Deputy Malone discussed how you could confirm the identity of Rory Detroit Wilson without him perceiving that he was being targeted as part of the Treehouse murder investigation, correct? A. Correct. Q. Okay. And you allege in your complaint that you suggested to Deputy Malone that he hang out in the area near the warehouse where Wilson was staying in a marked unit and make a legal, as in not illegal, traffic stop of Wilson on his bike, correct? A. That's correct. Q. Would you characterize that as a ruse? A. Yes. Q. Okay. You allege in your complaint that through the legitimate traffic stop Deputy Malone could then identify Wilson's or verify Wilson's identity. Is that correct? A. That's correct. Q. Okay. And you go on to allege that because you and Deputy Malone were fearful that directly contacting Wilson might alert him to the fact that you were investigating him as part of the Treehouse murder, that you told Deputy Malone to play the part of a grumpy old man who had nothing better to do, a white supremacist who was simply messing with a minority who was riding a bike. Is that correct? A. That's correct. Q. Okay. I'd like to mark what I'll have marked as Exhibit 1, which is a copy of the internal affairs investigation in this case. I'm going to put it up on the screen for you. Mr. Savage, can everybody see this? Mr. Catanzaro, I only see a list of items. Looks like they are not open. Mr. Savage, yes, I got you. Is that better? Mr. Catanzaro, yes. By Mr. Savage, Q. Ms. Phelps, can you see this? A. I can. Q. Okay. This is going to be marked as Exhibit 1 for the defendant. The Internal Affairs Investigation Report was marked for identification as Plaintiff's Exhibit 1. By Mr. Savage, Q. The cover sheet here says Monroe County Sheriff's Office, Office of Internal Affairs, Iowa, 2019-046. Penny Phelps, Inspector Maxwell. Do you recognize this document, Ms. Phelps? A. I do. Q. I'm going to draw your attention to the investigative summary. This is the investigative summary. Do you recognize this portion of the IA report? A. I do. Q. Okay. I'm going to take your attention to page 2 of 12. It has these block quotes. I'm not going to ask you to read these out loud, and I don't think I need to read them out loud as well. So I'd like you to read, if you can see it adequately, the statements in block quotes with the quoting. Let me know when you are done and I'll scroll down to the other part of that when you are finished with this section. Okay. A. I am done reading that section. Q. Okay. A. And I have that. Q. Okay. A. And I'm done. Q. Okay. Do you admit to giving those instructions to Deputy Malone, correct? A. Absolutely. Q. Okay. So you don't deny you made any of those statements to him, correct? A. I don't deny it. Q. And you heard the recording, correct, of that? A. Yes. Q. I'm sorry. You've heard the recording of that November 20th, 2017 meeting? A. I have. Q. Okay. And you do not dispute that you made any of the statements attributable to you on that recording, correct? A. I do not dispute that. Q. Okay. In your complaint you allege that, quote, Assistant State Attorney Colleen Dunn informed Plaintiff, Detective Pitcher and Detective Malone to appear to an evidentiary hearing related to the criminal matters on October 4, 2019, and to inform other officers to be present. Is that correct? A. That's correct. Q. Okay. When you say criminal matters, are you referring to the Treehouse murder cases? A. Yes. Q. And you and other officers did, in fact, attend the court proceeding on or about October 4, 2019, correct? A. That's correct. Q. Okay. And other sheriff's deputies attended at your direction? A. Some of them at my direction, some at the direction of their supervisors. Q. Okay. And who attended? Let me ask a better question. Of those that attended under your direction, put those in a bucket, who else attended at the direction of somebody else? A. Okay. I'm going to clarify at my direction. It was at a request. Q. Okay. A. All of the people that were involved in courtroom attendance were asked if they had time to attend and if they were willing to attend the court proceedings. I talked directly to supervisors and Hoverson from the training unit. All other deputies were contacted, and, excuse me, Sergeant Corzin. So supervisors and Deputy Hoverson, everyone else was contacted through their respective supervisors. Q. Okay. Who were those supervisors, if you know? A. Sergeant Barney Siduk, Lieutenant James Norman, Sergeant Spencer Bryan, Sergeant Greg Corzin, Lieutenant Charlene Sprinkle. Q. Did all of those supervisors supervise people that were involved in the Treehouse murder case? A. With the exception of Lieutenant Sprinkle from Communications had a piece of the Treehouse murder because they had the 911 call, so yes. Q. Okay. Kara Higgins made a complaint to Internal Affairs regarding the officers in the courtroom that day. Is that correct? A. That's correct. Q. Okay. And she, Kara Higgins, represented one of the criminal defendants in the Treehouse case? A. That is correct. Q. Okay. I'd like to mark another exhibit. I'll share the screen with you. Can everybody see that? I'm going to make it bigger. It's not letting me make it. Do you recognize this document, Ms. Phelps? A. Yes, I do. Mr. Savage, I'm going to mark this as Exhibit 2 for the defendant. The October 4, 2019, memo was marked for identification as Defendant's Exhibit 2. By Mr. Savage, Q. This memo is a memo from the Colonel to yourself dated October 4, 2019. Is that correct? A. That's correct. Q. And then there's in the ray line there is 3 different cases, it looks like. Are those the Treehouse murder cases, as far as you know? A. Yes, they are. Q. Okay. And you recall receiving this memorandum, correct? A. Yes, I do. Q. Okay. It notes in there that, in the second sentence, that an internal affairs investigation has been opened to determine the validity of allegations of improper conduct, basically. Is that what you see? A. That's what I read, yes. Q. Okay. And then in the next sentence it says, in the interim, in an effort to avoid any appearance of impropriety, I am transferring supervision of these pending cases to Major Ched Sibilia. Is that correct? A. That's correct. Q. Is it your contention this memorandum was somehow improperly disclosed to Ms. Higgins? A. Yes, it is. Q. What is the basis for that contention? A. I received that memorandum from Major Ched Sibilia on October 4 when he served me with the notice of investigation for IA 2019-039, which was the complaint made by Higgins about the deputies in the courtroom. On the notice of investigation, on the directive lines it is clearly typed, see attached memorandum from Colonel Caputo. The memorandum was handed to me at the same time the notice of investigation was handed to me by Major Sibilia, thus making it part of the Internal Affairs investigative file and it should have remained confidential until that Internal Affairs investigation was closed as outlined in Florida State Statute 112. Q. Do you contend today under oath that this memorandum contained information that was obtained pursuant to the agency's investigation of the complaint? A. I contend that it is part of the investigative file as outlined in the notice of investigation and should not have been released. Q. I understand that. You said that earlier. I think my question was a little bit different. Do you contend sitting here today that this memorandum contains information that was obtained pursuant to the agency's Internal Affairs investigation IA 2019-039? A. Yes, I do. Q. Okay. What in that memorandum do you contend is information obtained pursuant to the investigation? A. Allegations of improper conduct. Q. Those words? A. Yes. It's part of the investigative file. It's pursuant to the investigation. Someone filed a complaint, Ms. Higgins filed a complaint and alleged improper conduct, therefore that memo is part of that internal affairs investigation file. Q. Right. So would you agree with me that Ms. Higgins' filing of the complaint gave rise to the IA? A. The accusations of improper conduct gave rise to the internal affairs investigation. Q. Right. And so then it was normally, well, we know that it was assigned an investigator, correct? A. Correct. Q. Okay. So the investigator, are you telling me today that the investigator in the course of his investigation found out that there were allegations of misconduct, or was he tasked with investigating those allegations of misconduct? A. Both. Q. Okay. In late October of 2019 the complaint was made by Kara Higgins and Franklin Tucker to the sheriff's office about your statements on November 20, 2017, that were contained in that recording. Is that correct? A. That's correct. Q. Okay. And as a result of that you were notified by the sheriff's office that an internal affairs investigation was going to be opened into the allegations? A. That is correct. Q. Okay. And that IA was referred to as IA 2019-046? A. That's correct. Q. Okay. On November 13 of 2019 you were served with a notice of investigation in that case, correct? A. Correct. Q. Okay. Excuse me, November 14th, sir. Q. Okay. A. It was authored on the 13th, given to me on the 14th. Q. Okay. So it was authored on the 13th and you were provided it on the 14th? A. Correct. Q. Okay. And Inspector Michelle Maxwell was assigned in that case to investigate the allegations? A. Into IA 46? Q. Yes. A. Yes. Q. Okay. And do you claim that Inspector Maxwell was biased against you in her investigation? A. Absolutely. Q. Okay. What is, if any, the basis for your contention that Michelle Maxwell was biased against you? A. Michelle Maxwell and Kara Higgins are extremely good friends. They vacation together, socialize together, attend each other's weddings, Christmas, birthday parties. That assignment never should have occurred because of the conflict of interest. Q. Okay. And what is the basis for your contention that they are very good friends, or even as best friend as you've characterized them? A. Facebook posts, seeing them in attendance at social events, fundraising events, the fact that they vacation together and post vacation photos together. I have pictures of them at Maxwell's wedding in West Virginia. So she traveled out of state to attend, Higgins traveled out of state to attend a wedding. The photograph evidence of their friendship is extremely clear. Q. Okay. So your view from viewing photographs, you believe that you can hold the opinion that they are best friends? A. I wouldn't say best friends, but they are very good friends. And it's not just photographs, sir, I've seen them at social events and fundraising events. Q. Okay. But in your interrogatory responses you called them best friends. So you're saying that it's different now? A. They are very close friends. I believe it was Higgins that referred to Maxwell as a best friend in a Facebook post. Q. Okay. And those Facebook posts are strictly from Ms. Higgins, correct? A. Some of them are from other people. Q. Okay. But none of them are from Inspector Maxwell, correct? A. I don't believe so, sir. Q. Okay. Now, during this period when you were notified of the investigation in 046, you were still supervising the Major Crimes Unit and the Narcotics Unit, correct? A. Yes. On November 14th I still had supervision of them, yes. Q. Okay. On or about November 19th of 2019, you met with Colonel Caputo and Major Sibilia regarding your command of those units. Is that correct? A. That's correct. Q. Okay. Is it true that Major Sibilia had been having discussions with you about your command supervision of those units since about January of 2019? A. Absolutely not true. Q. Okay. What about that is not true? A. There were no discussions. There was a discussion between myself and Major Sibilia in January of 2019. We had gone through 3 sergeants in the Major Crimes Unit in about a year and a half because of transfers and retirements. He had done an audit of the open cases in January, sat with me with the audit report, and we went through the cases. He gave me direction to work with a new sergeant to get the cases cleaned up. There was no discussion from January 19th until November 19th of 2019 between Major Sibilia and I whatsoever about the status of any of those investigative files until I suddenly received all those internal affairs complaints. Q. Okay. Do you contend that when Major Sibilia addressed that with you in January of 2019, he was doing that for an improper purpose? A. No. I think he did it for a legitimate purpose. We had gone through 3 sergeants and he ran an audit report. He had outlined the cases that he wanted addressed with the sergeant, so he addressed it with me. I addressed it with the lieutenant who addressed it with the sergeant, and we changed some of the procedures that were going on in major crimes to address the Major S concerns. Q. Okay. Did he address his concerns with you that he had found several areas in cases that lacked proper investigation, management, and oversight? A. No. His primary concern was that a lot of cases had not been properly closed, they were remaining open without any status. That the assignments seemed to be not equally distributed amongst the detectives. He addressed a variety of concerns in January of 2019. The state attorney's office said that they weren't getting the proper notifications. So we changed the way we did the electronic management of the system. So there was a variety of things that he discussed in January of 19 and we put a system into place to address his concerns. And I had no conversations with him between January and November about his concerns. Q. Okay. In January, did he give you instruction that it was your responsibility ultimately for all of those things to get done? A. He told me to get the sergeant on board and get the sergeant to do his job. Q. Okay. Was that your responsibility then? A. Yes. Q. Okay. I'd like to show you what we are going to mark as exhibit number 3. The November 22, 2019, memo is marked for identification as Plaintiff's Exhibit 3. Mr. Savage, can everybody see that document? By Mr. Savage, Q. Ms. Phelps, can you see this document? A. Yes. Q. Okay. Ms. Phelps, do you recognize this document? A. First time I've ever seen it. Q. Oh. You've never seen this memorandum? A. No. Q. Okay. You never saw it even after your separation from employment? A. No. Q. Okay. Do you contend that, well, ultimately on December 4th of 2019, you were removed from the command of major crimes and narcotics, correct? A. That is correct. Q. And you received a memorandum from Colonel Caputo to that effect? A. I don't know that came from the major. I don't remember. Q. You did receive a memorandum, though? A. Yes. Q. Okay. And it informed you that you were being removed from the command of Major Crimes and Narcotics Unit and that Patty Thompson was being assigned to that responsibility? A. That's correct. Q. Okay. Was that Director Patty Thompson? A. That's correct. Q. Okay. Is Patty Thompson a female? A. Yes. Q. Is Patty Thompson homosexual? A. Yes. Q. Do you contend that this action had something to do with the pending internal affairs investigations? A. Yes. Q. Okay. What's the basis for that contention? A. As I said previously, he had raised some concerns in January 2019. There were no discussions until November 19 of 2019. My command of major crimes and narcotics was challenged after I met with Major Sibilia on November 14. I expressed concerns about getting 3 internal affairs complaints on one day and asked him if he had a 4th. He laughed at me and I told him that the situation was not the least bit funny to me, that I was very uncomfortable with what was going on and I felt that I was being hung out to dry. And I asked him if I was being asked to resign or they are piling on all these internal affairs investigations in an attempt to get me to resign. He said he didn't know. He didn't think I was going to be hung out to dry. But his exact quote was, "I have not been privy to all their conversations," which genuinely concerned me. And I said to him, "Major, penny to Chad, if you were sitting where I am sitting, would you get an attorney? I am very uncomfortable with what is occurring." He told me that he couldn't tell me to get an attorney or not get an attorney. He reiterated that he had not been privy to all the conversations. So I told him, I said, "I think it's going to be in my best interest to retain an attorney as we move forward in this internal affairs investigations." And he told me that was my prerogative. 5 days later, after this investigation conversation with Major Sibilia, 1am getting relieved from my command from the Major Crimes and Narcotics Unit right on the heels of these 3 internal affairs investigations, a 4th one that I had received, again, the deputies in the courtroom from Higgins, and my commentary that I was going to retain an attorney. I find it highly suspect the timing of this removal. Q. Are you reading from something when you give that long statement? A. No, sir, I'm not. I lived it and I know it. Q. Okay. I'm just making sure. So it's the timing of the thing that gives you the basis. Am I gathering that correctly? A. Mr. Savage, there's no discussions about any of the performance issues in the Major Crimes Unit from January 19 until November 19. There's nothing in my performance evaluation. There are no notes in my employee tickler file. There's no memorandums outlining anything that needed to be done or still wasn't being done. Nothing. A discussion in January and then November, 10 months later, I'm being removed of command without any notice whatsoever that the performance issues that he wanted fixed in January had not been corrected up to his standards. Nothing. I find it suspicious, highly suspect. Q. Okay. Is the suspicion based upon the timing as well? Mr. Mastro Marco, Jr., well, I'm going to object as to you asked and answered, the question and that she answered it, but go ahead. Mr. Savage, you can answer, Ms. Phelps. The witness, I've already provided you with the answer, sir. By Mr. Savage, Q. Well, I don't know if I got that answer because I got a long rehearsed statement. I would like to know just, if you'd give me yes or no. Mr. Mastromarco, Jr., all right. Just a minute, Penny. There will be no more of that, Luke, all right. You do not need to treat her improperly calling her statement rehearsed. So I'm going to object to you doing that, and I don't want to have to involve the court, but please don't do that. By Mr. Savage, Q. Ms. Phelps, do you understand my question? A. I do, and I am going to reiterate that I am extremely offended that you think my statement is rehearsed. I've lived this hell for 2 years, sir. I know what happened to me, and I can tell you exactly what happened to me. My statements are not rehearsed. I've lived this, so I resent you saying what I'm telling you in my testimony is rehearsed or written out statement that I am reading from. It's not. I've lived it. Q. Okay. Do you understand the question I asked you before that? A. I do. The timing is one part that is extremely suspect. The fact that there was no follow-up conversation about what he identified as performance issues any time between January and November, there was no notes in my employee evaluation, nothing in the employee tickler file, no memorandum in the file, no continued contact between Major Sibilia and I between January and November that would give rise to all of a sudden out of left field we now have some concerns. In addition, I asked him on November 19th what caused him to bring this issue to light on November 19th. And at first he wouldn't answer me, and then I just had some serious concerns. I'm going to tell you like I told him on that date. I'm throwing, Mr. Savage, she's frozen. The witness, against me that was adverse, by Mr. Savage, Q. Ms. Phelps, one just have to stop you just because your computer froze. You said, you were at the point you said you were going to tell me like you told him that day, you are going, and then it froze. So you want to continue from there? I need to tell you like I told him that day when he gave me his answer that he just had some serious concerns and thought to take a look into those files. I told him, I'm throwing the bullshit card. I find it highly suspect. I told him that day that I believe Carrie Higgins was orchestrating the adverse employment action against me by filing all these complaints, and then further answering that I was being removed from the Treehouse murder and being removed from supervision of major crimes and narcotics. Q. Did you believe at that time that Major Sibilia was taking that action against you or recommending that action be taken against you because of your sex? I didn't know. Q. Okay. Did you contend or believe that day he was taking that recommended action against you because of your sexual orientation? I know that the two people between me and the detectives whose issues he had were both straight white men. Q. That's a different question, Ms. Phelps. Let me answer it. Q. Answer my question first, then you can tell me, Mr. Mastromarco, Jr., no. 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 Let her answer. If you don't like her answer, that's fine. Continue your answer. The witness, the action that was being taken against me. The captain that does primarily administrative oversight of the unit. There was no adverse employment action taken against Lieutenant James Norman, who is a straight white male, and no adverse employment action taken against Sergeant Barney Siduk, who is a straight white male. I was the only one being held accountable for any of the activities in that major crimes unit. By Mr. Savage, Q. Ms. Phelps, my question was, did you believe that he, at the time he told you he was recommending you be removed from major crimes, that he was making recommendation because of your sexual orientation? A. Yes. Because he took no action against the straight white males who were also in that chain of command. Q. But you knew that at that time? Mr. Mastromarco, Jr., same objection. The witness, you are going to have to repeat your question, Mr. Savage. You froze. By Mr. Savage, Q. Sure. The question was, you knew that at the time he was making the recommendation? Mr. Mastromarco, Jr. Same objection. The witness, I knew he was not taking any action against Norman and Siduk, correct? By Mr. Savage, Q. On November 19th you knew that, correct? A. Yes. Q. On December 14th you knew that as well? A. Right, because the only person that was removed from the chain of command was me. Q. The other two individuals, Lieutenant Siduk one think you said? A. Lieutenant Norman and Sergeant Siduk. Q. Okay. Lieutenant Norman and Sergeant Siduk, were they charged with supervision of major crimes and narcotics units? A. Yes, they are. Siduk has the responsibility of the day-to-day operations and Norman has oversight of Siduk. Q. Were they supervisors of you or you supervisor of them? A. I supervised them. Q. So we're above them in the chain of command, correct? A. Correct. Q. And in a law enforcement agency the chain of command goes up and down, but if it's going up as far as responsibility is concerned, you had the ultimate responsibility before Major Sibilia for the major crimes unit, correct? Mr. Mastromarco, Jr., Form and Foundation. Go ahead. The witness, it's interesting that you bring that up because I asked Major Sibilia that same question on December 4th when we met with Colonel Caputo, how come he wasn't being held accountable for his participation in the lack of oversight on the major crimes unit since he had addressed it in January and waited 10 months to address it again in November. I turned to the colonel in that meeting and asked the colonel specifically, "And what action are you going to take against Major Sibilia?" And he told me that was not my concern. And as far as I know, no action was ever taken against Major Sibilia by Mr. Savage. Q. My question was whether or not you had ultimate supervisory responsibility for MCU before it got to Major Sibilia. Is that yes or no? A. Yes. Q. Okay. Thank you. Mr. Savage, I'd like to mark, I think I'm on 4. The December 4, 2019, memo was marked for identification as Plaintiff's Exhibit 4. By Mr. Savage. Q. Ms. Phelps, can you see this document? A. Yes. Yes, I do. Q. My question to you is, do you see any reference to any internal affairs investigation or any investigation whatsoever into you in this memo? A. No. Q. Do you believe that Colonel Caputo, in issuing this memorandum to you, was discriminating against you based upon your sex or sexual orientation? A. Yes. Q. What's the basis for that? Is it the same as what you mentioned earlier? A. Yes. Q. Okay. Did you report that to Human Resources? A. No. Q. And you're aware that all of the internal affairs investigations that were pending against you were all still pending at the time that memorandum was issued on December 4th, correct? Mr. Mastro Marco, Jr., objection as to form and foundation. The witness, Mr. Savage, 1. Don't know if IA 2019-042, which was later turned to a preliminary review, was still open at the time or not. That one might have been closed but the rest of them were still open. By Mr. Savage. Q. Did you receive any disciplinary action with respect to 042 that you can recall? A. No. Q. Okay. So you are not sure that was an IA, is that what you said? You said it was a preliminary review? A. No. It was initially an internal affairs investigation, later changed to a preliminary review. Q. Okay. And you are not certain when it was changed to the preliminary review, or are you? A. It was sometime during the first week of December, but I'm not sure if it was prior to the December 4th memo from Caputo. Q. Okay. Do you know what the outcome of that 042 was, the findings? A. 042 was an allegation that started out about me improperly recording time on my timesheet, which was handed to me on November 14th along with IA 43 and IA 46. IA 42 was a 4-month-old complaint that the agency had received and was handed to me on November 14th. And then it was later determined that there had been nothing wrong with what I had done and it was changed to a preliminary review and the IA was cancelled. Q. Okay. So that was the outcome, that it was, you were determined not to be at fault and the IA was cancelled? A. I don't believe it says not at fault. It says the IA was cancelled. Q. Well, you said, I think, something to that effect. Were you determined to be at fault in any way? A. The determination that was made is that it wasn't anything that I had done with any timesheet, it was a clerical thing done by finances. So the IA was cancelled. Q. So you were not at fault then. Is that right? A. I don't know what the document says for sure without looking at it in front of me. I know the email from Lieutenant Captain Wheelwright says it's cancelled. Q. Did Carrie Higgins or Franklin Tucker or anybody else make that, the allegations in 042 against you, or was that something separate? A. I don't know. It was an anonymous letter. I don't know who made those allegations. Q. Okay. The first actual internal affairs investigation that was concluded against you with evidentiary findings was 046, is that correct? A. That's correct. Q. And that was concluded on December 13, 2019? A. That is correct. Q. Okay. And you are aware that Major Sibilia, after reviewing the investigative file, recommended that you be terminated, correct? A. I don't, Mr. Mastro Marco, Jr. Just a minute. Just a minute. All right. I'm going to place an objection to form and foundation. Go ahead. The witness, I don't know if he reviewed the file. I know he made a recommendation to terminate me. By Mr. Savage. Q. Okay. I think this was marked as 1. I'm going to share this again. This is from your internal affairs file, which we previously marked as Exhibit 1. Did you receive this memorandum from Major Chad Sibilia on December 14, 2019? A. I did. Q. Okay. And did you review it at that time? A. Reviewed this letter? Q. The memorandum, yes. A. Yes. Q. Okay. Now, in the first sentence that he writes in here he says, after reviewing internal affairs investigation IA 2019-046, and then he goes on. Do you, A. correct? Q. After reading that, do you have any reason to believe that he did not review the internal affairs investigation file? A. I can tell you he's written that he reviewed it. Q. Okay. Do you contend sitting here today that the Major's stated reasons for his recommendation for termination are actually a cover for discrimination against you? A. Rephrase your question. What do you mean by a cover? Q. Well, he didn't mention your sex or your sexual orientation in his memorandum, did he? Mr. Mastromarco, Jr., objection as to the document speaking for itself. Mr. Savage, you can answer, Ms. Phelps. The witness, he does not mention sex or sexual orientation. By Mr. Savage, Q. Okay. So I'm asking you whether you contend sitting here today that his recommendation was really just a ruse for discriminating against you based upon your sex or your sexual orientation? Mr. Mastromarco, Jr., you mean pretext? The witness, what I'm going to tell you, Mr. Savage, is I believe this document has no basis to serve as a reason for me to be fired. I think it's a pretext to my firing and had no basis in fact. By Mr. Savage, Q. Okay. Is it a pretext because of your sex or your sexual orientation? A. No one else involved in the Treehouse investigation, the heterosexual white males, were held to the standard of terminating employment because of allegations made by Higgins or Tucker. Q. The question was, do you believe that this was a pretext for sex or sexual orientation discrimination by Major Sibilia? A. Yes. Q. Okay. And the basis for that is because you think nobody else was held at the same standards as you? A. Right. Only the white female who was openly gay was terminated. Q. Okay. And now you receive this memorandum, you said, on December 14th, correct? A. Correct. Q. And you subsequently had a meeting with the sheriff and the major and the colonel, correct? A. Correct. Q. Did you say that they had discriminated against you because of your sex or your sexual orientation in that meeting? A. I read a prepared statement, Q. Okay. Sorry, I didn't mean to cut you off. A. I don't think I specifically outlined sex or sexual orientation in the letter. Q. Didn't even mention it, did you? A. I don't believe so. Mr. Mastromarco, Jr. Objection, argumentative. Go ahead. The witness, I don't believe I did. By Mr. Savage, Q. Okay. Do you contend that other individuals within the Treehouse murder investigation team made statements that somebody act like a neo-Nazi white supremacist just out to get the black guy riding a bicycle? A. I made those statements, sir. Q. Right. I'm asking if you contend anybody else made those statements? A. I don't know of anybody else making those statements. Q. Do you know of anybody else making statements similar to that? A. I don't know what was relayed beyond my initial discussion with Malone and with Lara, so I cannot speak to what others told people on their teams. Q. And you are aware that, if you are not you can say no, that Colonel Caputo, after reviewing the recommendation from Major Sibilia, agreed with the Major's recommendation to terminate you. Is that correct? A. That's correct. Mr. Mastromarco, Jr., same objection, form and foundation. By Mr. Savage, Q. Okay. And the memorandum here, which is part of Exhibit 1, it's page 130 of that exhibit, the previous memorandum was page 129. This memorandum dated December 13, 2019, from Colonel Caputo to the sheriff. You were served with this as well on December 14th? A. I was. Q. Okay. And you read this memo at that time? A. I did. Q. Okay. And do you sitting here today contend that the Colonel's stated reasons for recommending your termination are a cover-up for discrimination based upon your sex or sexual orientation? Mr. Mastromarco, Jr., say objection as to the term cover-up as, unless you know, rephrase to pretext. Mr. Savage, sure. Pretext, cover-up, whatever term you would like to use. The witness, pretext. I do. By Mr. Savage, Q. And what is the basis for that contention? A. Same thing I already stated. Q. And that would be that the white males that you would supervise weren't held to the same standard that you were? A. Correct. Q. And you are aware the sheriff, after reviewing the investigation as well as the recommendations of the major and the colonel, notified you of his intention to withdraw your employment, correct? A. That's correct. Q. Okay. In the sheriff's notice of intention to withdraw your employment, he provided you with an opportunity to have a predetermination meeting or a hearing with him. Is that correct? A. That's correct. Q. And you, in fact, elected to have that meeting with him, correct? A. Right. Q. Do you know whether or not the sheriff normally attends those meetings? A. Can you repeat your question, Mr. Savage? You cut off again. Q. Oh, sorry. Yeah, I didn't know that. Do you know whether or not the sheriff normally attends predetermination hearings? A. I don't know. Q. Okay. He did attend yours, though, correct? A. Yes. Q. Okay. Who else was in attendance? A. Major Sibilia and Major Colonel Caputo. Q. Okay. And at that hearing, that was on December 19th of 2019, correct? Ms. Phelps? A. Mr. Savage, I'm really sorry but you are breaking up badly. Repeat your question, please. Q. Yeah. The predetermination hearing, was that on December 19th, 2019? A. I just got the tail end of that, December 19th, 2019, I didn't get the first part. Q. I think it's your internet. A. Yes, sir, it was. Q. Your video keeps going in and out. Can you hear me now okay? A. I can hear you. Yep, I got you now. Thank you. Q. Okay. The question was, the predetermination hearing, was that held on December 19, 2019? A. Yes, sir. Q. Okay. And you were provided with an opportunity to state your position with respect to the findings and recommendations for your termination, correct? A. Correct. Q. And I think you mentioned it earlier, you read a prepared written statement addressed to Sheriff Ramsey? A. Correct. Q. Okay. And a copy of that written statement was given to the participants of that meeting as well? A. I don't know if all participants received a copy. A copy was left with one of the persons at the meeting. I'm not sure who we gave a copy to. Q. So you left a copy? A. Yes. Q. Okay. And you are aware that it made its way to the internal affairs file? Mr. Mastromarco, Jr., same objection as to form and foundation. By Mr. Savage. Q. If you are you aware that copy of your letter made it into the IA file? A. I don't think it's in the IA file, sir, not the copy that I was given. Q. Okay. Well, the copy you were given, was that given to you on December 14, 2019? A. Correct. But I was also mailed hard copies of documents after the fact and I don't recall if that came with those hard copy documents or not. Q. Okay. And in your letter to Sheriff Ramsey you defend your investigative strategy to have Deputy Malone play the role of a white supremacist neo-Nazi, correct? A. That's correct. Q. And I'm going to show you your letter. Is this your letter, Ms. Phelps? Did you hear me, Ms. Phelps? I'm not sure if you broke up or, Mr. Mastromarco, Jr., he was asking you if this is the letter. The witness, yes, it is the letter. By Mr. Savage. Q. Okay. And that was page 1. This is page 2. And this is page 3. And that's your signature at the bottom? A. Correct. Q. Okay. And you read, this is the letter that you read at the predetermination hearing? A. That is correct. Q. Did you make any other statements that are not contained in this letter to participants at the predetermination hearing? Mr. Mastromarco, Jr., when? At the hearing? Mr. Savage, yes. The witness, I was asked by Colonel Caputo if I had anything else to say, and I thanked them for their time. By Mr. Savage. Q. Okay. So that would be the substance of what you said in addition to what you read in that letter? A. Correct. Q. Okay. Now, let me see. In the second to last paragraph here, the paragraph starts on the middle of page 3, I'm directing your attention to. It says, on November 14, 2019, you wrote, you see that paragraph, where the cursor is hanging. A. I can see the paragraph you are referring to, but I did not hear the question. Q. I'm just making sure that you were looking at the same thing I'm looking at. This is the paragraph I'm referring to. I've highlighted it now. You see that? A. Yes, but you're, Q. We are having a real tough time with her signal. She's breaking up constantly. Can you hear me, Ms. Phelps? A. I can. Q. Okay. You are kind of cutting in and out. I'm not getting, the court reporter is not getting your answers, so I'm going to go slow on this, alright? This paragraph that's highlighted, this is the second to last paragraph on your letter that you read at the predetermination hearing, it's from page 3. In this letter right around here where the cursor is it says, you spoke to due process on December 11, 2019. Your words of December 13, 2019, were written without giving me the chance, afforded by law, to be interviewed as part of the internal affairs investigation. Did I read that accurately? A. Yes. Q. Okay. What is the basis for your contention that the sheriff's office was required by law to give you the chance to be interviewed as part of the internal affairs investigation? A. Florida State Statute 112, the Law Enforcement Officer and Correctional Officer Bill of Rights. Q. That's your belief or your understanding that requires the subject of an investigation to be interviewed every single time? A. Yes. Q. Okay. A. I also have due process rights as afforded by federal law to be notified of allegations. Q. You broke up. Are you there, Ms. Phelps? Can you hear me? A. I am. Q. Okay. You said something about federal due process then you cut off. Do you want to repeat that? A. Yes. Federal due process allows me to be notified of the allegations against me and give me the opportunity to respond. I was notified of the allegations against me and was given absolutely no opportunity to respond to the allegations before I was fired. Q. You were fired on December 19, 2019, correct? A. Correct. Q. Okay. You were notified of the allegations in the notice of intent to terminate you on December 14, when you received the letters, correct? A. Correct. And the memos tendered by Caputo and Sibilia were tendered on the 13th, prior to any statement being made by me, recommending my termination. They had not heard anything from me in response to the allegations. Q. Okay. And you were afforded, before you were notified of the final action of termination, you were afforded a predetermination hearing, correct? A. Which I believe was a farce. Q. But you were still afforded it, correct? A. Correct. Q. Okay. You stated everything that you wanted to state during that meeting, correct? A. Not everything I wanted to state, sir. Q. Did anybody stop you from saying anything, anybody meaning the sheriff, the colonel, or the major that were in attendance? A. I read a written statement. It was not all I wanted to say. Q. But the question, Ms. Phelps, was did the sheriff or the colonel or the major prevent you from saying anything that you would have otherwise said? A. No, sir. Q. Okay. In your letter here, and I know we touched on this earlier, but since it's now in front of you as we were talking about it before and it was not in front of you, if you want me to go to the top and let you read it, my question is, can you point out anything in this letter where you accuse the sheriff or anybody at the sheriff's office for that matter discriminating against you because of your sex or your sexual orientation? Mr. Mastromarco, Jr., the document speaks for itself, so objection. Mr. Savage, you can answer, Ms. Phelps. The witness, the course of that document clearly says that I believe I was fired because I used a ruse, which I didn't even use the ruse, let's back that up. We had a discussion of a lawful ruse that was never implemented. The ruse was used as a pretext for my firing. That is contained in that document. Very clearly I say in the document that I believe that's why I was fired. By Mr. Savage, Q. Okay. The question was, can you point out anywhere on your letter where you accuse the sheriff of discrimination against you because of your sex or sexual orientation? Mr. Mastromarco, Jr., same objection as to the letter, and it speaks for itself. Go ahead. The witness, the document speaks for itself. By Mr. Savage, Q. That's your answer, is the document speaks for itself? A. It does. Q. Okay. Mr. Mastromarco, Jr. She already answered your question. Mr. Savage, Mr. Mastromarco, want to appreciate your objection. It's noted for the record. By Mr. Savage, Q. If I read a part of this letter later, are you going to tell me that that's where you accused him of being a discriminator based upon your sex or sexual orientation, or are you conceding that it does not say that in there? Mr. Mastromarco, Jr. Same objection as to what the letter says or doesn't say or what she might say at some future point in some future time that's undisclosed by a question formed by you. Mr. Savage, Ms. Phelps, you can answer. The witness, I can't answer it, sir, because I didn't hear the question. I can't answer because I didn't hear it. You broke up. By Mr. Savage, Q. My question was is there anything in this letter that you would characterize? I know the letter speaks for itself, but do you have a belief that there's anything in this letter that some reasonable person should read as you accusing the sheriff of sex or sexual orientation? Discrimination? Mr. Mastromarco, Jr., same objection as to the questions. It's been asked and answered and also the form of the question. By Mr. Savage, Q. Did you hear the question? A. I did, and I can't answer for what you think a reasonable person would say when they are reading this letter. I can't speak for somebody other than me. And I've explained to you it speaks for itself. Q. I'm not going to just sit here and listen to the letter speaks for itself because I don't want. Here is my quandary and this is why the question is being asked. And Mr. Mastromarco, your objection is noted. I'll let it be continuing so that she doesn't get confused between your objection and my question, if that's okay. You, and thanks, Ms. Phelps, one appreciate it, you cannot probably form the opinion of what a reasonable person would do, so I'm going to ask you your opinion. In your opinion, is there anything in this letter that you would read as accusing the sheriff of sex or sexual orientation discrimination? Mr. Mastromarco, Jr., same objection. The witness, it's not specifically stated in the letter. By Mr. Savage, Q. Okay. Your attorney, was he in attendance for the predetermination hearing in some form? Mr. Mastromarco, Jr., whatever that means. Mr. Savage, well, I don't know if you were there in person or by telephone, so that's what I meant by in some form. By Mr. Savage, Q. Was your attorney present for your predetermination hearing either in person or by Zoom or by telephone? A. Mr. Kevin Kelly attended via telephone. Q. Okay. And did he provide the statement to the sheriff's office in your support? A. Yes. He read the document into the record. Q. Okay. Is that document a part of the record that you are aware of? A. Mr. Savage, I'm happy to rephrase my last answer because I don't believe we recorded that meeting at all, so I just believe Kevin Kelly read it and I don't recall if he gave them a copy of that or not. I don't remember. Q. You don't know if you gave them a copy of that? A. I don't remember. Q. Okay. Did Mr. Kelly's letter, to your recollection, accuse the sheriff's office of sex or sexual orientation discrimination? Mr. Mastromarco, Jr., Foundation. The witness, I don't recall the contents of the letter. By Mr. Savage, Q. Do you recall hearing the attorney who read the letter say anything to the sheriff accusing him of sex or sexual orientation discrimination? Mr. Mastromarco, Jr., same objection. The witness, I recall. By Mr. Savage, Q. OK. I'd like to show you, I'd like to mark this as exhibit number 5. I apologize, I'm coming back to this one. Do you recognize this document, Ms. Phelps? It's page 133 of exhibit 1. So it's not exhibit 5, this is exhibit 1. A. Yes. Q. OK. Did you receive this memorandum after your predetermination hearing? A. Yes. Q. OK. In the last sentence of, I guess it's the second paragraph, it says, you have a right to submit a written statement to your personnel file to refute or explain the reasons given for your dismissal. Do you see that? A. Yes, I do. Q. OK. Did you take up the offer to submit a statement to your personnel file to refute or explain the reasons given for your dismissal? A. Mr. Savage, before I answer that I'd like to go back to a previous question you asked me about being afforded the opportunity to give a statement prior to the predetermination hearing, if I may. Q. I don't think I had a question on that. I only asked you if you had an opportunity to attend a predetermination hearing to say whatever you wanted, right? A. You asked me if I thought I had a right afforded by law to an interview and I want to clarify something about that. Q. OK. A. In the week of December 4th, I think it was December 6th, I received a Dropbox link that IA-46, as did Mr. Mastromarco, that contained the contents of IA-46 for the request for an interview. So not only did I think I was entitled to an interview, but the sheriff's office at one time was going to interview me and then decided not to. So I was reflecting back on that and wanted to let you know that they also believed, in my opinion, that I was entitled to an interview because they tried to schedule one. Q. OK. Whether they scheduled one or not or tried to schedule one or not, do you know who made the decision not to interview you? A. According to the investigative summary it was Captain Holroyd. Q. Inspector General Holroyd? Same person? A. Yes. She holds a double title, Inspector General in Internal Affairs and also a captain. Q. OK. And you think that because she decided not to that she was violating your rights under Florida statutes? A. Correct. Q. Do you think she was doing that because of your sex or your sexual orientation? A. I don't know why she did it. Q. OK. A. We had attempted to schedule an interview, the sheriff talked about due process and then 2 days later I was terminated. I don't know what happened. Mr. Mastromarco, Jr., just for the record I'm going to object and make note of Caputo and Holroyd's deposition, or I should say Holroyd's deposition and what she said about that. By Mr. Savage. Q. Do you recall the question I had before that or should I ask it again? The one, you went back? A. Please ask it again. Q. So we were talking about the sheriff's memorandum terminating your employment dated December 19, 2019. You remember? A. I remember. Q. OK. This is the memo and I had directed your attention to the second paragraph, the last sentence. You see that there? A. Yes. Q. OK. My question was, did you take the sheriff up on the offer to submit a written statement to your personnel file to refute or explain the reasons given for your dismissal? A. No. Mr. Mastromarco, Jr., objection. I'm sorry, objection to form. By Mr. Savage. Q. The answer was no, ma'am. A. I did not submit a letter. Q. OK. During the last 3 years of your employment, Ms. Phelps, did you ever file a complaint with Human Resources alleging you had been discriminated against because of your sex and/or your sexual orientation? A. No. Q. What is the basis for your allegation that the sheriff terminated you because of your sex and your sexual orientation? A. The sheriff has fostered an environment where there is a proclivity to subjugate women. There have been numerous extramarital affairs between the command officers and female subordinates. The sheriff had been intimately involved with female subordinates. I was told at one point in my career by a lieutenant that you don't lose your wife at the Monroe County Sheriff's Office, you just lose your turn. Mr. Mastromarco, Jr., she's frozen. Excuse me, Penny, you are frozen. Okay. You were frozen for a few seconds there. Can you repeat that? The witness, yes. The sheriff has fostered an environment during his administration that demonstrates a proclivity to subjugation of women. There have been affairs between command officers and female subordinates. The sheriff has been involved with female subordinates as a command officer during the course of his career. He's been extremely angry because gay men asked me if he was gay and he got very offended by the fact that he was labeled as a gay male. The males in the particular situation that we were discussing today, IA-46, all heterosexual, all white, all males, were treated dramatically different than me. David Lares, Sergeant, greatly profiled 2 Latino men by asking their immigration status on 2 separate occasions in May or June of 2017. Ramsey refused to comment to the media about Lares' situation. He had lots of comments to the media about my situation. Lares was never investigated, never disciplined, not suspended, not demoted nor fired. And he actually engaged in discriminatory behavior and received nothing from the sheriff office. I discussed a lawful ruse that was never implemented. The traffic stop never happened. Deputy Lee Malone never made contact with Wilson. So I say to you, the discriminatory and disparate treatment between the white straight males in the agency under Ramsey's tenure as sheriff compared to me as a white female and openly gay is horrifying. By Mr. Savage, QOK. So you never filed an HR complaint about any of that, though, right? Because you said you hadn't filed a complaint in the past 3 years before your termination. I have reported some of the behavior to command officers throughout my career. QOK. In the past 3 years, what did you report? I have talked to Patrick McCullough and Major Sibilia about Ramsey's continued use of the word lawman. QOK. A. That verbally erases 50% of the population and 100% of the females when he uses that term. I had that discussion with him personally before he started running for sheriff when I was helping him with his public speaking. Q. Are you contending here today that his use of that term is personally discriminatory against you because you are female and gay? Mr. Mastro Marco, Jr., Luke, I think you broke up. I could hear her in the other room. Can you ask that again? Mr. Savage, yes. Sure. By Mr. Savage, Q. So the use of the term lawman, are you contending that the sheriff's use of that term even before he was sheriff is discriminatory against you personally? A. Yes. It erases me verbally as a female. I'm not a man. I'm not a lawman. And he's been explained to, by me personally, and also I reported that to McCullough and Sibilia. The sheriff also has. Q. Hang on. We'll just take that. We'll go to the next one. I want to stay on the lawman for a second. Did you report the sheriff's use of the term lawman as sexually discriminatory to human resources at any time during your career? A. No. It was reported to Sibilia and McCullough. Q. OK. Is human resources, as far as you understand it, the department or the bureau within the sheriff's office that is responsible for investigating claims of discrimination? You broke up. You froze. A. You broke up. I'm sorry about this. Mr. Mastro Marco, Jr., it's your connection. You know, in fact, I'm thinking of moving you to where I'm sitting because I've got an Ethernet connection instead of, you know, and let you sit here and testify. That might be helpful, okay. Luke, is that okay with you? Mr. Savage, yes. That's fine if it helps speed the thing up. That's fine with me. Mr. Mastro Marco, Jr., yes. That might be helpful. All right. I'm going to just mute myself. A recess was taken in the deposition, after which the deposition continued as follows, by Mr. Savage, QOK. All right. I think my question was, if I can recall. We were talking about the term lawman, the sheriff's use of that term even prior to his election as sheriff, correct? A. Correct. QOK. And my question was, do you contend that the sheriff's use of that term is personally discriminatory against you as a woman, and I think you said yes. Right? A. Yes. QOK. A. That's correct. Q. And then I asked you whether or not you had ever reported that to HR. You said you reported it to Patrick McCullough and Major Sibilia, correct? A. Correct. Q. I think my question where we got stuck was, are you aware that the Human Resources Division or Bureau within the Sheriff's Office is the division or bureau that's responsible for receiving and investigating complaints of sex discrimination? A. They also recognize when I report it to a command officer they have an obligation to report to Human Resources. I reported it to Major Sibilia and also to the Sheriff's General Counsel, Patrick McCullough, so I was reporting it. Q. Ms. Phelps, the question is different, though. I understand you want to answer it that way. The answer, for the record, is noted. The question is whether you are aware that Human Resources is the department that takes those complaints? A. Correct. Q. OK. You could have gone to Human Resources at any time during your career and reported his use of that term as discriminatory against you, correct? A. Correct. Q. You did not do that, correct? A. No, I did not. Q. When was the last time or the most recent time, in other words, that you contend you reported the sheriff's use of that term? A. Within the last couple of years. I would be guessing. Q. OK. So 2 or 3 years before your termination? A. Correct. Q. OK. All right. You also in your complaint allege that Sheriff Ramsey refers to female supervisors by Miss, such as Ms. Phelps or Ms. Penny as opposed to Captain Phelps. Is that correct? A. That's correct. Q. OK. Is it your contention that the sheriff only referred to you as Ms. Phelps or Ms. Penny and never referred to you as Captain Phelps? A. No, that's my contention. Very seldom did he refer to me as Captain Phelps, but he referred to me as Ms. Penny or Ms. Phelps. Q. OK. You also allege in your complaint that you had previously reported this alleged disparate treatment of female supervisors to Patrick McCullough and, however, defendant Ramsey continued to use such language. Is that correct? A. That's correct. Q. Okay. When did you report this to Patrick McCullough? A. Several times over the course of Ramsey's tenure. And Ramsey's last use of the Ms. Phelps was in this December 18, 2019, radio show when he referred to me as Ms. Phelps and not Captain Phelps. Q. Okay. And before that December 18th use of Ms. Phelps, when was the last time that you recall him using that term? A. I can't recall with any definitive time frame. Q. Okay. When was the last time, or I guess the most recent time is a better way to phrase it, that you reported this conduct to Patrick McCullough? A. That would have been probably in the last year. The discussion between Patrick and I centered around the fact that he didn't think the sheriff was being disrespectful, he just thought that's the way the sheriff referred to women. And he tried to say that using miss in front of a female might have been something that he was taught when he was a young boy, and that he, and Patrick assured me that he had had conversations with the sheriff trying to get him to remove that from his language, so that wasn't that long ago. Q. Did you tell Patrick McCullough when the sheriff said that to you he was discriminating against you based on your sex? A. I told him he was being extremely disrespectful by erasing my title and not acknowledging my title in the agency and just calling me Miss Penny. It was infantile when I'm in front of the command staff. Q. And this you said was within a year of your separation? When was it? A. Within the last year Patrick and I had this discussion about the miss. Q. Could you pinpoint it any more definitively? A. I'm going to tell you it was after Hurricane Irma because Patrick's office was still in the trailers we were using for offices, so sometime between 2017 and when I got terminated. Q. Okay. But was it in 2017 or was it in 2018 or was it in 2019? A. It was between the time they were using the temporary trailer and when they moved back to headquarters. I know I had a conversation with Patrick in the trailer. Q. That conversation was had within the trailer? A. Yes. Q. So they had not, sorry. Go ahead. A. Yes. The office, the trailer they were using for temporary offices. Q. So they had not yet moved back into the administration building? A. Correct. Q. Okay. And did you ever report that use of them as to human resources? A. No. Q. Okay. In your complaint, Ms. Phelps, you allege that on one occasion a sergeant referred to you as, quote, and I don't want to say this but I'm just quoting it, my dumb, the C-word captain, in front of a room full of recruits. And this was allegedly investigated by Major Sibilia. Do you recall making that allegation? A. Yes. Q. And who is the sergeant that you are referencing there? A. Fernando Lopez. Q. Okay. How did you become aware of that alleged statement? A. One of the recruits that was in attendance in class came forward. Q. Okay. And when did this comment allegedly occur? A. 2003, 2004, when I had just started to work for the sheriff's office. Q. And that was that Sheriff Roth? A. Correct. Q. Okay. In your complaint you allege that there was a fundraiser. During that fundraiser Sheriff Ramsey appeared on stage. And you allege, among other things, he was sitting in a chair and you describe what Michelle Maxwell is wearing. Do you recall that? A. Yes. Q. Okay. That fundraiser was on July 21, 2017? A. Correct. Q. Okay. And how did you become aware of the sheriff's appearance at that fundraiser? A. It appeared in the newspaper. Q. Okay. You were not in attendance at that fundraiser? A. No, I was not. Mr. Savage, we are getting some feedback. I think if you have people in your room with the microphone on. Are you hearing that? Mr. Mastro Marco, Jr., go ahead. Mr. Savage, if there is another audio device in that room streaming the Zoom I will pick it up and it will give a feedback, so we have to keep everybody else muted. By Mr. Savage, Q. Did you file a complaint with Human Resources when you became aware of the sheriff's appearance at that event? A. No. Q. Did you think that the sheriff's appearance at that event was discriminatory against you because of your sex or sexual orientation? A. Discriminatory against women. Q. Okay. Women generally? A. Yes. Q. Okay. In your complaint, Ms. Phelps, you allege that the sheriff had attended an event and at that one point a group of gay men requested the sheriff's phone number from you and were questioning the sheriff's sexual orientation. Do you recall generally those allegations? A. Yes, sir. Q. That event, when was that? A. 2003, 2004, it was the Florida Law Enforcement Gays and Lesbians Conference that was hosted in Key West. Q. Okay. And that was, Rick Ramsey was not the sheriff at the time, right? A. He was the colonel. Q. But he was not the sheriff, correct? A. That's correct. Q. Was that still Sheriff Roth? A. Correct. Q. Okay. And you said, in your complaint you say the sheriff gave the welcoming address. What you meant is that Colonel Ramsey gave the welcoming address. A. Now Sheriff Ramsey, then Colonel Ramsey, gave the welcoming address. Yes. Q. Okay. So he was invited to give that address by the Florida Law Enforcement Gays and Lesbians Conference? A. I don't know if he was invited. I think Roth turned down the invitation to speak. He wasn't comfortable with public speaking events. I don't know how Ramsey was the speaker. Q. Okay. But he participated voluntarily, correct? A. I don't know. You'd have to ask him. Q. Okay. So you don't know one way or the other? A. Right, I don't. Q. Okay. You allege that you notified that group that the sheriff was not gay because they started questioning his sexual orientation. Do you recall that? A. They wanted his phone number. And I told them I don't think he plays in your team, gentlemen. And they scoffed at me, told me my gavel was broken. Q. Okay. Did you dissuade them any further? A. I just told them that I didn't have his phone number, couldn't give his number, and I walked away from the conversation. Q. But then you allege in your complaint that your girlfriend, I guess at the time, I don't know if she's currently your girlfriend, so I'm not going to assume, she continued the conversation with those men and egged them on, I guess. Is that fair to say? I'm not sure. A. I missed the last part of your question. I got the first part about she continued the conversation and then tailed off. Q. Yes. I guess the allegation in your complaint makes it sound like she egged them on. I don't know if that's a term you would use, but did she provide them with information that would lead them to believe the sheriff was gay, or what happened? Tell me what happened, that you know. A. I don't know. I walked away from the conversation. She continued to participate in the conversation. What was said, the content of that conversation, I'm not aware of. I didn't include myself in it. Q. Okay. And you allege that the next day Colonel Ramsey called you into his office after learning, somehow he learned about the conversation your girlfriend had with those men. Is that correct? A. Yes. A sheriff's office employee was in attendance at the event and went and told Colonel Ramsey what was said. Q. Who was that employee? A. Kim Johnson. She used to be our payroll clerk. Q. Okay. And so the sheriff wanted to question you about that. What did he say to you? A. Well, he was extremely angry. Adamantly told me he was not gay. He was offended that I would even think he was. I told him I told the men I didn't think he was. He said, so you are not going to lie about the conversation? I said, I have no reason to lie about the conversation. I had it, I participated in a conversation with people that asked me about your sexual orientation. When they laughed at me and continued to push the issue, I walked away from the conversation. And he said, well, I want to let you know I am absolutely not gay and I am offended that you would even think that, and I'm really angry that you didn't stop the conversation. And I said, those people don't work for me. It was an off-duty event. None of these people are employees of the sheriff's office. I can control my behavior, and I walked away from them. He then told me that if I didn't get my girlfriend under control, I would not like what was going to happen. And I assured him that if he had a beef with my girlfriend, that the conversation that he was having with me needed to be had with my girlfriend, not with me, and the conversation ended. Q. Okay. And did you report that to Human Resources? A. No. Q. Did you report it to anybody at the agency? A. Probably 2 or 3 years later I had a conversation with then Sheriff Perriam about the behavior, but not in the way of a complaint. I just told him what had happened. Q. Okay. You also allege in your complaint that on another occasion a male deputy grabbed a female deputy's breast in front of several other deputies, that event was witnessed by a sergeant, and that the deputy who engaged in that conduct subsequently received a promotion to the rank of sergeant. And neither the deputy who engaged in the conduct nor the sergeant who failed to act or respond to act received any discipline. Is that generally your understanding of the allegation? A. That's correct. Q. Okay. And when did this alleged, as you describe it, battery occur? A. 2012, maybe 2013. I'm not really sure. You can find out about the time the deputy's promotion occurred because it was shortly before the promotion. Q. Was Rick Ramsey the sheriff at the time this occurred? A. Yes. Q. Do you know, personally do you know whether or not he was made aware of the incident? A. I know Human Resources was made aware of it. Q. Do you know whether or not the sheriff was personally made aware of the incident? A. I don't know. Q. Do you know whether or not the sheriff had input in any outcome of the investigation, if there was one, or any involvement in the matter whatsoever? A. I don't know. Q. Okay. What were the names of the individuals? Let's first start with the deputy who you allege committed the battery. What was that person's name? A. Nick Whiteman. Q. Okay. And who was the individual that he allegedly battered? A. Rosa DiGiovanni, Digiovanni. Q. Is she currently still a deputy? A. I don't know. Q. Okay. Was she employed by the sheriff's office at the time of your separation? A. Yes. Q. Okay. You don't know what her rank is, though? A. She was a deputy when I left. I don't know if she's still with the agency. Q. Okay. Now, who was the sergeant who allegedly witnessed this and did nothing? A. Sergeant Mark Mason. Q. Okay. And you said, I don't know, maybe you didn't. Did you tell me when you thought Nick Whiteman was promoted to sergeant? A. I don't know. I said I didn't know when this event occurred, but it occurred shortly after he was promoted to sergeant, so that would give you the date. Q. Okay. So you said, I think you said it was around 2012, 2013 is when the event occurred? A. I'm guessing. What I'm telling you is to narrow down the time frame. If you look at when Nick Whiteman was promoted, this incident happened shortly before he was promoted. Q. Okay. A. And I'm not sure on that time frame. Q. Do you know who made the complaint to Human Resources? A. I don't. Q. Do you know whether or not Deputy Sheriff Whiteman was already in line for a promotion at the time of the alleged incident? A. I don't. Q. Okay. Do you know who made the recommendation to promote Deputy Whiteman? A. I had the conversation with Patrick McCullough about that. Q. When was that conversation? A. Shortly after Whiteman got promoted, because there was an uproar within the female deputies in the agency about Whiteman getting promoted after the behavior, after grabbing Rosa by the breasts. And I went to Patrick and I said this has caused a lot of controversy in the agency and the women are not happy about him getting promoted after what he did to Rosa. And Patrick admitted that that was, in his word, his bad, that he had supported Whiteman's promotion. And he said he didn't think there would be such a strong negative reaction to it. And I said there is. The women are really angry that Ramsey has promoted him after what he did to Rosa. And that was shortly after Whiteman got promoted that I had that conversation with McCullough. Mr. Savage, do you remember what my question was before that? The question was thereupon read by the reporter as above recorded. By Mr. Savage, Q. When was that conversation? A. Shortly after Whiteman was promoted. I made it a point to go and talk to Patrick about what the women deputies were saying in the agency about Whiteman's promotion. Q. Okay. Ms. Phelps, one just generally asked you who do you contend was the person or persons who discriminated against you because of your sex or your sexual orientation? A. Well, it started with a dumb sea captain comment that happened shortly after I got hired by the sheriff's office. Then Sheriff Roth came to me personally when I was commander in the jail and apologized to me because Fernando Lopez only got a written reprimand for doing that. Ramsey was the lieutenant colonel at the time and according to Roth, had not told him about the situation, what had happened in the classroom, did not tell him that they had already tendered discipline against Lopez, that it was done without his knowledge. And he came over to the jail and he personally apologized to me and said he was absolutely offended that a sergeant would say that to one of his female captains and that had he known about it, he would have fired Lopez. And he told me there's nothing I can do about it because he's already been disciplined. It's really unfortunate because I hope you accept my apology. So that's when it first started. Q. Ms. Phelps, maybe I can narrow it down. Who do you contend? You have allegations in your lawsuit based upon the charge of discrimination that you filed with the EEOC, correct? A. Correct. Q. Okay. The allegations center around your termination from employment in December of 2019, correct? A. Correct. Q. Okay. Who were the people that you are saying now that had responsibility for your termination? Who were the people you are claiming discriminated against you on the basis of your sex or your sexual orientation? A. I'm saying everyone that was involved in this decision-making in this investigative process. Q. And who is that? A. The ruse was used as a pretext to fire me. So you have Sibilia, Caputo, Ramsey, Mike Rice was involved in the decision-making, Maxwell is the investigator, Holroyd is the inspector general. Anybody that had any decision-making action in this complaint. Q. Okay. A. Patrick McCullough. Q. Are you contending that Patrick McCullough made the decision to terminate you? A. I am saying I know how the discussion happened. When there is an employee facing termination, Patrick McCullough is involved in the discussions. Now, I can't say definitively, but based on how it happened in the past he would have been aware of what was occurring. Q. Do you have any facts or knowledge, personal knowledge that Patrick McCullough had any discussions around your termination in this case? A. I know he had a calendar date on October 23rd with Kara Higgins. Q. Ms. Phelps, the question is different than that. Do you have any facts that Mr. McCullough had any conversation with anybody about the decision to terminate you in this case, personal knowledge? A. I know that there was a series of text messages between Patrick McCullough and Sheriff Ramsey. On Friday the 13th of December, before I was served my paperwork, there was a flurry of text messages back and forth, call me before 500, we have to talk before 500. And again, do I know the content of the phone conversation? I don't. But it's right at the time frame when termination paperwork is being prepared and they are looking for me to serve me with my notice of intent to terminate. So I guess we'll have to ask Patrick McCullough. Q. Do you have any personal knowledge that he had a conversation with the sheriff about the decision-making process to terminate you? A. I just told you the knowledge that I have, sir. Q. You told me they sent a text message saying, call me before 500? A. And I said I know based on past practice he's had it. I gave you an answer. Q. How do you know based upon his past practice? What's your personal knowledge of that? A. I've been in a situation where I have been in the command structure of somebody being fired and there is always a conversation with the general counsel. The general order requires the general counsel to review the paperwork in an internal affairs file. So unless Patrick neglected his duty or didn't file the general order, he would have been aware of the contents of the internal affairs file as outlined in Chapter 20 of the general order. Q. OK. Him being aware of the contents of the file doesn't mean that he had conversations with the sheriff about the reasons for your termination. Do you see what I'm saying? Mr. Mastromarco, Jr., I'm going to object to what you are saying or what you are trying to say. It's argumentative and it's not even a question. The witness, you have to ask Patrick McCullough if he had any conversations. By Mr. Savage, Q. OK. A. I don't. Q. You don't have any knowledge of them, right? A. No. Q. OK. Ms. Phelps, are you, well, before I get to that. Do you claim that anybody was, well, you've said this earlier. I'm not trying to step on what you testified earlier and I don't want to rehash ground we've been over, but you said there was a Lieutenant Newman and a sergeant. Who was the sergeant? A. Lieutenant Norman. Q. Norman? A. Norman. Q. And there was Sergeant Kislik, phonetic, or something? A. There were two different sergeants in major crimes during the span of the Treehouse murder to when I was terminated. We first had Sergeant Christian Kellenberger who goes by Chuck, Kellenberger. Q. OK. A. He was at major crimes at the time of the Treehouse murder. And then Sergeant Barney Sidak, that's SAJDAK, came into major crimes after Kellenberger. Q. OK. So of those individuals do you claim that they were treated more favorably than you with respect to the investigation centered around the Treehouse murder case? A. Absolutely. Q. All three of them or just, you mentioned Norman and Sidak earlier. Are you adding Kellenberger in that mix as well? A. Yes. Absolutely. Mr. Mastromarco, Jr., Luke, if I may interject. Mr. Savage, sure. Mr. Mastromarco, Jr., I know that you are probably going to go off and ask her about each one of those different things and I think it's probably going to be, you know, quite involved. Okay. So can we take a half an hour break? I'm not going to, you know, certainly, Mr. Savage, I'm almost done, Victor. I'm not going to, I don't have a lot left. I just have a couple of questions on those individuals. So I think we can finish up in the next 15 minutes. Mr. Mastromarco, Jr., all right. Mr. Savage, if that's all right. Mr. Mastromarco, Jr., that's fine. Okay. I'm going to have some questions possibly. Mr. Savage, that's fine. Okay. By Mr. Savage, Q. So with respect to, Mr. Catanzaro, Luke, before we go, hold on. I'm going to have questions after Mr. Savage is done. I have no problem with you breaking for lunch before I start. Mr. Mastromarco, Jr., thank you, Mark. Mr. Savage, I just want to conclude my examination, if that's possible. Mr. Mastromarco, Jr., no problem. Mr. Catanzaro, no problem. Mr. Mastromarco, Jr., go ahead. By Mr. Savage, Q. Are you contending that Lieutenant Norman, Sergeant Kellenberger or Sergeant Sidak were, the allegations were leveled against them and that the sheriff did not investigate? A. Correct. Q. OK. What allegations for Lieutenant Norman? A. Lieutenant Norman, as part of the Treehouse murder investigation, determined that it was necessary for Detective Danielle Malone to access the emergency contact information from the driver and vehicle identification database. When we were attempting to find April Walker so she could be deposed. Q. OK. And, A. Detective Malone was investigated and disciplined. Lieutenant Norman, who testified under oath that he is the one that gave the order and told Malone to access the information, was never investigated, never disciplined, not demoted, not suspended or fired. It was the female who followed the order that got disciplined. Q. OK. Do you know whether or not the sheriff had any involvement in that investigation? A. Inspector General Leon Holroyd assigned it and was part of it. Q. I'm saying do you know whether the sheriff had any involvement in the investigation? A. I don't know. Q. OK. Is that the allegations surrounding Lieutenant Norman? A. Repeat your question. Sorry, I missed it. Q. Are those the allegations that you contend that, well, bad question. Strike that. Is that the information that you have with respect to Lieutenant Norman that supports your contention he was treated differently than you? A. In addition, sir, Lieutenant Norman was the supervisor of the Major Crimes Unit. Q. Did you supervise him? A. Yes. In the chain it was Kellenberger and Norman and me and then Sibilia and Caputo and then the sheriff. Q. OK. A. During the Treehouse murder investigation, I was held accountable for the detectives mishandling 208 pieces of evidence. I, as the command officer, the openly gay female white command officer, was the only one that was held responsible for the detectives mishandling evidence. James Norman, who in that chain of command and is a heterosexual white male, was not investigated, disciplined, demoted, suspended nor fired, even though he was in that supervisory chain of command. Neither was Detective Sergeant Chuck Kellenberger. And Kellenberger supervised the day-to-day operations of the detectives. So he would have been the one most responsible for the detectives ensuring they were doing what they needed to do with evidence. And again, Kellenberger is a heterosexual white male, never investigated, never disciplined, not demoted, not suspended, not fired. So in that situation it was Norman and Kellenberger who were in the layers of chain of command that were not held responsible for the behavior of detectives, but I was. Norman also was not held responsible for what Major Sibilia called a lack of oversight on the other cases in the Major Crimes Unit when he removed me from command. But nothing happened to Norman and nothing happened to Sidek in that decision when I was removed from the chain of command. So the two commanders between the detectives and me received no adverse employment action whatsoever, it was all me. OK. You do admit and acknowledge you had supervisory responsibility for all three of those individuals, correct? A. Correct. OK. And did that mishandling of evidence that you said you were held responsible for, was that part of an IA investigation? A. Yes. OK. That IA investigation was not the basis for your termination, though, correct? Mr. Mastromarco, Jr., objection as to foundation. The witness, I was told that the basis for my termination was because of what I said on the tape on IA 46. By Mr. Savage, Q. That's correct. So that you were not told that it was because of mishandling of evidence, correct? Mr. Mastromarco, Jr., same objection. The witness, correct. By Mr. Savage, Q. Ms. Phelps, are you currently employed? A. No. Q. OK. Have you been employed at any point since your separation from employment from the sheriff's office? A. I had 1 day of teaching. Q. OK. Where was that? A. I taught for a company called Luca, LOU. I did a 1-day leadership seminar in Detroit, Michigan in November of 2020. Q. OK. And have you applied for employment elsewhere since your separation? A. No. Q. You have not. OK. Have you been seen by a psychologist or psychiatrist since your termination from employment? A. No, I have not. Q. Have you received medical treatment that you claim is a result of damages or injuries sustained as a result of your termination? A. No, I have not. Q. OK. Have you answered all of my questions truthfully and fully and to the best of your knowledge today? A. Yes, sir, I have. Q. Have I treated you fairly today? Mr. Mastromarco, Jr., objection. Instruction not to answer. Mr. Savage, ma'am, you can answer. Mr. Mastromarco, Jr., no, you are not going to answer that. Mr. Savage, what's the, Mr. Mastromarco, Jr. self-serving question by you. Mr. Savage, what's the privilege that you are asserting, Mr. Mastromarco? Mr. Mastromarco, Jr., oh, you can't ask a question like that. You are going to ask her, maybe I ask your client, am I a good guy? And then wait to see what they are going to say. What if she doesn't think you are fair? Mr. Savage, then she can. Mr. Mastromarco, Jr. I'll ruffle your feathers and then you are going to ask her, hey, why don't you think I'm fair? I'm going to instruct her not to answer. If you feel this is really important for your case or your defense, you can go to Judge Martinez. Mr. Savage, we are going to certify the question. You can answer it now, there would be no argument but. The witness, certify it. Mr. Savage, I'm done with my direct examination. I know that you gentlemen had mentioned wanting to go to lunch, take a break of some sort. What do you guys want to do? Mr. Mastromarco, Jr. That's what we want to do. Mr. Savage, how long do you want to do it? Mr. Mastromarco, Jr., how about, Mark, what do you want? How much time do you want? Mr. Catanzaro, I'm ready to go forward and I don't care, whatever you want to do. Mr. Mastromarco, Jr., well, I want to get something to eat right now. Mr. Catanzaro, I know. That's why I said, whatever you want to do. Mr. Mastromarco, Jr., okay. Fine. Let's try for 40 minutes. How is that? Mr. Savage, so we'll be back at 1:15 approximately? Mr. Mastromarco, Jr., that's fine. Mr. Savage, see you back. A recess was taken in the deposition, after which the deposition continued as follows. Cross-examination, by Mr. Catanzaro, Q. Ms. Phelps, good afternoon. A. Good afternoon. Q. My name is Mark Catanzaro. I represent Carrie Higgins, Lauren Genai, and Franklin Tucker. I have some questions for you. I don't know how long we are going to be, we just took a break, but if you need one at any time feel free to go. The only instruction is that you can't speak to your lawyer about the case if there are any questions pending or as we go on. Fair enough? A. Fair enough. Q. Okay. Why were you terminated? A. Because the sheriff said I used racially charged language. Q. Okay. I guess that was a poor question. You are correct, that's what the sheriff said. Why do you believe you were terminated? A. I believe that the ruse was used as a pretext for my firing. Q. Okay. A pretext for what? A. For sex and sexual discrimination. Q. So why didn't he do that sooner? A. You would have to ask him that, sir. Q. Well, you were there for 18 years and he had not sought to fire you. Well, he was there, strike that. He was there when as sheriff? A. I believe from 2012 until the present. Q. And prior to October of 2019 had he sought to terminate you? A. No. Q. Okay. You indicate in your letter that Mr. Higgins, that Mr. Savage showed you, and I can put it up if you need it, that in that letter it said that Higgins orchestrated your removal. Do you recall that? A. Yes. Q. How did Higgins orchestrate your removal? A. It started with phone calls on the jail recording system between Franklin Tucker and his then-girlfriend, Lauren Genai, where there was a discussion about Project and Operation Mayhem. These discussions did not happen until after Higgins was appointed, the attorney, for Mr. Tucker. The Project Mayhem and Operation Mayhem were discussions about how they were going to try to discredit myself and Matt Pitcher and get us removed from the Treehouse murder investigation, get Assistant Attorney Colleen Dunn disbarred, get myself and Pitcher fired. There was going to be a blitz of contacts with the media to get media attention as to what was going on in the case. And then true to the phone conversation, September 15 there is a letter sent by Mr. Tucker to Internal Affairs alleging criminal misconduct on the part of myself and several others involved in the Treehouse murder investigation. There is a meeting between McCullough and Higgins. We learned of another meeting that I had no knowledge up until Inspector General Holroyd talked, where she, Holroyd, and Barrios went to the jail and interviewed Mr. Tucker and Attorney Higgins about IA-46. There's nothing in any of the records that I received that reflects this conversation ever happened. Holroyd says she audio recorded it. I don't have a copy of that audio recording. We were never given that, didn't know that this meeting even happened. October 4th, at the request of Assistant State Attorney Dunn, we had deputies come to a court proceeding. We thought it was going to be an evidentiary hearing. I was told by Dunn to have myself and Malone and Pitcher prepared to testify. When we got to the courtroom, within about 15 minutes, we recognized we weren't going to testify, that it was nothing more than a status conference. There were deputies in the courtroom who sat quietly, didn't make any kind of disruptions to the court proceedings at all, didn't say anything, didn't do anything. Ms. Higgins and the other two defense attorneys had ample opportunity to voice an objection to Judge Jones during the proceedings to talk about, they weren't comfortable with the presence of the deputies in the courtroom. We did that as a show of support for Matt Pitcher and for the case because our presence as investigators in the case had been absent in the previous court proceedings and Ms. Higgins had been calling Detective Pitcher a perjurer in open court and accusing him of planting informants in the jail and made also comments about me in court and there had been nobody representing the sheriff's office or any of the investigators from the Treehouse murder involved in it. When the deputies showed up in the courtroom, Ms. Higgins made a point of standing up and counting the deputies in the courtroom more than once, counting the deputies. There was a videographer, I later learned from the blue paper there with a camera. When Ms. Higgins started counting us, the videographer started taking pictures of the deputies making some of them very uncomfortable to where their pictures have their notebooks up in front of their face so they are not being photographed. As deputies left the courtroom, Ms. Higgins took her personal cell phone and was taking pictures of the deputies outside the courtroom so she can make a record. It's my understanding that there were requests for videos from the courtroom asked by her and she immediately fired off an email that inadvertently went to Patrick Flanagan from the state attorney's office instead of Patrick McCullough, the general counsel for the sheriff, talking about how we were wasting taxpayers' money by the presence of the deputies in the courtroom, and how myself and Pitcher were pulling inmates out of jail unannounced and talking to inmates without their attorneys present and a litany of other accusations in this email. And then this email got sent from the state attorney's office to Mr. McCullough. The very next day I meet with Major Sibilia. I'm served with a notice of investigation because the deputies were in the courtroom, gave me a memo from Colonel Caputo telling me I was being removed from the supervision of the Treehouse murder case. Sibilia explained to me that, he asked me if we had caused a disruption in the courtroom, and I told him we had not. And he told me on the day that he gave me the notice that he didn't see a problem with what we had done, that he himself had asked deputies to attend court proceedings in the past. And he said, "Did the state ask you to do this?" And I explained to him I had a text message from Assistant Attorney Dunn asking us to put deputies in the courtroom, to be there. Ms. Higgins alleged that most of them didn't have anything to do with the Treehouse murder investigation. That's not accurate at all. Of the deputies that were in that courtroom, all but 4 or 5 of them had some role in the Treehouse murder investigation. They had all participated in some form or shape during the investigation. Her counting us, having us photographed, and then filing an internal complaint, an affairs complaint against us. Her big accusation was we were trying to intimidate her and intimidate a witness in a case, and a bar complaint against Colleen Dunn when, in fact, her actions intimidated the people that were witnesses in the Treehouse murder case. So October 3rd started, September 15th letter from Tucker, and then the October 3rd hearing and subsequent complaint from Kara Higgins started it. Then there's a meeting, a clandestine meeting that I was never made aware of until we listened to Holroyd's testimony between Higgins and Tucker and Holroyd and Barrios. And then there's a decision, although Barrios had taken the original phone call according to Holroyd's testimony, and she assigned Barrios to go with her to interview Higgins and Tucker. Now he suddenly assigned Michelle Maxwell, one of Kara Higgins' very good friends, to investigate a complaint against me, lodged by her very good friend, Kara Higgins, and now Maxwell is the investigator investigating this complaint. So now there's this complaint lodged. There's an investigation. Excuse me, Maxwell got assigned to the deputies in the courtroom. Let me back up. So that happens on October 3rd. There's this meeting. Barrios goes to the meeting. I am served 2 weeks after this meeting. So they hold on to this complaint for 2 weeks. 2 weeks later I am served by Major Sibilia on November 14th with 3 internal affairs complaints, all at the same time. Of those 3, Kara Higgins' name is on 2 of them, 2 of the 3. And they were one after the other, one of which was the way I investigated and supervised the Treehouse murder investigation, no specific allegations. In fact, I wrote right on the notice of investigation, what is the specific violation? And the same thing about the neo-Nazi comment. Now, it's my understanding based on Holroyd's testimony that came to light in late October, and I am now 2 weeks later being served with a notice of investigation. And now Maxwell is investigating IA-46, a very good friend of Kara Higgins. I have a conversation with Major Sibilia about my concern about being hung out to dry, that this is going to damage the criminal investigation, that it will attack my credibility, and that I believe that Kara Higgins is orchestrating the decisions made by the sheriff's office. I tell him I'm uncomfortable. I want to get an attorney. Ask him about his advice for an attorney, and he tells me he can't recommend that one way or another. And then 5 days later I'm meeting with Major Sibilia and Colonel Caputo, and I'm now being removed from the supervision of the Major Crimes and Narcotics Unit without any forewarning. Conversation in January of 2019, no conversations in between. It's November 19th now, and now I'm being removed from Major Crimes and Narcotics. And again, I questioned the timing of my removal with the Major, and his answer was just, well, I had some concerns. In the December 4th meeting I had with the Major and the Colonel, I asked the Major again, why now? You went 10 months without looking at these cases again. Why now? His answer was, he just felt something wasn't right. Well, I know something wasn't right. This was all happening in rapid succession, in complete alliance with the discussions on the phone about Operation Project Mayhem in an attempt to discredit the investigators that were involved in this murder investigation. So I get served with 3 of these on November 14th. I get removed from Major Crimes Supervision and Narcotics on November 19th. I am given a Dropbox link to IA-46, and my attorney is given a Dropbox link, and the sheriff's office is requesting an interview with me. And then suddenly I'm not being interviewed anymore. I don't even have an opportunity to interview. Sheriff Ramsey is on the radio on December 11th at 8 a.m. in the morning, and he is saying I have due process rights. He's in the middle of due process right now. He can't see himself taking action based on one complaint that came in. I have a right to be interviewed. I have a right to tell my version of events, my take. He has to get my side of the story. He has to gather all the facts before he can make a decision and do the right thing. That is at 8 a.m. on Wednesday, December 11th. Ms. Higgins got on the radio on December 11th at 5 p.m. and said that the sheriff's decision that he wasn't going to do anything based on one complaint was despicable or something along those lines, and she goes on a rant about how I botched the investigation, that what I did was criminal, that I developed a narrative and manufactured evidence to fit my narrative, and if Sheriff Ramsey doesn't do something, then she is going to conduct her own investigation into the sheriff's office and the state attorney's office. Now, I have a November 14th text message from Sheriff Ramsey, where I sent him a text saying, "Happy birthday, Sheriff." He sent me a text back. He said, "Thank you. On another note, please don't stress too much about these complaints. The Blue Paper and Kara Higgins have said not nice things about you. We support you and hope to clear your name soon. Stress later if you think you have to." Now, that was on November 14th. On December 11th he is still telling the public I have the right to due process, a right to tell my side of the story, and he can't see himself taking action based on one complaint. Kara Higgins gets on the radio at 5 o'clock in the afternoon, threatens to conduct an investigation of the sheriff's office. The very next couple of days charging documents are prepared. And on Friday, December 14th, There are documents prepared. This investigation is abruptly closed with an ending paragraph I have never seen in an IA before. Due to the nature of the investigation and the quality of the evidence, Inspector General Holroyd determined it was unnecessary to secure a statement of Captain Phelps. And then my house is under surveillance Friday night and Saturday because I was out of town and they are trying to find me to serve me with this paperwork. 4 people dressed in tactical vests, like they are executing a high-risk search warrant, come to my home, beat on my door to give me a notebook saying the sheriff's intent is to terminate you. My question to the sheriff and everyone involved, at the time I was a 59-year-old woman, 18-year employee of the sheriff's office, wouldn't it have been more respectful, more humane, less embarrassing to wait until I came to work on Monday and serve me privately with those papers in an office and tell me I was being terminated? No, because there are a series of text messages between Ramsey and McCullough Friday night that appear to be panic-stricken. Make sure you call me before 5:00. It's my belief that there was a lot going on between December 11th and Ramsey's comment about due process and Higgins' comment at 5 o'clock about conducting their own investigation into the sheriff's office, and suddenly and abruptly I no longer have an interview scheduled, I no longer have due process rights, I just have in my hand a notice of intent to terminate filled with paperwork saying that on December 13th without never hearing my side of the story the colonel and the major recommended my termination. That's why I think Kara Higgins had a lot to do with my firing. Q. What control does Kara Higgins have over the sheriff's office? A. That would be a question that I intend to have my attorney ask Kara Higgins. Q. So you have no evidence Kara Higgins has any control of the sheriff's office? A. Sir, I have a text message from Rick Ramsey to then Captain Ann Sweeney where they are engaged in a text message and Ramsey tells Sweeney in a text message, and this is on December 12, 2019, the day of the radio broadcast, and the front part of those text messages are about the comments that Higgins made about Ramsey on the radio and Sweeney apologizing to Ramsey for Kara bringing his name into it. And Ramsey's response is Phelps deserved, past tense, on the 12th. Although I don't have paperwork saying I am being fired, Phelps deserved due process and a thorough investigation. And Kara knows this and she's just trying to dismantle the case against her client. Q. Isn't that her job? A. It's her job to defend her client. I don't think it's her job to professionally destroy people that are doing their jobs. Q. Isn't it true that people are supposed to bring complaints to the sheriff of what they perceive to be illegal and inappropriate conduct? A. Yes, but you don't release. Q. That's the answer to the question. A. You don't release audio files. I'm answering your question, sir. Q. No, you are not. The question was a yes or no answer. Is it her job to complain if they believe there is unethical conduct or illegal conduct taking place? A. I cannot answer that with a yes or no. I have to explain it. Q. No. So answer the question. So it's not a person's obligation to bring any complaints they have to the sheriff about what they perceive to be unethical conduct or illegal conduct on the subordinate? A. That's not what I said, sir. Q. My question, the question requires a yes or no answer. Mr. Mastromarco, Jr., let me just object to the form of the question and to the foundation. Go ahead. By Mr. Catanzaro, Q. Is it a person's right to bring to the attention of the sheriff or the sheriff's office what they perceive to be illegal or inappropriate conduct by members of the department? A. Yes. Q. And there aren't any repercussions for those people bringing those complaints to the sheriff's office. Is that right? Mr. Mastromarco, Jr., objection as to the form and foundation. The witness, I don't know. I don't understand what you mean by repercussions. Rephrase it. By Mr. Catanzaro, Q. Okay. What was, I'm going to change the direction. 2019-046, do you understand what that investigation was? A. I was told through the testimony of Holroyd and Maxwell that if my voice was on the recording and I said what I said, that they didn't need anything more and I was done. It was my understanding when I was given the notice of investigation that they were exploring the ruse that was used and whether or not this ruse in itself was lawful or appropriate, so. Q. Do you have the notice of investigation? A. We do. Q. What does it say? A. It talks about the circumstances surrounding the use of neo-Nazi white supremacy, and I am paraphrasing, but it talks about the circumstances surrounding in addition to the comments. Q. So it's your position that wasn't just to determine who the speakers were? A. That's my position, yes. Q. Okay. Were there mistakes made in the Treehouse murder investigation? A. Yes, there were. Q. Were there significant mistakes made in the Treehouse investigation? A. Define significant. Q. Okay. Did you lose all the evidence? A. Did I personally lose all the evidence? Q. Monroe County Sheriff's Office. A. No, sir. That is a gross generalization. Did all the evidence get lost? No. And you know that's not true. Q. Did the audio recordings get lost? A. I don't know what happened to the audio recordings, sir. I was not privy to that part of Major Sibilia or Colonel Caputo's actions. Q. You were the captain of the Major Crimes Unit. Is that right? A. That's correct. Q. And that means the buck stopped with you as it concerned the Major Crimes Unit, correct? A. Correct. Q. You would be responsible for the actions of the lieutenant, correct? A. Correct. Q. You would be responsible for the actions of the sergeant, correct? A. Correct. Q. You would be responsible for the actions of the detectives overseeing the investigation. Is that right? A. Correct. Q. Okay. And fair to say, and I'm sorry, you were the training officer, correct? A. I was the director of training, correct. Q. So you know you were, as the director of training you oversaw the entire training department, right? A. That's correct. Q. That would include the handling of evidence. Is that right? A. No, sir. We did not train in handling of evidence, that was done at the academy level and or by in-service training. Q. I thought you said that you did in-service training. A. I did not teach evidence handling, sir. And that, Q. You've answered that. You were the head of the training department. That's what you just said, correct? A. Correct. And sir, I recall no particular training, other than academy training, where we did any in-service training and evidence handling. It was handled at the academy level. Q. So an officer or detective or a sheriff officer that's been on the police force for 15 years, needs to rely on what he learned in the academy who did no in-service training? Mr. Mastro Marco, Jr., objection as to what some other person might have to do, as far as the form of the question. Thank you. The witness, people were sent to external training on when they would receive promotions, when in the detective bureau, so I can't speak to what training they did or did not get in the academy. By Mr. Catanzaro, Q. Did you review the letter that Mr. Tucker sent to various people? A. I have since I was terminated. I had never seen it before I was terminated. Q. You didn't know that it was made part of the Treehouse murder case, A. No. Q. On or about September 25, 2019? A. Not in the file I was given, sir. I never seen the letter until after I was terminated. Q. So when it indicates that it was made part of the court record on September 25, you are not familiar with that? A. No, I was not. Q. Okay. So you had not seen it until you were terminated. Is that right? A. Correct. Q. Now, one of the complaints in that letter, he complained about the investigation that was done by the Monroe County Sheriff's Office, correct? Mr. Mastro Marco, Jr., I'm going to object as to hearsay from your client. By Mr. Catanzaro, Q. It doesn't matter. I'm asking her, does she know that one of the complaints was the investigation conducted by the Monroe County Sheriff's Department? Mr. Mastro Marco, Jr., same objection. The witness, into the Treehouse murder? Mr. Catanzaro, yeah. The witness, yes. By Mr. Catanzaro, Q. Okay. And you were in charge of major crimes, correct? A. Correct. Q. Major crimes investigated that. Correct? A. Correct. Q. And one of the complaints was failure to investigate and the protection of a homicide suspect Anthea Clay. You recall that? Mr. Mastro Marco, Jr., well, again, I'm going to object as to what the letter that she claims she did not see, that was written by your client out of court, which is hearsay within hearsay within hearsay that you are bringing forth. So object to any questioning on this. Mr. Catanzaro, your speaking objections are not appropriate. Mr. Mastro Marco, Jr. I agree with you, but I'll keep quiet if you'll agree to grant me a continuing objection on, what the letter says that was written by your client. Mr. Catanzaro, that's fine. Mr. Mastro Marco, Jr., all right. Mr. Catanzaro, you have it. The witness, I did not have. Mr. Mastro Marco, Jr. Wait for a question. The witness, sorry, repeat your question. Mr. Catanzaro, hold on. I'm going to mark this Exhibit 6. The Tucker letter was marked for identification as Defendant's Exhibit 6. By Mr. Catanzaro, Q. Do you see it? A. I do. You don't need to make it any bigger. I can, there you are. Q. I'm making it smaller. A. Okay. Q. Do you see it? A. Be careful, I have old eyes. Q. You see the whole thing? A. Yes. Q. Okay. And so the first part of the letter says, in the subsequent investigation conducted by the Monroe County Sheriff's Department, do you see that? The bottom first, A. Yes, I do. Q. Then he makes a complaint about failure to investigate and the protection of a homicide suspect, Anthea Clay, by the Maxo, right? A. I see that. Q. Okay. The illegal informant operation carried out by the Maxo inside the detention center, A. You read that correctly. Q. Okay, and the criminal misconduct of some Maxo officers has already been partially documented by the court. Did I read that correctly? A. You did. Q. Now, at that point he's talking about Monroe County Sheriff's Office, correct? A. Correct. Q. Does he mention your name at all at that point? A. No. Q. Okay. Now, he also goes on to talk about an unsatisfactory investigation, right? A. Yes. Q. And he talks about a number of things that all took place on the first night, correct? A. Correct. Q. And he makes a complaint. In number 2, he specifically talks about a number of people including you, Matthew Pitcher, David Fernandez, David Smith and Danielle Malone. Is that right? A. That's correct. Q. And he talks about that they are all under the direction of Phelps and Pitcher, right? A. You read that correctly. Q. And, in fact, the Monroe County Sheriff's Office Major Crimes Unit is under your umbrella. Is that right? A. Right. By he's making no, the Major Crimes Unit is under my direction, but this letter is saying that all those criminal misconduct issues were under my direction. There's a difference. I direct the unit. Those criminal misconduct things were not under my direction. Q. Was there criminal misconduct? A. No. Q. So there was nothing to be under your direction then, right? A. But his letter says that those activities were under my direction. And I am telling you those activities were not under my direction. Q. Do you recall being in a room that was recorded and they were talking about Todd O'Quinn? A. Yes. Q. And you mentioned he was talking about NID, right? Remember that? A. No, I don't. Q. You don't remember saying, Jesus Christ, if he doesn't identify him we are in trouble? A. Is that the date? Give me the date. Tell me what day you are talking about. Q. I don't have the date in front of me. I'm asking you, if on the recording you show him a lineup or a photographic lineup to Todd O'Quinn and you say, Jesus Christ, if he doesn't identify him we are all in trouble? Mr. Mastromarco, Jr., I would object to the foundation at this point in light of what he's asking you. The witness, sir, I read the investigative summary and that comment is not in there and I don't have an independent recollection of saying that. By Mr. Catanzaro, Q. Are you saying, is it possible that you would have said something like that? Mr. Mastromarco, Jr., objection as to what's possible. The sky is falling, I don't know. The witness, I don't recall. Mr. Catanzaro, excuse me, ma'am. Again, Victor, when I read the federal rules I thought speaking objections weren't permitted. If you want to object to the form of the question that's fine. Mr. Mastromarco, Jr., I'm sorry. You are right. I will refrain. The witness, I don't recall the comment. By Mr. Catanzaro, Q. You prepared notebooks when you went to your criminal deposition, did you not? A. Yes, I did. Q. And did you look at those and review those before you came here today? A. No, I did not. Q. When was the last time you even looked at those notebooks? A. June 15th, 16th, 17th of 2021, during my criminal deposition. Q. What is it that you did review before you came here today? A. My EEOC complaint, the IA complaints, and the complaint I filed in federal court. Q. So you didn't review your deposition transcript from the federal case? A. No. Q. Do you recall the issue with wanting to ID Mr. Wilson when you used the white supremacy neo-Nazi comment? A. Do I recall that conversation? Is that your question? Q. Yes. A. Yes, I do recall that conversation. Q. And do you recall what the purpose was? A. Yes, to obtain the identification of Rory Wilson so we can confirm that Rory Wilson was Rory Wilson and that Rory Wilson was Detroit and I. Q. Okay. Do you know Paula, the individual that was injured? A. No, I did not know her. Q. Did you subsequently come to know her? A. I've never talked to Paula. Q. Okay. So did you ask anyone in your investigation team if the person that was injured and still alive knew the black male that was involved? A. What we knew, sir, was that, Q. That's not my question. I asked you a specific question. Yes or no? A. I can't answer yes or no. Mr. Mastromarco, Jr. I'm going to object also because of foundation. By Mr. Catanzaro, Q. Did you know, yes or no, did you know that Paula was familiar with the black male that was in that treehouse that day? A. Paula knew the black male as Detroit. Q. Did you know you were going to have her, strike that. You knew where this black male lived, correct? A. I didn't at the time of the discussion. Q. Didn't you indicate he lived in the back of the warehouse and you couldn't have approached it from the front, you had to approach it from the back? A. Do you want to ask me a question so I can explain something to you or do you want to testify? Q. I'm not testifying, I'm asking you a question. Did you know that the black male lived in a building that you could not approach from the front? A. Not at the time we were having the discussion on the hot mic. We learned that later in that morning when Smith and Fernandez came back after talking with William Peebles, phonetic. Q. How would Detective Malone know where to go in order to find Mr. Wilson? A. The detectives and I met on that Monday, November 20th. Q. Right. A. We were talking. Smith and Fernandez stepped outside of the building when William Peebles approached, and that's how we got information about a white guy and a black guy being at Burger King and then being at Metro PCS. And the black guy was Detroit and that Peebles had heard Detroit was involved in a homicide. It was when Smith and Fernandez went to Metro PCS and found out that there was a white guy and a black guy that had just been in there, and the white guy, who the clerk identified by the phone records, was Franklin Tucker, and there was an address provided. Q. And you didn't know that at the time of the hot mic? A. If you would let me finish, sir. Smith and Fernandez. Q. These are long answers, just, A. Well, you are asking me yes or no. I can't explain it to you yes or no, and you are making it appear as if I'm not giving you accurate testimony, and I'm trying to. Smith and Fernandez. Q. You like to give soliloquies. I'm asking for just answers to the questions. A. I read a lot of Shakespeare. Okay, so let me finish my aside. They went to the warehouse, Smith and Fernandez, and they contacted Franklin Tucker. Franklin Tucker said he was at Metro PCS and he was there with a guy named Rory Wilson, and that Rory Wilson lived in a warehouse with his pregnant girlfriend. Smith and Fernandez then came to the headquarters building and shared that information. It was then I knew that a black guy named Rory Wilson lived in a warehouse, but I did not know that the black guy named Rory Wilson was Detroit that Paula was identifying. So I didn't know, and Paula didn't know where Detroit lived. It wasn't until all that information came together and was brought back to the headquarters building that we suspected Rory Wilson was Detroit and that he lived in a warehouse on 2nd Street. So I know it was a long answer, but that's the accurate answer so you understand what happened. Q. On the hot mic, how did Malone know where to go? A. Because once I had that information, the discussion I had with Malone over the telephone, I now know Rory Wilson is probably Detroit and he lives in the warehouse on 2nd Street. So now I am giving direction to Malone. Earlier that morning I didn't know that information. Q. Okay. Now, so you knew that Rory Wilson might be Detroit, correct? A. Correct. Q. And you knew that Rory Wilson lived in that building, correct? A. Correct. Q. With his pregnant girlfriend. Is that right? A. That's correct. Q. Did you do anything to find out if Rory Wilson had a criminal record? A. I didn't. Q. Okay. You knew that Paula was able to identify the black male that was there as Detroit, correct? A. We were putting together a photo lineup so Paula could look at the photo lineup of Detroit in it, yes. Q. And that would have included Rory Wilson. Is that right? A. Correct. Q. So if Paula had identified Rory Wilson as Detroit, we never would have had to go and make the white racist, white supremacy comment, wouldn't we? Mr. Mastromarco, Jr., objection. Objection as to form and foundation. The witness, and if Paula couldn't identify Rory Wilson as Detroit, then we would have been right back where we were. So we were using two different investigative strategies to try to determine the identity of Rory Wilson, a photo lineup with Paula and the traffic stop. By Mr. Catanzaro, Q. Why did he have to be a white supremacist? A. I used that ruse because I needed something that would be credible to Wilson so he wouldn't suspect at all that he had been involved in, that he was a suspect in a robbery-murder investigation. I have an African-American person of interest. I have had an older white male deputy who's readily available to me because he works for me, who is from Texas with a southern accent and a shaved head. I did not want Rory Wilson knowing that we know that he's involved in a robbery-murder because I don't want him to hurt Malone or anybody else involved in the homicide. I don't want him to flee the jurisdiction, he is homeless and he is unemployed, and I do not want him being aware of the fact that we are looking at him. Also, if there's any evidence left, he could destroy the evidence. So my decision to use, "You are the grumpy old man who has nothing better to do than to pick on the black guy riding a bicycle" is because, number 1, a deputy stopping somebody for a traffic violation on a bicycle is extremely unusual, it doesn't happen very often. To make Wilson suspect that this traffic stop was anything other than a traffic stop would have made him recognize I am a murder suspect. He could have hurt Malone or somebody else, destroyed evidence, or fled the jurisdiction. So the credible ruse to use was Malone plays this role. I never told Malone to be a racist. I never told Malone to be a neo-Nazi. I told him act like a white supremacist, make him believe he is not getting pulled over because he's involved in a homicide. And further emphasized that with Juan Lara when I called him. You clearly hear me say, Juan Lee knows his bit. It's all about playing a role, and that's what he was asked. If I would have had a young, female, blonde deputy available to me, the role would have been different because it's what I had available to me. The ruse was discussed and never implemented. Nobody was ever stopped. Q. That wasn't, I know you like to go on these long speeches. The question is simply, what you did. Now, you knew Rory Wilson was Detroit before that, did you not? A. We did not know that. We knew, Q. Okay. Let's look at your complaint that you filed in this case. Here is your complaint, your amended complaint. A. Yes. Q. Okay. 24, that the informant further reported that the two, defendant Tucker and Detroit, went to Metro PCS and, with the assistance of Metro PCS, the sheriff's office was able to identify Detroit as Rory Wilson. A. We were able to identify the guy who was in Metro PCS as Rory Wilson. We did not. Q. What did your complaint say, ma'am? A. I read what it says, but I am telling you that is not what happened. Q. Did you reviewed the complaint before it was filed? A. Yes, I did. Q. Okay. What is the word in the complaint, that you were able to identify Detroit as Rory Wilson? That's what your complaint says, correct? A. What happened? Q. Correct. A. No. Q. That's not what it says. A. That's what it says, but we didn't know if Detroit, that the informant that was Detroit was the same Detroit that Paula Belmonte said she knew. We had no idea that the Detroit in the Metro PCS was the same Detroit that Paula Belmonte described. There were two Detroits in this investigation, one was white, one was black. There could have been a third. We had no idea that Detroit was the same man. Q. OK. 25, that the state attorney's office instructed that the sheriff's office still needed to confirm the identity of Wilson via visual identification or thumbprint. A. Correct. Q. You couldn't have done a visual identification without stopping him? A. Government-issued ID. We had to get something that he presented saying this is who I am. Q. That's not what that statement says, does it? It says visual identification. Mr. Mastromarco, Jr. I'm going to object to you arguing now with her as to what some statement in a hearsay document says. Mr. Catanzaro, Vic, I thought we agreed that you would object and not speak? Mr. Mastromarco, Jr., objection, form, foundation. Okay. Mr. Catanzaro, thank you. That's perfect. The witness, visual identification, government-issued ID. We needed something that, by Mr. Catanzaro, Q. Does it say anywhere in their government ID? A. I know, Mr. Mastromarco, Jr., excuse me. Same objection. By Mr. Catanzaro, Q. Does it say anywhere in their government ID? A. No. Q. You indicate that visual identification is government ID? A. That was my take on what we were asked to do, get his government-issued identification, so visually look at his ID, visually look at him, and make sure that his ID is the guy who was holding that identification. And if he doesn't have identification, get a thumbprint so we can run it and see who he is. Q. Is there any communication between the state's attorney's office and you or anybody in your office as to what they were asking you to do? A. Yes. Between Matt Pitcher, myself, and Colleen Dunn. Q. Is there an email or some document which indicates what Colleen Dunn wanted you to do? A. No, it was a telephone conversation. Q. Okay. So there is no writing where she told you what she wanted you to do? A. Not that I'm aware of. Q. Well, I want to go to, do you see this document? A. Yes. Q. Are these your answers to interrogatories? A. Yes. Q. And you certified that these were true. Is that correct? A. Yes. That's correct. Q. And you reviewed these before you certified them? A. Yes, I did. Q. And they were accurate in all respects? A. Yes. Q. Okay. Going down to number I, you see that? A. I do. Q. It says, I did not order an investigation, discipline, demote or fire James Norman, Christian Kellenberger, David Smith and David Fernandez for mistakes committed during the Treehouse murder investigation. Did I read that right? A. Yes, you did. Q. Tell me about the mistakes. A. James Norman gave an order to Detective Malone to access emergency contact information in the David system. Malone was held accountable for accessing the information. James Norman under oath said he gave the order. He was not investigated, disciplined, demoted, suspended, or fired for giving that order, but Malone was handed discipline. Christian Kellenberger, the night of the murder, went to the hospital to get the victim, Matthew Bunnett's bloody clothing. He put the bloody clothing in plastic bags and brought them back and secured them in Detective Pitcher's office. David Smith and David Fernandez, Q. Could we stop there because I want to go back to Kellenberger for a minute. What did he do? What did he do? A. He took Matthew Bunnett, the deceased person's bloody clothing from the hospital, and put them in plastic bags and secured the bloody clothing in plastic bags in Matt Pitcher's office. Q. What's wrong with that? A. You did put bloody clothing in a plastic bag, number 1. And number 2, Q. Why? A. Because it makes the blood evidence deteriorate. Q. Okay. A. You get mold and maggots, and that's exactly what Matt Pitcher found in his office when he opened it. Q. That can compromise the investigation? Mr. Mastromarco, Jr., objection, foundation. By Mr. Catanzaro, Q. Can that compromise the investigation as a captain? Mr. Mastromarco, Jr., same objection. The witness, it can cause a problem with the evidence. By Mr. Catanzaro, Q. Okay. What else did he do? A. That's Kellenberger. David Smith and David Fernandez were the two individuals that were responsible for the audio recording equipment in the interrogation room in District 1 Criminal Investigation Unit. It's also, Smith and Fernandez were named by Tucker in his letter and accused of criminal misconduct just like I was, and they were never investigated by Internal Affairs. There was never a complaint opened up and they were never looked at for all the allegations that Mr. Tucker made in his September 15th letter. Q. Now, are you aware that Detective Pitcher allowed Anthea Clay to enter the treehouse the next day? That was, well, strike that. Was the treehouse itself a crime scene? A. Yes. Q. Okay. Are you aware that Detective Pitcher allowed Anthea Clay to enter the treehouse the next day, the day after the murder? A. I'm not aware of that. Q. Are you aware or were you aware that Anthea Clay painted either poetry or lyrics or statements on the wall of the crime scene? A. I am now. I was not then. Q. When did you become aware of that? A. When I received IA-43 with the investigation supervision, there was discussions about the graffiti. Q. And that was someone was allowed, that would have been Matthew Pitcher allowing a civilian into a crime scene. Is that fair? A. I don't know what happened with Matt Pitcher allowing anybody into the crime scene. I can't answer that. Q. Okay. It would involve somebody going into a crime scene. Fair enough? Mr. Mastromarco, Jr., same objection. The witness, I don't know when the graffiti was painted, sir. That treehouse was secured for about 48 hours. I don't know if that graffiti was painted while it was a crime scene or after the crime scene had been released. I can't answer your question. By Mr. Catanzaro, Q. Would you agree with me that if the crime scene had not been released, it would have been against Monroe County protocol to allow somebody, a civilian, into that facility or that building? A. That's not accurate, sir. You can take somebody into the crime scene, they just have to log in and out of the crime scene. Q. Would it be appropriate to allow them to write graffiti on the walls? A. No. Q. Okay. So if that occurred, that would be something improper that was done during the treehouse investigation? Mr. Mastromarco, Jr., improper hypothetical. By Mr. Catanzaro, Q. In violation of the rules and regulations of the Monroe County Sheriff's Office? Mr. Mastromarco, Jr., form. The witness, yes. Mr. Mastromarco, Jr., of the question. By Mr. Catanzaro, Q. You complained about your eyes, I'm complaining about mine, that's why I'm leaning forward. A. They just get old. You wake up one day and you can't read the paper because they've changed the font. Q. Are you familiar with this? A. Yes. I think we are looking at the request to produce. Is that what that is? Q. Yes. A. Can you just go back to the top because I thought at first it was interrogatories. All right. Yes. Okay. I know what we are looking at now. Thank you. Q. I have the wrong document, forgive me. Did you indicate that you were required to use investigative techniques that utilize negative race-based stereotypes? A. I was required to use them? Q. Yes. A. No. I chose to use it. Q. Okay. Give me a second. Can you read that all right? A. Yes, I can. Q. Okay. Do you recognize it? A. Yes, I do. Q. What is that? A. It's the charge of discrimination form from the Equal Employment Opportunity Commission. Q. Okay. And if you read it, it says, the particulars are, do you see that section? A. Yes. Q. You indicate. I was required to use investigative techniques that utilize negative race-based stereotypes. A. Yes, meaning that was the particular investigative technique that best fit the situation based on who I was trying to contact and the deputies I had available to me at the time. I choose to use that because the situation required that particular investigative technique. Q. Now, did you take into consideration the public perceptions of law enforcement at that particular time in society in general? A. Yes. It made the ruse that much more credible. Q. You did not conceive of it potentially being a problem for your agency that someone would be acting in that capacity? A. No. It was an investigative tactic. It was a lawful ruse. It would have been a credible ruse. It would have kept everyone safe. He wouldn't have been able to flee the jurisdiction because he wouldn't have known that he was a suspect and he couldn't have destroyed evidence. Q. You say that is a common practice to ensure the potential suspects are not alerted to a criminal investigation, correct? A. Yes. A ruse is an investigative strategy used for that purpose. Q. Well, now what I'm asking you is, that sentence follows the negative race-based stereotypes. Is it a common practice to ensure that potential suspects are not alerted to the criminal investigation to use negative race-based stereotypes? A. It would be a common practice. Ruses are common practices. Q. My question to you is, A. Yes. Q. It says, I was required to use investigative techniques that utilize negative race-based stereotypes. This is a common practice to ensure that potential suspects are not alerted to the criminal investigation. Did I read that right? A. Yes. You read it right. Q. Does it say anywhere in that section, in those sentences, that it was a ruse? A. It says it was an investigative technique, which is another term for ruse. Q. Is fingerprinting somebody an investigative technique? A. Yes. Q. Is that a ruse? A. No. Q. Is a photo lineup an investigative technique? A. Yes. Q. Is that a ruse? A. No. Q. Is taking a statement from someone an investigative technique? A. Yes. Q. Is that a ruse? A ruse could be involved in taking a statement, yes. Q. That wasn't the question. Is taking a statement a ruse? A. I can't answer with yes or no. Mr. Mastromarco, Jr., objection, asked and answered. By Mr. Catanzaro, Q. It says that you were required to use investigative techniques that utilize negative race-based stereotypes. It doesn't say ruse. It's a common practice. Is it a common practice to use negative race-based stereotypes in law enforcement? A. Asked and answered. I already told you yes. Q. Tell me where you learned that it was appropriate to use negative race-based stereotypes as a common investigative practice? A. Ruses are common practices. They are nothing more than investigative techniques that make a person believe something is something that it isn't. The use of the negative stereotype was used by me. It's used when officers try to infiltrate pagan motorcycle gangs. It's used when people are trying to infiltrate KKK clans. It's used when you are trying to get into just regular gang activity. It's common practice, sir. Q. Have you ever used a negative race-based stereotype to stop someone? A. Define stop someone in the circumstances. I'm not certain I understand. Q. Have you ever used a negative race-based stereotype as an investigative technique before this? A. I probably have. I can't recall anything off the top of my head. Q. So in the 37 years as law enforcement you can't ever remember utilizing this common practice? A. No. I can remember sending Hispanic detectives into Hispanic gangs. I can remember using African American people to go and buy crack. I've used the perceptions that a particular race would fit in better with a particular situation. So yes, I have used them in the past. Q. Is that a negative race-based, when you send an African American in to buy crack, is that a negative race-based stereotype? A. Yes, because you are assuming that African American people are more likely to sell crack to somebody who is African American, so yes, you are playing on a stereotype. Q. Okay. Did you ever teach using negative race-based stereotypes when you trained your officers? A. No. Q. In your answers to discovery you said other individuals involved, primarily men, were not subjected to discipline and, in fact, were promoted. Do you recall saying that? A. I do. Q. Okay. Did any of them propose to you these race-based stereotypes in an investigation? A. Kellenberger was present during the conversation and didn't object to it. Matt Pitcher was present during the conversation and didn't object to it. Q. Who was the captain? A. Rhetorical. I was, sir. Of that situation, me. Q. Okay. And who's the supervisor? A. Of? Q. The Major Crimes Unit. A. Kellenberger is a supervisor in the Major Crimes Unit. Lieutenant Norman is a supervisor in the Major Crimes Unit. And I am a supervisor in the Major Crimes Unit, sir. Q. Let me make sure I understand the hierarchy at the Monroe County office. You have the sheriff, right? A. Correct. Q. You have a colonel, correct? A. Correct. Q. You have a major, correct? A. Correct. Q. Then you have some captains, correct? A. Correct. Q. Then you have lieutenants. Is that correct? A. That's correct. Q. You have sergeants? A. Correct. Q. Okay. So a captain is the superior officer to a lieutenant? A. Correct. Q. Captain is a superior officer to a sergeant? A. Correct. Q. A captain is a superior officer to a detective? A. That's correct. Q. Okay. Do you recall reading where Detective Pitcher indicated he was uncomfortable, when he was deposed in the criminal case, that he was uncomfortable with your utilization of the race-based stereotype with regard to Mr. Wilson? Mr. Mastromarco, Jr., objection as to what Pitcher stated out of court in his hearsay statement, what that even means that he was uncomfortable. Mr. Catanzaro, Vic, can we again? I mean, I know you can't help yourself. Mr. Mastromarco, Jr., I'm not going to stop. Mr. Catanzaro, you can object to the form of the question, but speaking objections are not permitted. Mr. Mastromarco, Jr., you know, I've probably been doing this longer than you have. Go ahead. Mr. Catanzaro, I don't know about that, but it doesn't matter. The rules are no speaking objections. I thought you said you agreed with me. Mr. Mastromarco, Jr., I do agree with it. Mr. Catanzaro, then you object to the form and that's fine. But you don't need to speak and give her the answers you want her. Mr. Mastromarco, Jr., I don't need to give her any answers. Mr. Catanzaro, then I would ask you to stop doing it and simply interpose an objection when you have a problem with the question. Can the court reporter read back the last question, please? The question was thereupon read by the reporter as above recorded. The witness, I don't recall. By Mr. Catanzaro, Q. Do you recall taking notes about that as part of your criminal deposition? A. I do recall taking notes, but I don't recall the specific things that Matt Pitcher said and I don't want to answer to something that you are saying he said when I don't have anything to refer to and I haven't looked at the document in a great many months. Q. In your complaint you indicate that Higgins subsequently obtained discovery from defendant Ramsey in his office. Do you see that? A. I do. Q. Is that true? A. The discovery I believe would have gone to the state attorney's office and then to Higgins, but it ultimately would have come from Ramsey. We would have had to supply discovery. Q. But Higgins obtains discovery from the state attorney's office. Is that right? A. Who gets it from the sheriff's office? Q. She gets it from the state attorney's office, correct? A. I said and who the state attorney gets it from Ramsey. Mr. Mastromarco, Jr., foundation as to who gets what from whom. By Mr. Catanzaro, Q. The sheriff's office personnel uploaded various video and audio recordings to an external storage device. Who would that have been? A. I don't know. Q. You agree with me that the recording of you having the conversation with Detective Malone was provided by the sheriff's office to the state attorney's office? Mr. Mastromarco, Jr., objection, foundation. Go ahead. The witness, I don't know if that's the way it happened, sir. It got there from somebody and I, by Mr. Catanzaro, Q. It got where from somebody? A. From the sheriff's office to the state attorney's office. Q. Okay. And then the state's attorney would have provided that in discovery. Is that fair? Mr. Mastromarco, Jr. objection as to foundation. The witness, I don't know. By Mr. Catanzaro, Q. Do you have any evidence that the sheriff's office provided that directly to Ms. Higgins? Mr. Mastromarco, Jr. same objection. Foundation. The witness, I don't know. By Mr. Catanzaro, Q. That wasn't my question. Do you have any evidence, do you, Ms. Phelps, have any evidence that the sheriff's office presented or gave it to Ms. Higgins? A. No. Q. You specifically in page 45, paragraph 45, you talk about Project Mayhem, correct? A. Correct. Q. It was a premeditated plan to discredit you and Detective Pitcher. Is that right? A. That's correct. Q. It was a plan to discredit the investigation. Is that not right? Mr. Mastromarco, Jr., objection, form. The witness, it was a plan to discredit the investigators involved in the investigation. By Mr. Catanzaro, Q. And that included you and Detective Pitcher, correct? A. Correct. Q. And it included Sergeant Kellenberger, right? A. I don't know about Kellenberger's name coming up in Project Mayhem. Q. But he was an investigator in that case, right? A. The two names that I was told that were mentioned during Project Mayhem were myself and Pitcher. Q. Do you have those recordings? A. We've asked for them. I don't think we have them yet. Q. So you've never heard those recordings. Is that right? A. That's correct. Q. How about the video of any conversations between Mr. Tucker and Ms. Genai, do you have those? A. No. Q. So you believe Project Mayhem was to discredit you and Detective Pitcher based upon what you were told? A. Correct. Q. Who told you that? A. Assistant State Attorney Colleen Dunn. Q. And what is your relationship with Assistant State Attorney Colleen Dunn? A. We are friends. Q. How long have you been friends? A. Post my firing. We were colleagues prior to me being fired in December of 2019. Q. Did you go to Disney World with her after your firing? A. No, sir. This has been asked and answered. I was at Disney World. She was at Disney World. I didn't go to Disney World with Colleen Dunn. Q. And there's a picture of you and Colleen Dunn in Disney World? A. Yes. Q. That would be a photograph of you and another individual and from that someone could draw that you were friends? A. Just like the Facebook photographs of Ms. Maxwell and Ms. Higgins, yes. Q. That's my point. Mr. Mastromarco, Jr., well, they were friends, that's what she said. By Mr. Catanzaro, Q. But you indicated you weren't friends until you were discharged. A. It was the week before I was discharged, sir. Q. You weren't friends at that point. Is that correct? A. We are friendly colleagues. Q. Didn't you just tell me a minute ago that you were just work people before you were fired? A. We were work colleagues, sir. We were at Disney, not together. We were there separately. I took a picture with Colleen Dunn at Disney World. You asked me if someone could assume based on the picture that we were friends. I told you yes, just like the pictures with Maxwell and Higgins. I told you we did not become friends until post-firing. Q. Paragraph 46 says that, Project Mayhem was a premeditated plan to discredit plaintiff and detective Pitcher, right? A. Correct. Q. What evidence do you have to support that statement? A. The conversations I had with Colleen Dunn about what was going to happen during Project Mayhem. Q. That's the extent of the evidence you have that that's what it was about? A. I had a discussion with Patrick McCullough about Project Mayhem and what the sheriff's office was going to do, if anything. Q. Tell me about that conversation with Patrick McCullough. A. I had a conversation with Patrick McCullough after Ms. Higgins made comments in the courtroom calling Matt Pitcher a perjurer and how he had planted an informant in the jail. I talked to McCullough about the plan to discredit Pitcher and I asked him if the sheriff's office was going to help take any kind of sanction against Higgins, a bar complained, something with the court. He said no, he was not going to get involved in that, the sheriff's office would not get involved in that. That if Matt Pitcher or I wanted to seek our own bar complaint against Higgins we could, but the sheriff's office was not going to get involved in that. He didn't think it was a smart thing to file a bar complaint because those are oftentimes seen as frivolous. So he was dissuading us from doing any kind of action against Higgins. Q. Did you indicate that Higgins was involved in Project Mayhem? A. I don't know if I said she was specifically involved in Project Mayhem, but I talked to him about Project Mayhem and the things that she was doing. I don't know specifically if her name came up in Project Mayhem. Q. What was she doing exactly? A. Releasing documents to the media, releasing internal affairs documents to the court, making them public records, releasing audio files that were part of the internal affairs investigation to various media outlets throughout the country. Q. What was she releasing? Let me go through that one by one. What documents did she release that were part of an IA file? A. The October 4th memo from Colonel Caputo to me removing me from supervision of the Treehouse murder. Q. Can we agree that the document doesn't say anything anywhere on it of internal affairs, correct? A. Can we agree? Let me see the document. Q. Okay. Can you see it? A. Yeah. Let me see the document. Mr. Mastromarco, Jr., just for the record, I'd object, the document speaks for itself. Mr. Catanzaro, that's why I'm asking her, Vic. Mr. Mastromarco, Jr. Well, I mean, you wouldn't be able to ask questions like this in front of a judge. I don't know what your point is, counselor. It either says it or it doesn't. I mean, you would point that out, I guess. Mr. Catanzaro, I may have the wrong one. It is part of that. Maybe I don't. Luke, do you? I hope Luke is there. Mr. Savage, I'm here. Mr. Catanzaro, can you put that, you had marked it as an exhibit. Mr. Savage, let me find it real quick. Is this what you are looking for? Mr. Catanzaro, yes, that's what I'm looking for. If you can shrink it a little so she can see the whole thing. Mr. Mastromarco, Jr., what's the exhibit number, counsel? Mr. Savage, number 2. The witness, yes. In the second sentence it says, an internal affairs investigation has been opened. So it does say internal affairs. By Mr. Catanzaro, Q. What does it say at the top? Re. A. I don't want, did you say, Q. State of Florida versus John Johnson with a criminal number, right? A. Correct. Q. State of Florida versus Rory Wilson with a criminal number, correct? A. Right. Q. State of Florida versus Franklin Tucker, correct? A. Correct. Q. And it says, allegations of improper conduct have been raised in the cases listed above. An internal affairs investigation has been opened to determine the validity of same, correct? A. Correct. Q. How does Higgins know that that's part of an internal affairs file? A. It says an internal affairs investigation has been opened. And the notice of investigation says, see attached memo from Colonel Caputo. Q. Would she have the notice of investigation? A. I don't know. Q. You were captain in the Monroe County Sheriff's Office. You indicated that you've been involved in disciplinary hearings before, matters before. Is the complainant normally served or given a copy of the notice of investigation of one of your law enforcement officers? Mr. Mastromarco, Jr., objection, form, foundation. The witness, I don't know, sir. I don't conduct internal affairs investigations. I'm not with the Internal Affairs Division. By Mr. Catanzaro, Q. So you don't know if the complainant is given the notice of investigation. Is that right? A. That's correct. Q. So if Higgins is given something in the criminal case, she receives it as part of the criminal case. Are you saying she is not allowed to use it if it might be also a part of an internal affairs file? A. Yes. Q. Okay. So if you had taken a statement from a witness in a case and they made it and there's a question as to the propriety of your questioning of that witness, she couldn't use that statement in the criminal case? Mr. Mastromarco, Jr., objection as to improper hypothetical and form and foundation. The witness, I can't answer it. I don't know the answer to it. By Mr. Catanzaro, Q. Okay. Is it fair to say you don't know whether one can use documents that might be in an internal affairs file in a criminal case? A. That's not what you asked me. Q. Yes, I did. A. You said to me if there was a file with an improper statement, could she use that statement in court? I don't know that. I know that an internal affairs document, until the case is closed, can't be made public. Now, could she go to court and stipulate and get it? Maybe, but I don't know the answer to that. Q. So she'd have to go to court to get permission to use that statement? A. I don't know. Mr. Mastromarco, Jr., excuse me. I object to foundation for that issue. Mr. Catanzaro, Luke, you can take that down. By Mr. Catanzaro, Q. You indicate in paragraph 48 the defendants Tucker and Genai also aim to have plaintiff removed from the investigation. You see that? A. Yes. Q. What evidence do you have to support that statement? A. Information from Colleen Dunn. Q. Did you indicate that? Strike that. Did you have much involvement in this particular investigation? A. During what time frame? Q. At any time. A. During parts of it some involvement, during other parts a lot of involvement. Q. And were you involved the entire time? A. Sporadically after the initial 5 days. Q. Detective Pitcher was the lead detective, correct? A. Correct. Q. And you were taking direction from Detective Pitcher. Is that right? A. Correct. Q. And Kellenberger was also involved in the investigation, correct? A. Correct. Q. Why did they want you removed from the investigation? A. Why did who want me removed? Q. Your paragraph 48 says, they aim to have me removed from the investigation. A. That would be something you'd have to ask them. I don't know. Q. If they perceived that you had done something wrong, they had a right to complain. Fair enough? A. Correct. Q. And you had the right to expect that if you had done nothing wrong that you would be exonerated by your office, right? Mr. Mastromarco, Jr., objection as to the form and foundation of that question. The witness, repeat your question, please. By Mr. Catanzaro, Q. Sure. If you had done nothing wrong you had the right to expect that the sheriff's office would find the complaints to be unfounded, right? Mr. Mastromarco, Jr., same objection as to form and foundation. The witness, that didn't happen in IA 46. By Mr. Catanzaro, Q. I didn't ask you that. I asked you, A. Well, you would have expected it, but in IA 46 I didn't do anything wrong and I got fired. Q. My question was you would expect, I didn't ask you what happened. You would expect that you would, A. I would expect it, yes. Q. How could Higgins, Genai, or Tucker have known that you did not consent to that recording? A. Because it's on a telephone call. It's clearly a telephone call. Ms. Higgins is an attorney. I would hope that she is aware of the fact that Florida is a two-party consent state when it comes to phone calls, unless one party is part of a criminal investigation. Q. You were part of the criminal investigation, right? A. I wasn't the focus of a criminal investigation, sir. That's what the statute says that there has to be, one party is part of the criminal investigation. The police can have a victim make a phone call to a suspect and because they are talking to the suspect on the phone as long as the victim is agreeing to the recording of the phone call, it can be recorded. If Malone or I are not the subject of a criminal investigation, we both have to consent. Q. I'm going to ask you to break that down a little bit. Did any of Lee Malone's conversations get recorded? A. I don't know if you can hear Lee Malone. You couldn't on the recording. Q. Right. You couldn't on the recording, correct? That's what was, A. Right. Q. What Higgins had would have been recorded, correct? A. Correct. Q. And Tucker and Genai would have had to have recorded, correct? A. Correct. Mr. Mastromarco, Jr., objection. By Mr. Catanzaro, Q. The only person that would have been recorded was you, correct? Mr. Mastromarco, Jr., objection, foundation. The witness, no. There were other voices that were picked up in that room. By Mr. Catanzaro, Q. How would Higgins have known that the people in that room did not know there was a recording taking place? A. I don't know. Mr. Mastromarco, Jr., objection as to foundation. By Mr. Catanzaro. Q. Is your answer I don't know? A. I don't know how she would have known or not known that people knew or didn't know they were being recorded. Q. You have no evidence that she would have known that what occurred was against Florida statutes, right? Mr. Mastromarco, Jr. Objection as to the form of the question and foundation. The witness. It was a phone call, sir. It's readily apparent it's a phone call. By Mr. Catanzaro. Q. But the only person recorded is the individual in the room. Fair enough? Mr. Mastromarco, Jr. Objection as to form and foundation and also I. By Mr. Catanzaro. Q. I'm going to ask, what is your understanding of Florida law if you are on a telephone? Can you agree for yourself to be recorded? Mr. Mastromarco, Jr. Same objection. The witness. I don't understand your question. By Mr. Catanzaro. Q. All right. I'll see if I can rephrase it so that you might be able to. A. You don't need to be condescending. I am just trying to be clear on your answer. Mr. Mastromarco, Jr. Hold on. That's enough of that, Mark. I'm going to. Mr. Catanzaro. Well, Vic, you've done that to every witness that has testified. Mr. Mastromarco, Jr. But you've made it a point that whatever I've done isn't right. I'm making a point that what you are doing is being condescending to this witness. I'm not being condescending, Mr. Catanzaro. Every word. Mr. Mastromarco, Jr. I'm not being condescending to the witness. Mr. Catanzaro. Luke did. I didn't. Mr. Mastromarco, Jr. Yes, Luke did. Mr. Catanzaro. I'm not Luke. Mr. Mastromarco, Jr. Well, then don't be condescending. By Mr. Catanzaro. Q. If you are on a telephone, what's your understanding of Florida law, since you've raised the topic? A. I already asked and answered the question. Q. If you are in a room and you record yourself, if you are on a telephone, can you record yourself if the person on the other end is not being recorded? A. No. You have to have both parties consent to record the phone call. You cannot unknowing. Q. I'm not recording the phone call. A. You are, sir. The person is on the phone and you are picking up a conversation that is on a phone. You can't do that without both parties' consent or on the phone. So no, I cannot take a recording and record only me. I'm recording a phone call and the other person has to consent. Q. So it's your testimony that if I'm only recording the one person in the room that's on the telephone, that would violate the law even if that person knew it was being recorded? A. Yes. Both parties, unless one of them is the focus of a criminal investigation, need to consent to the recording of the phone call. Q. The October 3rd hearing, you instructed people to appear in the courtroom, did you not? A. No. This has been asked and answered. I asked people to attend. Q. You are a captain. Is that right? A. That has been asked and answered, yes. Q. Are not officers trained to follow the direction of their superior officers? A. It was not a direction, sir. It was a request. There is a difference. Q. Did you say I request that you attend? A. What I told the supervisors that I talked to is that if their people were available and they were willing to attend the hearing, then they could be in attendance at the court hearing. There was no order for anybody to come to the courtroom. Q. What was the hearing for? A. It turned out to be a status conference. Q. What did you understand the hearing to be for before you went there? A. An evidentiary hearing. Q. An evidentiary hearing involving who? A. I believed it was going to be involving Dunn. Q. Dunn was going to be part of an evidentiary hearing? A. Excuse me, no. Dunn was handling an evidentiary hearing and we were asked to attend. Q. But who was going to be on the evidentiary hearing? Who was going to testify? A. Dunn told me, Pitcher and Detective Danielle Malone to be prepared to testify. Q. Okay. Testify about what? A. She didn't get into specifics, she told us to prepare to testify. Q. In your experience, do the state's attorneys normally just tell you expect to testify without telling you what the topic is going to be? Mr. Mastromarco, Jr. Same objection as to form and foundation. By Mr. Catanzaro. Q. You've been a police officer for 37 years. Have you ever been told to just show up at a courtroom prepared to testify about whoever, whatever? You don't know that, strike that. It's a horrible question. Have you ever been asked to show up in a courtroom prepared to testify but never told even the general area of what the testimony might be? A. Yes, unfortunately. Q. So it wasn't unusual for you to have to go to the courtroom and not know what you might testify about? A. It's happened to me in the past, yes. Q. Did it ever happen with Ms. Dunn? A. Not that I can recall. Q. Isn't it fair to say that Ms. Dunn would generally, not generally? Isn't it fair to say that Ms. Dunn would always prepare you before she put you on the witness stand? A. To clarify this whole thing before you keep going down this line of questioning. I thought the hearing that we were going to was an evidentiary hearing. There was a miscommunication between Dunn and I, so she wasn't prepared to tell us about testifying because she knew it was a status conference. I did not know that. Q. I thought you just told me that she told you, Pitcher, and a third person, I forget, to be prepared to testify? A. Yes. I thought that was for that day. It was not for that day. Q. And why would you bring all of the police officers to go into the courtroom? A. Show support for the case and for Matt Pitcher. Q. But you didn't even know if Matt Pitcher was going to testify? A. I believed he was going to testify. Q. In said complaint, Defendant Higgins noted the fact that 20 employees of the Monroe County Sheriff's Office appeared at the October 3, 2019, scheduling conference. However, Defendant Higgins did not allege plaintiff engaged in any specific misconduct. Did I read right? A. Yes, you did. Q. And wasn't she concerned that the Monroe County Sheriff's Office was trying to intimidate her? Mr. Mastromarco, Jr., objection as to foundation and form. By Mr. Catanzaro, Q. What did you understand Ms. Higgins' complaint was? Mr. Mastromarco, Jr., same objection as to form and foundation. Mr. Catanzaro, she can't testify as to what she understood, Vic. Mr. Mastromarco, Jr., do you want me to give you a speaking explanation why she can't testify as to what someone else thought or maybe some hearsay account that she got as to what was the mental status of Ms. Higgins at the time? I don't know. Mr. Catanzaro, I was asking your client what she understood. Mr. Mastromarco, Jr., no. You know, from whom? Hearsay. Mr. Catanzaro, hearsay is a proper objection in a deposition. Mr. Mastromarco? Mr. Mastromarco, Jr. I think the last time I checked the rules of evidence apply to depositions, but anyway, go ahead. The witness, the notice of investigation I received for that IA did not outline any allegations, it just said the fact that there were 20 people in the courtroom. By Mr. Catanzaro, Q. Is it illegal or improper for the Monroe County Sheriff's Office or State's Attorney Office to give a criminal defense attorney discovery? Mr. Mastromarco, Jr. objection as to form and foundation. Mr. Catanzaro, okay. The witness, repeat your question. By Mr. Catanzaro, Q. Sure. Is it improper for the state, for the Monroe County Sheriff's Office to give information concerning a criminal case to a defense attorney? Mr. Mastromarco, Jr., same objection. The witness, I don't know. I don't release records from the Sheriff's Office. By Mr. Catanzaro, Q. Okay. Now, you indicated that Higgins attached that memorandum in a court filing. Is that right? A. Correct. Q. How did she violate your rights by attaching that document to a court filing? A. Are we talking about the memo from Colonel Caputo? Q. I think that's what we are talking about. Perhaps you are right. I should explain. We are at paragraph 63 down. A. Yes. The memo from Colonel Caputo is part of an internal affairs investigation file. Documents in an internal affairs file are not supposed to be released until the internal affairs investigation is closed. Q. And so if she received the document she's not permitted to, your understanding is she would not be permitted to use it in a court file? A. Yes. Q. Okay. Looking at paragraph 71, I'll make it a little bigger for you. Paragraph 71, it indicates as an attribution to Mr. Genai. Is that correct? A. Correct. Q. Does it mention you anywhere in that attribution? A. No. My name is not in there. Q. It talks about reports. Is that right? A. Yes. Q. Are they your reports? A. I wrote reports on the investigation, yes. Q. Okay. But did you write reports concerning that Ty was on the surveillance video when it was done? A. I don't think any of my reports say anything about him being on surveillance. Q. How could that be defamatory as to Captain Phelps, that statement? A. I don't read that as the report, that the report said Ty is on surveillance. I don't know if she's talking about the surveillance reports or the reports that are also included in that investigation case. I can't tell if that is one and the same. So I don't know if she's saying, Q, so the reader of that would not have any idea that it was referring to Captain Phelps. Is that fair? Mr. Mastromarco, Jr., objection as to what the reader would think. The witness, I don't know what a reader would think. By Mr. Catanzaro, Q. Does anyone see your name in that paragraph? A. My name is not in that paragraph. Q. How can it defame you? Mr. Mastromarco, Jr., same objection, form and foundation. The witness, it is attacking the reports that were written in the case. I've written reports in the case and she is saying that things are not true. So the accusation is that the reports were false. By Mr. Catanzaro, Q. Do you have that article that indicates that you wrote reports in that case? A. I don't know what the entire article said. I don't know if I was specifically named in that article. You have a little piece of it here. In piece it's talking about the reports. I wrote reports in that investigation. Q. Well, I only have what you gave me. A. I understand that. Q. It says that said statement implies that Ms. Phelps inappropriately made false statements or made false police reports, accusing plaintiff of violating Florida law. How does that statement imply that you made false statements or made false police reports? A. Because I was one of the investigators on the case and I had written reports. Q. So that would have defamed any investigator in that case that wrote a report? A. Yes. Q. Okay. Paragraph 89 talks about defendant Higgins posted online, "I want you to be the neo-Nazi picking on the black guy riding the bike." That's in quotes. Is that right? A. Yes. Q. Do you agree that this is an accurate quote of what you said to Detective Lee Malone? A. I don't know if that's an accurate quote. I don't remember. I don't remember if I put neo-Nazi or the grumpy old man picking on the black guy riding the bike. I'd have to look at and listen to the tape. Q. Did you use the term neo-Nazi? A. I did. But again, I'm telling you I don't know if I used the term neo-Nazi in that sentence, so I don't know if that is an accurate quote. Q. Okay. Assuming that that statement is true, the next sentence says, "This is how a captain at Maxo directs subordinates to act." That's a true statement, is it not? Didn't you direct Matthew, or Detective Lee Malone to act like a neo-Nazi or white supremacist or a grumpy old man? Mr. Mastromarco, Jr., excuse me, counsel. Excuse me. Objection to form. The witness, repeat your question. By Mr. Catanzaro, Q. Sure. Did you not direct Detective Malone at some point in that conversation to act like a neo-Nazi? A. It was Deputy Malone and I didn't direct multiple subordinates to act. I directed Malone, not multiple subordinates. It's not like I tell multiple people to do that or told a couple of people to do that. Q. So your issue is with the plural, not the singular. Is that right? Mr. Mastromarco, Jr. I'm going to object as to your form of the question. Mr. Catanzaro, okay. The witness, it's not my only objection to that. That statement is taken completely out of context. It lays no foundation to how or where or when and the circumstances involving a direction from me to Malone. By Mr. Catanzaro, Q. So that is an untrue statement? A. There's no context. It's defamatory. It's inflammatory, it lends a reader to believe that I am doing that without context, without a ruse, without a purpose. That's not what happened here. Q. Paragraph 90, Higgins posted a news article which stated, "All officials may lose jobs in the aftermath of the murder case." You see that? A. I do. Q. What article is that? A. From the Citizen newspaper. Q. So that would have been an article that everybody could have read if they received the Citizen? A. It was the headlined article, yes. Q. That means the article itself was available to anybody that received the Citizen. Is that right? A. Correct. Q. So she posted a document that was in the public forum? A. Correct. Q. Right? A. Yes. Q. Paragraph 93, that defendant Higgins contacted a Washington Post reporter, Hannah Knowles. You see that? A. I do. Q. What evidence do you have that Higgins contacted Washington Post reporter, Hannah Knowles? A. The email right below on 94 where Hannah Knowles tells me Kara Higgins, the defense attorney, contacted her. Q. Where does it say that Kara Higgins contacted her? A. It's in Hannah Knowles' email. Q. Please tell me where it says that Higgins contacted her and that Hannah Knowles didn't contact Higgins? A. There is another email that's part of the notes that isn't in there. Q. This is your complaint, is it not? A. Yes, it is, sir. And we've been getting documents through our request to produce and I've been getting additional information. Q. Just so I can clarify. You are telling me that you received an email in discovery in this case that says Kara Higgins contacted Hannah Knowles? A. No, sir. Mr. Mastromarco, Jr., wait a minute, just stop. All right. I mean, counsel, can you please, if you want to know, you know, what evidence she has that Higgins contacted this reporter, she's told you it's in that other email. I mean, if you want the other email I might be able to find that. But, you know, if you really want to know as opposed to arguing about what's in the complaint or isn't in the complaint, Mr. Catanzaro, do you want to tell her how to answer, Vic, again? Mr. Mastromarco, Jr. I'm not trying to tell her how to answer. I'm trying to, you know, trying to help you out here. Mr. Catanzaro, I really appreciate your help. Mr. Mastromarco, Jr., I knew you would, that's why I was trying to do that. Mr. Catanzaro, it's greatly appreciated. Mr. Mastromarco, Jr. Do you want the email or not? Mr. Catanzaro, I'd love to see that email. Mr. Mastromarco, Jr., all right. Mr. Catanzaro, we'll go on. Vic, you take care of that for me and when you get it, let me know. Mr. Mastromarco, Jr. I certain will, boss. Mr. Catanzaro, thanks. That was you volunteering. I wasn't directing you, Mr. Mastromarco Jr. I am volunteering. I want to help you as much as I can. I don't want you to go into this blindsided. By Mr. Catanzaro, Q. It indicates, page 95, or paragraph 95, I'm sorry, Higgins wants Phelps dismissed from the agency. You see that? Is that right? A. Yes, I do. Q. That was Higgins' expression of an opinion, correct? Her opinion was she wanted you dismissed from the agency? Mr. Mastromarco, Jr. Objection as to form and foundation. By Mr. Catanzaro, Q. I just read it the way it says, Higgins wants Phelps dismissed from the agency. I don't know the context of this. Mr. Mastromarco, Jr., just answer. Mr. Catanzaro, Vic, she was answering the question. You shouldn't stop her? Mr. Mastromarco, Jr., no, I just wanted her to answer if questioned directly. By Mr. Catanzaro, Q. Paragraph 96, her actions were completely egregious, and I think it's despicable and unnecessary. You agree that's an expression of an opinion? Mr. Mastromarco, Jr., same objection. The witness, I think it's a conclusion, yes. By Mr. Catanzaro, Q. Okay. Your actions were egregious, weren't they? A. No. Q. You got fired for your conduct, did you not? A. Wrongfully fired for my conduct, sir. Q. She was not the only one concerned about your conduct, your department was, were they not? Mr. Mastromarco, Jr., objection as to foundation. Also, you are now being condescending to the witness, bordering on harassment. Mr. Catanzaro, bordering on what? Mr. Mastromarco, Jr., harassment, sir. Mr. Catanzaro, okay. Thanks. Repeat the answer. The witness, repeat the question. Mr. Catanzaro, I'm going to ask the court reporter to repeat it. The question was thereupon read by the reporter as above recorded. By Mr. Catanzaro, Q. Was your department not concerned about your conduct? Mr. Mastromarco, Jr., same objection as to foundation and form of the question. The witness, can you try without a negative in the sentence so I can answer it and be clear about my answer? By Mr. Catanzaro, Q. Was your department concerned about your conduct? Mr. Mastromarco, Jr., foundation. The witness, I don't know what they were concerned about. By Mr. Catanzaro, Q. Was Detective Pitcher concerned about your conduct? A. I don't know. I don't recall. Q. I just want to make sure. I think you already indicated you don't remember. You don't recall indicating that if Todd O'Quinn did not identify Tucker in a photo lineup, you would be in trouble? A. I don't recall that. Q. If that is true, would that be inappropriate? Mr. Mastromarco, Jr., same objection, form and foundation. The witness, I don't know what you mean by inappropriate, and I don't understand the context of this question. By Mr. Catanzaro, Q. Paragraph 97, memos shared by the sheriff's office show that Captain Phelps was removed from supervision of the Treehouse murder case in early October. Last week, the sheriff's office also revoked her command of the Drug and Major Crimes Unit, right? A. Correct. Q. And your position is that you were removed based upon your conduct in the case, right? A. Removed from what? Q. What the paragraph says, supervision of the Treehouse murder case and command of the Drug and Major Crimes Unit. Mr. Mastromarco, Jr. Objection, form and foundation. The witness, no. I've already testified that I was removed from supervision by Caputo for the deputies in the courtroom. It had nothing to do with the Treehouse murder investigation. And I've already explained to you that I do not believe that my removal from major crimes and narcotics was due to anything I did in the Treehouse murder case. In fact, they made a point to tell me it had nothing to do with that. By Mr. Catanzaro, Q. When you went to the court in October of 2019, were you not going to the court in the Treehouse murder case? A. Your question was about the investigation of the Treehouse murder case. I don't recall attending a court hearing as part of the investigation. Q. That paragraph doesn't say anything about the investigation, does it? A. You said something about the investigation. You asked me if it was because of the investigation in the Treehouse murder, and I said no, it was because deputies attended the courtroom. Q. Is that paragraph not true? A. What paragraph are we looking at again? Q. 97. A. Yes, I was removed from supervision of the Treehouse murder case in early October, and yes, I did get revoked of my command of the Drugs and Major Crimes Unit. Q. Paragraph 99. Higgins reported to the news that the recording involving the alleged racist statements bolstered her previous efforts to get Phelps taken off the Treehouse case, she said. Now Higgins wants Phelps dismissed from the agency. Anyone who uses those words has no place in the department at that level, she said. Did I read that right? A. Yes, you did. Q. And what she's referring to is the alleged racist statements. Is that right? Mr. Mastromarco, Jr. Objection, foundation. By Mr. Catanzaro, Q. Is that what you read your complaint to say? A. Yes. Q. You did instruct Lee Malone to make racist statements, right? Mr. Mastromarco, Jr. Same objection. The witness, I did not instruct Lee Malone to make racist statements, I did not. By Mr. Catanzaro, Q. You directed him to act like a racist? A. Yes. Q. If we assume that the recording of the conversation was improper or violated Florida statutes, would it be inappropriate for the sheriff to utilize that in an internal affairs investigation? A. Yes. Q. What rule does it indicate that a document or items obtained contrary to statute can't be used in an internal affairs investigation? A. The same rules apply to an illegally obtained. It's illegally obtained, therefore, how can it be used against me? It's not lawfully obtained. Q. So you believe that the Fourth Amendment, the exclusionary rule of the Fourth Amendment applies to disciplinary actions as well as criminal cases. Is that fair? Mr. Mastromarco, Jr., same objection as to your foundation for the question. The witness, I am not an attorney. What I am telling you is I believe the conversation was illegally obtained and as such, should not have been used in the internal affairs investigation or disseminated as part of the internal affairs investigation. By Mr. Catanzaro, Q. And what's the basis of that belief? A. That it wasn't lawfully obtained. Q. So your basis is if it's unlawfully obtained it cannot be used in your hearing, your disciplinary matter? A. Correct. Q. That's your basis? A. Correct. Q. Would you agree with me that putting your words into the newspaper does not defame you? Mr. Mastromarco, Jr., objection as to the form of the question, and go ahead. The witness, taking words out of context without giving me an opportunity to respond, because I am under a no-talk order because of the internal affairs investigation, absolutely subjects me to defamation. By Mr. Catanzaro, Q102, Higgins released this intercepted recorded phone conversation to various media outlets to improperly obstruct, impede or interfere with a duly authorized criminal investigation. Did I read that right? A. You did. Q. I don't see anywhere in that paragraph where it says that it was done to impact you. Does it say that anywhere? A. No. Q. So you allege the purpose was to impede the criminal case when she released that, right? A. No, sir. I also believe she did it to discredit me. Q. And is that contained anywhere in your complaint? A. You mean the fact that she was trying to discredit me? There are several times where it says she tried to defame me in my complaint. Q. Okay. What was your relationship with Detective Pitcher? A. Co-workers. Q. Was he a good investigator? Mr. Mastromarco, Jr., objection as to form and foundation. By Mr. Catanzaro, Q. Did you supervise Detective Pitcher? A. For a short period of time, yes. Q. What's a short period of time? A. Maybe 2 years. Q. Okay. 2 years. Did you have an opportunity to observe him work? A. Yes. Q. Did you find him to be a good investigator? Mr. Mastromarco, Jr., same objection. The witness, there were some things he did well and some things not so well. By Mr. Catanzaro, Q. Did you find him to be an honest investigator? Mr. Mastromarco, Jr. Same objection. The witness, yes. By Mr. Catanzaro, Q. Okay. You interviewed Rory Wilson. Is that right? A. Yes. Q. And you told Mr. Wilson he was a good and decent man. Is that right? A. I did. Q. And that Ty double-crossed him. Is that right? A. I don't believe I used the words Ty double-crossed him. Q. Okay. Did you pound on a desk and say, Ty did it, Ty did it? A. I don't recall pounding on a desk. Q. Do you recall telling Mr. Wilson that Ty might go hurt his pregnant girlfriend? A. I don't recall. I remember telling him that Ty was going to go home and April was there, but I don't remember saying that Ty was going to hurt her. Q. Do you recall that there's a missing part of that recording? A. There was a belief that there was a part of that recording that was missing. Q. Do you have the entire recording? A. The recording from the interview room skipped and there's a part of it missing. Detective Pitcher's body-worn camera is on the table in that interview room and continued recording even though the interview room skipped. Q. Have you heard that recording? A. Which recording? Q. Detective Pitcher's body-worn camera, which you are telling me would have picked up those 3 minutes. A. Yes, I listened to that part of the recording. Q. Do you have it? A. No, I do not. Q. Did it pick up the entire 3 minutes, to the best of your memory? A. I don't recall. Q. So you don't know whether there is some gap, whether it be 3 minutes or something less than that? A. Correct. Q. And do you recall Mr. Wilson saying, I can go home if I just say Ron did it? A. Something to that effect, yes. Q. You didn't start the interview with Wilson, did you? A. No, I did not. Q. You told Wilson what to say, didn't you? A. No, I did not. Q. So when he sits there and says I can go home if I just say Ty did it? That wasn't you telling him what to say? A. No, sir. Q. So when you said Ty did it, that wasn't you telling him what to say? A. No, sir. Q. What were you conveying to him when you said Ty did it? A. That I had a belief that Ty did it. Q. You weren't telling him that he should say that? A. No, sir. Q. Are you aware Detective Pitcher believes you fed Wilson the story you wanted? Mr. Mastromarco, Jr. Objection as to foundation. The witness, I don't know what Pitcher thought. By Mr. Catanzaro, Q. Did you read Pitcher's criminal deposition? A. Yes, I did. Q. But you don't remember what he said in there? A. I don't remember him saying that he believed I fed him Wilson's statement. I don't recall that. Q. Are you aware at the time you interviewed him that the medical examiner's report indicated that it was consistent with a left-handed man? A. No. Q. You are aware Wilson is left-handed, right? A. No. Q. Okay. That wasn't important for you to know? Mr. Mastromarco, Jr. Objection, foundation and form. By Mr. Catanzaro, Q. Did you interview April Walker? A. I did. Q. Is there a gap in the conversation? Did you turn off the recorder during a part of your investigation with April Walker? A. No. Q. Are you aware Detective Pitcher believes you were telling April Walker what to say? Mr. Mastromarco, Jr. Objection as to what the foundation is for her to know. The witness, I know I read in Pitcher's deposition that he said he felt that I was telling Walker to tell the truth. By Mr. Catanzaro, Q. Okay. Did you ever talk to Pitcher about him having a problem with your conduct? A. No. Q. Were you present for Tucker's bond hearing when Colleen Dunn represented that Nam Jackson has no reason to lie? A. Yes. Q. Did you testify to that? Mr. Mastromarco, Jr. Same objection. By Mr. Catanzaro, Q. Did you testify at the bond hearing? A. I did testify at the bond hearing, but I don't think I testified to the fact that Nam Jackson had no reason to lie. Q. You are aware that your office arranged to have Mr. Jackson placed in proximity to Mr. Tucker? A. No, I was not. Q. That wasn't run by you ahead of time? A. No, it was not. Q. Weren't you aware that Jackson was promised things in exchange for him being placed next to Mr. Tucker? A. No, I was not. Q. Were you aware Mr. Jackson was released 2 weeks after he was placed in proximity to Mr. Tucker? A. No, I was not. Mr. Mastromarco, Jr., same objection. By Mr. Catanzaro, Q. Were you aware that, Mr. Mastromarco, Jr. She's not going to, the stenographer, excuse me, counsel. I'm not getting your objection and I'm not getting the question either, because you are both talking over each other. So can we please, just one at a time? Mr. Mastromarco, Jr. That's what I'm trying to do. I object to this line of questioning as to the form of the question. Thank you. By Mr. Catanzaro, Q. Were you aware that Detective Barrios asked Jackson what his endgame was and he said he expected to have his charges dismissed? A. No. Q. Were you aware that Jackson had worked over 30 cases for the Monroe County Sheriff's Office? A. No. Q. As the head of the Major Crimes Unit you didn't know that? Mr. Mastromarco, Jr. Same objection, argumentative. The witness, no. By Mr. Catanzaro, Q. Did you have a file in your office for confidential informants or, I'm sorry, for cooperators? A backup file, yes. Q. And that backup file would be the same as the actual file, a copy of that? A. Yes. Q. And so you had access to everything in your office. Is that fair? A. Yes. Q. Paula Belmonte, she was the one that was injured but survived. Is that right? A. Correct. Q. And she told you and the other detectives that she knew Mr. Tucker and that it wasn't him. Isn't that true? A. I never talked to Paula Belmonte. Q. Was it ever relayed to you as a member of the investigative team that Paula Belmonte told a Monroe County Sheriff's officer that she knew Ron Tucker? Mr. Mastromarco, Jr. Objection as to foundation and hearsay. The witness, during what time period? By Mr. Catanzaro, Q. Did you become aware of that before you were terminated? Mr. Mastromarco, Jr. Same objection. By the way, are you getting my objections now, court reporter? The stenographer, I am. If I wasn't I would be speaking up. The witness, I'm not certain as to when I knew Belmonte had told investigators that Ron was not involved. By Mr. Catanzaro, Q. Todd O'Quinn was a witness in this case. Is that right? A. Correct. Q. And did you speak to Mr. O'Quinn? A. No, I did not. Q. Were you aware that Mr. O'Quinn indicated he was familiar with Mr. Tucker? A. Yes. Q. Okay. Were you aware he indicated that it was not Tucker? Mr. Mastromarco, Jr., same objection as to foundation and form. The witness, he was aware of, it was not Tucker when and under what circumstances? By Mr. Catanzaro, Q. It wasn't Tucker that was in the house that night? Mr. Mastromarco, Jr., same objection. The witness, I'm not aware of Todd O'Quinn saying anything like that because the people had masks on. By Mr. Catanzaro, Q. Then why did you propose to show Todd O'Quinn a lineup? A. Todd O'Quinn had seen someone running out of the treehouse. He saw somebody out front and the person had removed the face covering and he knew it was a white guy and that's why Todd O'Quinn was shown a photo lineup. Q. And Todd O'Quinn actually described the white guy as having curly brown hair, didn't he? A. I don't recall. Q. Tucker didn't match the description that Todd O'Quinn gave, did he? A. I don't recall the description that Todd O'Quinn gave, sir. Q. Todd O'Quinn identified Tucker in a lineup? A. I don't recall. There was something about Tucker in the lineup and O'Quinn, but I can't remember the particulars. I'm not going to speculate. Q. Okay. Do you recall seeing Tucker in a Halloween costume? A. No. Q. So you didn't decide to arrest Tucker because he looked the part based upon the Halloween costume? A. No. Q. You didn't pull a picture off of Facebook and show it to Detective Picture with Iran Tucker in a Halloween costume? A. No, I didn't pull a picture off Facebook. Q. You and Danielle Malone didn't talk about this picture of Tucker in a Halloween costume? A. Your characterization of a Halloween costume and what I saw are two different things. Q. Okay. Did you see Mr. Tucker with A? Did you see Mr. Tucker in a photograph? A. Yes, I did. Q. Okay. What did that photograph depict? A. He had a hat on, some face paint, and he was holding a knife. Q. Okay. And do you know where that photograph was taken from? A. Malone pulled it off his Facebook page. Q. Malone pulled it off his Facebook page, not you? A. Correct. Q. Was it Danielle Malone or Lee Malone? A. Danielle. Q. Were you aware that picture indicated that prior to you getting the picture you had nothing else with regard to Tucker? A. No. Q. Were you aware that Detective Picture testified you didn't act properly in this investigation? Mr. Mastromarco, Jr., same objection as to statements by Picture, form and foundation. Mr. Catanzaro, okay. The witness, I don't recall. By Mr. Catanzaro, Q. Are you aware Detective Picture said you directed most of the testimony for the prosecution? Mr. Mastromarco, Jr. Same objection. The witness, don't recall that. By Mr. Catanzaro, Q. Okay. Paragraph 106, what's wrong with that statement? A. Because I never told Deputy Malone to illegally pull Rory over on his bike. I specifically told him to make a legal legitimate traffic stop. That is an absolute false statement. Q. So the defamatory aspect of that statement is the illegally pulled him over, correct? A. Yes. Q. Okay. But telling the deputy to play a neo-Nazi racist cop is, in fact, accurate, correct? A. That's what I told Malone to do, yes. Q. Let's go to 107. That's what Genai said to the New York Times. Do you see that? A. I do. Q. And the first sentence says, I think the bigger story here is really about a very corrupt police department and prosecutor's office in a very small town, she said. Did I read that right? A. You did. Q. That doesn't say anything about you, correct? A. That sentence doesn't, no. Q. Corrupt police department, that would be the entire Monroe County Sheriff's Department. Is that right? A. Could be, yes. Q. Now, isn't that the police department that investigated Mr. Tucker? A. Yes. Q. And basically, they've been getting away with this kind of thing for years, because mostly they're picking on poor people and homeless people, and they count on the fact that nobody's going to come and look into what they're doing, correct? A. You read that correctly, yes. Q. This doesn't refer to you. Is that right? A. Not by name. Q. Okay. How does that imply that you were or are a corrupt employee, a corrupt law enforcement officer? A. Because as you just stated, the police department means all of us. Q. So by calling the entire police department corrupt, that included you and defamed you? A. Correct. Q. Okay. If you look at 122, Higgins indicated that the sheriff noting that it was based on one complaint was outrageous. Is that right? A. Correct. Q. You agree that's an expression of her opinion? A. Yes. Q. And, what Phelps did was botch this investigation. Is that what it says? A. Yes, it is. Q. Okay. You did botch the investigation, didn't you? A. Absolutely not. Q. The tapes, audio tape weren't lost? A. I already testified I don't know what happened to the audio tapes. Q. But you were in charge of the major crimes unit, right? A. Yes. Mr. Catanzaro, one was in charge. We've already established that I don't know what happened to the tapes, Q. The actions of Mr. Mastromarco, Jr., I'm just going to object. You are implying the tapes were somehow destroyed. We've requested these things. We haven't got them yet from the county. We'll certainly share them with you when we do. Mr. Catanzaro, I appreciate it. By Mr. Catanzaro, the actions of Penny Phelps are, in my opinion, criminal, and for this to be taken lightly and suggested that it is just one complaint over a poor choice of words is really despicable. Did I read that right? A. Did you skip the second sentence on purpose or did you just miss it? Q. No, that's fine. She created a story in her mind and then manufactured the evidence to fit her narrative. We can put that in? A. I just didn't know if you deliberately missed it. I just wanted to make sure I was looking at what I needed to look at. Q. Look at the whole thing and, A. I am. Q. Okay. A. Yes, you read it. Q. The actions of Penny Phelps, she specifically indicates it's her opinion that your conduct was criminal. Is that right? A. Yes. Q. That the same radio broadcast provided that defendant Higgins is conducting her own investigation into the conduct of the sheriff's office and the state attorney. Did I read that right? A. Yes, you did. Q. Does that defame you? A. No. Q. So what's the purpose of putting that in your complaint? A. Because what happened with that is what I believe prompted the sheriff to switch from I have the right to due process, I'm going to be heard, gather all the facts. That statement is what I believe prompted the sheriff's office to change it midstream, and within 48 hours of that statement I was fired. Q. Do you know why the sheriff would be concerned about being investigated? A. No, I don't. Q. So you don't know why he would change stream because she indicated she was going to investigate the sheriff's office and the state attorney? A. No, I don't. Q. Paragraph 137 says that all defendants acted in accordance with the goals articulated in the scheme named Project Mayhem, as defendants successfully, yet baselessly, filed internal affairs complaints against plaintiff, which led to her removal from the Treehouse murder investigation, and, ultimately, her removal from employment with the Monroe County Sheriff's Office. Is that right? A. Right. Q. If they were baseless, why were you fired? Mr. Mastromarco, Jr., same objection as to the form and foundation. The witness, you have to ask Sheriff Ramsey. By Mr. Catanzaro, Q. Did you not tell a subordinate to act like a white supremacist? A. Yes. Q. Did you not tell a subordinate to act like a neo-Nazi? A. Yes. Q. Did you not participate in packing the courtroom on October 3rd? A. Your characterization of that, not mine. Q. Okay. Were you a participant in making sure that 20 or more deputies were in the courtroom on October 3rd, 2019? A. Yes. Q. Do you have any explanation for why the camera or the video recording during Rory Wilson's interview lost 3 minutes? A. No, I don't. Q. 141. The defendant Tucker further made false and defamatory statements, including that plaintiff got in trouble for some racially motivated comments she made and directing officers to make illegal stops. Do you see that? A. Yes. Q. And is it fair to say that your objection or the reason that it's defamatory is because of the illegal stop? A. I disagree with a racially motivated comment. I'm asking somebody to play a role, they are not racially motivated comments. I'm directing somebody to play a role. Q. Didn't you say it's a negative racial stereotype? A. Right. But they are not racially motivated. I didn't go after Rory Wilson because he was African American, so his race did not motivate my comments. Q. Act like a neo-Nazi would not be racially motivated? A. He's playing a role, and asked and answered your question. Q. Paragraphs 145 through 149. You see that? A. Yes. Q. How does that have anything to do with your claims of defamation by the department or your termination by the sheriff? Mr. Mastromarco, Jr., let me, if I can, counsel. Can you just hold off one? Can we take like a 5-minute break? I want to pull up this complaint that you've been referring to. Mr. Catanzaro, yes. You can't see it? Mr. Mastromarco, Jr., no, not from where I'm sitting. You know, I would if I was at my computer where she's at, so. Mr. Catanzaro, okay. A recess was taken in the deposition, after which the deposition continued as follows, by Mr. Catanzaro, Q. Paragraphs 145 through 149. What do they have to do with your claims of defamation? A. Judge Jones saw fit to issue a protective order because all of the extrajudicial statements he felt were prejudicial and impacting the ability of the defendants and the state to have a fair trial. So all the statements that were being made in the public were defamatory and inflammatory, and Jones felt he needed to step in and stop that from occurring because it was impacting the ability for the state and the defendants to have a fair trial. Q. So your paragraphs 145 through 149 indicate that at least, in part, the judge determined that the extrajudicial statements were defamatory? A. They were prejudicial and impacting the ability of the state and the defendants to have a fair trial. Q. Did he ever make any suggestion that they were defamatory? A. I'd have to read his order. I believe they were defamatory and actually asked the state for assistance in getting the protective order. Q. Tucker wore a shirt that said not guilty. What's defamatory about that? A. It's the whole thing that they were doing to paint this picture of me being corrupt, criminal, being unethical, illegal, making traffic stops. All of that stuff combined with a, hey, I'm not guilty, never have been guilty, she framed me, led to that whole scenario of me being something that I'm not. So it was extremely defamatory. Q151, if we declared ready for trial today, there is no way the prosecution would be ready. They don't have a case. How is that defamatory? A. Because, again, it implies that I didn't do my job as an investigator and that A. we don't have a case that we are still moving forward to prosecute him. Q. So when it says the prosecution, that indicates you as well as the rest of them, correct? A. Correct. Q. Which would include Detective Pitcher and the state attorney's office. Is that right? A. Correct. Q. What if someone framed me for murder and there was nobody to help? That's 152. Is that right? A. That's correct. Q. How does that defame you? A. Again, it's the whole picture that they are trying to paint that I am a corrupt cop who engaged in criminal misconduct. This article was about the Treehouse murder investigation and I was part of that investigation. So the implication is that I framed Tucker for murder and that was said. Q. And you indicated that there were others. There's Detective Pitcher, there's Sergeant Kellenberger, and there are others. Is that right? A. Correct. Q. Okay. And so this defames all of you? A. I'm talking to you about what I believe it did to me. It defamed me. I cannot speak for Pitcher or Kellenberger. Q. It says, what if somebody framed me? How does the reader know that's you? A. That is one little snippet out of the article. Q. You put the snippet in, I didn't. A. Yes. I took it to read me and other investigators. I can only speak to whether I thought it was defamatory towards me. I believe it is. Q. Paragraph 178. This is what you talked about before when Lieutenant James Norman directed his subordinate, right? A. Correct. Q. That was part of the investigation. Is that right? A. That's correct. Q. That was improper, correct? A. What was improper? Q. What Detective Norman directed a subordinate officer to do. A. Yes. Q. Illegally access emergency contact information? A. Yes. Q. Okay. Officers, subordinate officers mishandled evidence. That's right? A. Correct. Q. You agree with that statement? A. Yes. We've already talked about Kellenberger. Q. Talked about Kellenberger putting the victim's bloody clothing in a plastic bag, right? A. Correct. Q. Fernandez and Smith were responsible for the interview room and failed to turn off the recording equipment, right? A. Correct. Q. Aren't these all based upon your own statements? Aren't these all pieces of botching an investigation? A. It said I botched the investigation, sir. There's a difference. Q. Well, would you agree that Monroe County Sheriff's Office botched the investigation? A. No, sir. That's your characterization of what happened, not mine. Q. So ordering a subordinate to do an illegal search would not be botching, partially botching the investigation? A. You don't have all the information about James Norman and that situation. Q. Well, he illegally, your complaint says that his order was illegal? A. Yes. Q. And so that's not botching the investigation? A. No, sir. Mr. Mastromarco, Jr., just for the record, I'm going to object to the form of the question. Mr. Catanzaro, no, okay. The witness, no. By Mr. Catanzaro, Q. Is Kellenberger's actions of putting bloody clothing in a plastic bag and putting it in Pitcher's office botching the investigation? A. No, sir. Q. Despite the fact that it makes the evidence worthless? A. It didn't botch the investigation, sir. Asked and answered. Q. I thought you said you didn't have a law degree? A. I don't. Q. You don't have the right to object to questions. Mr. Mastromarco, Jr., just don't respond right now. There's no question. By Mr. Catanzaro, Q. Kellenberger failed to complete a property evidence receipt. That's not a factor in botching the investigation? A. No. I don't like your characterization of botching the investigation. Q. What don't you like about my characterization of botching? A. Because I don't believe a mistake in an investigation is botching the investigation. Q. What is your definition of botching? A. Totally destroying it, ruining it. Q. And where do you live, Ms. Phelps? A. In the Keys. Q. Has anyone ever told you they read the stories about you? A. Yeah. Yes. Q. And who would that be? A. The stories about me in this case? Q. Yes. A. Well, in the investigative file that I was given there were a series of news article and social media posts, and there was a post from a person who stated that I had coached them in softball in the 80s to a 12-0 season, that they always had admired and respected me, and after reading the one news article, were disgusted and disappointed in me. So yes, people have read and contacted me, and I read things that people have said about me. Q. Okay. You mentioned the one in the comments section. Who else? A. There are several more in the comments section from all over the social media posts. I've had my family ask me about it. I've had friends ask me about it. I lost all my teaching jobs because of this. Q. Did you lose all your teaching jobs because of the article, or because you were fired for using racist comments by the sheriff's office? A. I was given the reason by different reasons by different employers. Q. What were the reasons by different employers, and who were they? A. Pasco Hernando State College sent me a letter and saying that based on the sheriff's office investigation where they had found that I had committed a moral standard violation, removed my contract. I had another agency tell me because of the media attention that they weren't willing to continue to put me out in front of students. I had a second employer tell me the same thing. Q. Who are these employers? A. The University of Tennessee. Q. Okay. A. Luca Tactical, Hillsborough Community College. Pasco Hernando we've already talked about. Q. Okay. Well, Pasco Hernando I think you said was because of what the sheriff. A. Right, as a result of the sheriff's investigation. Q. Right. A. The other employers were because of the media attention. Q. Anybody indicate to you that they had read Ms. Higgins' Facebook posts? A. Somebody said it to me and I don't remember who it was, so yes, I know people read it. Q. I know people read it too, but I'm asking if anybody indicated to you that they read it and that they formed a negative opinion of you as a result of reading it? A. Yes. And I also had another person talk to me about the post that she allowed to stay on the Facebook page that I should be hanged at noon in the courthouse, and Q. Who are these people? A. The person that did the post was Conway Minor. Q. And that would be a comment in the Facebook post, or they talked to you directly? A. No, Conway Minor posted a response to her Facebook post. Mr. Mastro Marco, Jr., who is her? The witness, to Higgins' Facebook post. By Mr. Catanzaro. Q. Anybody else? A. Not that I can recall right off the top of my head. And it's been a topic of discussion with me with various people over the last 2 years. Q. You haven't sought employment anywhere since your termination. Is that fair? A. Correct. Q. Did anyone tell you that they had fired? Any of these employers tell you that you were fired because of what Higgins said? A. No. Q. And did any employer tell you were fired because of what Janai said? A. Let me clarify that. Not specifically, it was the media attention and the comments in the paper, so yes. Q. That's not what I'm asking. You said the media attention. Did anybody ever tell you it was based upon what Higgins said? A. In general, the comments that were made in the paper and the way I was portrayed as a racist corrupt cop. So the comments taken in total were the reasons people were giving me about not continuing my employment with them and people saying negative things about me. It's the comments as a whole. Did anybody specifically say, oh, it's Kara Higgins' comment as a standalone? I don't recall any of that. It was the comments that appeared in the media in general that painted this false image of me as a racist, corrupt cop that caused me to lose my employment and to suffer defamation to the point where I'm not the same person I was 2 years ago, let's put it that way. I said it earlier, I'm in living hell. Q. Did you just say you lost your job because of what Higgins, Janai, and Tucker said? A. I didn't say that. I said the comments in the media, the comments in total painted this perception of me being a race-corrupt criminal cop, so yes. Comments in whole caused me to lose my job. Q. You are talking about the teaching jobs, not the sheriff's job. Is that right? A. Yes, my teaching jobs. Q. Okay. A. I don't. The sheriff's office was. Q. Are you finished or? A. Yes. Mr. Catanzaro, can we take a break for about 5 minutes? Mr. Savage, it's okay with us. Mr. Catanzaro, okay. The witness, Vic, are you okay if we take a break? Mr. Mastro Marco, Jr., yes. The witness, okay. A recess was taken in the deposition, after which the deposition continued as follows. By Mr. Catanzaro. Q. Ms. Phelps, prior to your criminal deposition did you create various notebooks with information concerning your review? A. Yes, sir. Q. Various documents? A. Yes. Q. Okay. And do you recognize that? A. Yes, I do. Q. What's that? A. It's one of the notebooks. Q. Okay. There's a document that says page 1 of 2, meet with Christine and Joe. That would be the state's attorney, assistant state's attorney, right? A. Correct. Q. Bear trap, what does that mean? A. It was a characterization just by Joe. Q. What did it mean? Do you know? A. He just told me there were things that, talking point that had come up in different depositions. Q. Were they concerns they had with the nature of the investigation? A. No. He just said that they were things that had come up in previous depositions. Q. Okay. I'm going to go down to the bottom and it says, I think what you are asking me is then say a stupid answer. A. Yes, I see that. Q. Who wrote that? A. I did. Q. Is that what, did somebody tell you to put that or did you put it? A. I wrote it down. Q. So when you were going in to sit in a criminal deposition you were telling yourself that you would just give them a stupid answer to a question? A. No, sir. Q. Tell me, explain for me what you meant when you said I think what you are asking me is then say a stupid answer? A. If I was being asked a question that was compound, difficult to understand, hypothetical in nature, I think what you are asking me is then to say something that whether it's convoluted or complicated back to the person asking the question. Q. That's what a stupid answer means? A. Yes. Q. I know they are really, it's really bad. You don't have a copy in front of you, do you, a paper copy? A. No, I do not. Q. You may have to trust me if you can. It says, to Seth leading, at the top, to Seth leading questions with a rant. Do you need a minute? A. You read that correctly. Q. Okay. What did you mean by that? A. If Seth Lobe, phonetic, gave me a leading question, was ranting about a leading question, just to ask him, do you need a minute? Q. Why would you ask him that? A. To get him to stop asking leading questions, to stop yelling, just have him take a minute. Q. And then the next one, if you were asked the question you were fired, you told yourself what you should say? A. Yes, I did. Q. Okay. You didn't remember what you should say? A. No. These were notes that I was taking to prepare myself for testimony. I was anticipating some of the questions and just writing down my answer to the anticipated questions. Q. So the question involvement. Pitcher says you did. Mistaken. What does that mean? A. I didn't have any involvement with Nam Jackson and Pitcher said he believed I had helped with the movement of inmate Nam Jackson and I didn't, so he was mistaken. Q. Trouble if O'Quinn can't ID Tucker. You see that one? A. I do. Q. You told yourself have more work to do? A. Sir, I'm going to say to you, I don't like your characterization of me telling myself to say this. I am writing down questions that I anticipate and those are my answers. I am not telling myself to say that, I am writing down answers to anticipated questions. Q. Okay. Does that refresh your recollection of the comment Jesus Christ, we are in trouble if he doesn't ID Tucker? A. I don't recall that specific comment that was on a video that I haven't listened to in a long time. I do remember the trouble if O'Quinn can't ID Tucker, and I knew that that meant we had more work to do because we didn't have anybody IDing Tucker. Q. Now, you also anticipate, you had, in 2010 you were given a last chance agreement. Is that right? A. That's correct. Q. What's a last chance agreement? A. It's a document that was offered by Sheriff Perry saying you are put on notice if you engage in that behavior again. You don't get another chance. You will lose your employment with the sheriff's office. Q. Now, when you say that behavior, is it a specific behavior or improper behavior? A. No. It was a specific thing that he took issue with me. Q. So if you had committed other violations separate and distinct from the one he took issue with, that would enact or implement the last chance agreement? A. That wasn't my understanding. Q. Okay. So this was all your notes as to the questions you are anticipating and the answers you are going to, the answers that you would potentially give to those anticipated questions. Is that fair? A. Yes. Q. And when you testify at the deposition your goal is to be complete and accurate with regard to your testimony. Is that right? A. Correct. Q. So what did you mean on page 14 when you say minimize and rationalize, offer them a solution? A. Those are notes about interrogation techniques and the training that I received in interrogation. So it means to minimize and rationalize their involvement in the criminal activity and offer them the way out, offer them a solution that it's safe to tell the truth. So that was my note to me about interview techniques. Q. There's a section, I can't find the page right now, but it indicates every time, and if you remember this, every time she brings up the IAs say I was wrongfully discharged for discussing a lawful ruse that was never implemented. Do you recall that? A. Yes. Q. So you are identifying what your answer is going to be if that question is ever asked? A. No. That was an answer to a possible question. If I was asked something more specific, I would have provided an answer to the question asked. In general, when asked about IAs, I knew I was going to try to explain the firing as a wrongful discharge. Q. I think it might say, do you see where my cursor is? Do you see that, where I am? A. I don't see your cursor. But can you tell me what? Q. I think it might say Lisa or Visa or something. A. Yes. I see where you are. Q. It says, will not stipulate to previous depot. Then it says, frike. Did you write that? A. Yeah, but I don't know what these notes are about. So it's about, okay. Yeah, it's the hearing that stipulates to Belmont's testimony, and that's Giza from the county, and I think she was the only attorney that said she would not stipulate and that we were moving to, everybody would, and then she didn't, so I wrote the word fuck, because she was the only attorney that didn't stipulate to it, everybody else was willing to stipulate. Q. This is picture, it says 6 of 11, page 180. Matt said I was telling April what to say. How do I handle this? As I was training and experience. Did I read that right? A. Yes. Q. Is that your answer as to how you were supposed to handle that? A. I was using the way I was trained to interview to get April to tell us her version of events, so Matt believed that I was telling April what to say, telling her to tell the truth. My question to myself was, how do I handle this? It's the training and experience the way I was trained in interview and interrogation techniques. Q. Page 8 of 11 of picture, page 300, rule with iron hand, my way or highway. How do I respond? A. That's what I wrote. Q. Reference, that was picture's reference to you, is that right, that you rule with an iron hand, my way or the highway? A. No. That was actually a question that was asked of picture that Phelps ruled with an iron hand, is it her, my way or the highway? I believe his answer was something along the lines she's very clear on what she expects and she holds you to high expectations. Q. And it indicates, how do I respond? What was your response going to be? A. I just wrote, how do I respond? That it's absolutely, I mean, picture's characterization of me being a person with very high standards and holding people accountable was absolutely accurate. Q. Page 10 of 11, Matt did not like my interrogation tactics. Does that refresh your recollection concerning what I asked you about before? A. I can see that I wrote he did not like my interrogation tactics, yes. Q. That doesn't refresh your recollection as to whether he had any concerns he had? A. I don't recall any of that. I'm sorry. Q. Okay. Who's Jake Brady? A. He is now a retired sergeant with the sheriff's office. Q. Okay. You read depositions before your criminal deposition, is that right? Transcripts? A. Yes. Q. Okay. A. I can't look at that, it's making me sick. Q. Jake Brady, that hurt to read? A. That's correct. Q. Why did it hurt to read? A. Because it was rambling. It was difficult to figure out what he was saying about what. Q. Didn't say anything about you, though. A. Pardon me, Q. He didn't have anything to say about you? A. I don't remember him saying anything about me. I know the deposition was difficult to read because he rambled. Mr. Catanzaro, Ms. Phelps, one thing, that's all I have. I thank you for your time. The witness, thank you, sir. Mr. Mastro Marco, Jr. All right. Just a minute, Mark and Luke. I have a couple of questions I wanted to ask her. Cross-examination, by Mr. Mastro Marco, Jr., Q. All right. So I wanted to take you back to some of the questions that Mr. Savage was asking you concerning what some of the things that were done to you that you felt were discriminatory in nature. You remember those areas of questioning? A. Yes, I do. Q. Can you tell me, in addition to the things that you've already told Mr. Savage, or maybe to further elucidate some of those issues, can you tell us what other things do you feel were discriminatory in nature that were utilized by the county, in this case, the sheriff's department I should say, to terminate your employment that you felt were discriminatory? Mr. Savage, object to form. The witness, for the first time in my tenure with the agency there were news articles and social media posts in the back of an IA file, and the public perception of what occurred all of a sudden became an overwhelming, undue influence in the move to terminate me. I've never seen that in the history of the sheriff's office where that was a factor that was even considered. I never was interviewed in any of the IAs that were tendered against me from the October 3rd incident, the deputies in the courtroom, to the other 3, so I had 4 in total from October to November 14th. I was not interviewed in a single one of those internal affairs. By Mr. Mastro Marco, Jr., Q. All right. And let me ask you this, with regard to the IA that they utilized to terminate you, this ruse I'm going to call it, did they ever, you indicated to, I believe, Mr. Savage earlier that they actually were setting up or trying to set up an interview. For you? A. Correct. Q. And that never came out, though. They never give you a day or anything like that? A. No, they did not. Q. And, in fact, when we look at the report that was written, and I wanted to clear this up because some of the questions it read, that IA report authored by Inspector Maxwell, at the last paragraph of the 2-page document, do you remember, to the best of your recollection, what do you remember that saying? I only almost read it verbatim. It said due to the nature of this investigation and the quality of the evidence, Inspector General Holroyd determined it was unnecessary to secure a statement from Penny Phelps. Q. Now, just, 2 days before that the sheriff is on the radio saying you'll get a chance to tell your story, right? A. Yes. Q. And yet they never actually interviewed you even though they sent an email telling you they were going to? A. Correct. Q. Just a minute. Just a moment here. I'm trying to recall my train of thought. What other things would you point to that you feel are discriminatory in nature? Mr. Savage, object to the form. You can answer. The witness, there's a chapter of the General Orders, Chapter 9, which talks about conditions of work and benefits. By Mr. Mastromarco, Jr., Q. Wait a minute. I didn't mean to interrupt you, but I just recalled. I was going to ask you this question because of something that was said concerning this issue. You remember when we took Holroyd's deposition? A. Yes. Q. We asked her about why the decision was made as to why they didn't interview you about this alleged quality of evidence rule? A. I believe that was Maxwell. Q. No. Well, we did ask Maxwell, but do you remember me asking Holroyd? A. Yes. Q. Why she told Maxwell that? A. Yes. Q. Do you remember what Holroyd said? A. Holroyd said that all they needed was to know that I was on a tape and that I had made those statements. And she was asked what was so improper about what I said in the tape? And her comment was, you'd have to ask Sibilia, Caputo, and Ramsey. Q. Do you remember when I asked her directly as to why she gave the directive to Maxwell not to take your statement? A. She didn't need it. Q. All right. In any event, you were getting into something else that you wanted to point out as to what you felt was discriminatory, and I want to make sure that Mr. Savage hears it. Go ahead. Mr. Savage, object to the form. The witness, Chapter 9 of the General Orders talks about conditions and benefits at work. There's a section that says an employee gets their sick time, unused sick time payout if they leave in good standing. I did not receive my sick time payout. It was a $40,000 payout because I was told by the finance person, by no one in command, by the finance person that they were told not to pay that to me. Director Brooks Bateman from Aviation was escorted off the property by uniformed people and he was given his sick payout. By Mr. Mastromarco, Jr., Q. Is Brooks a white male? A. He's a straight white guy, yes. And David Lawrence, who left the agency not in good standing, also received his sick payout just recently and he is a straight white male. Q. While we are talking about Lawrence, let's stay on that subject. Did Lawrence do something that received national attention? A. Yes, he did. Q. Tell us about that. A. In May of 2017 a person riding a bicycle was hit by a truck. Lawrence responded to the scene and on his body-worn camera, the first question he asked of the man is, "Are you illegal?" So he was inquiring about the guy's immigration status before he was even asking the man if he was hurt. And it received local, state, national, and international media attention. Q. Was that something that the sheriff was aware of? A. Yes. Mr. Savage, object to the form. By Mr. Mastromarco, Jr., Q. How do you know the sheriff was aware? A. Because he made a comment to me that he wasn't going to comment on the circumstances involving David Lawrence's interaction with the person. Q. Yet he definitely commented on you, though, didn't he? Mr. Savage, object to the form. The witness, yes, he did. By Mr. Mastromarco, Jr., Q. So he doesn't comment on Lawrence but he does comment on you? A. Yes. And Lawrence, a month after the very same, that situation he engaged in the very same conduct where he made a traffic stop and on his body-worn camera he asked the driver his immigration status, "Do you have papers? Are you legal?" And that again caught a flurry of local, state, national, international media attention. Q. Was Lawrence terminated for any of that? A. No, he was not. In fact, Major Sibilia said no, sir, not even close. Q. And who did he say that in front of? A. To us in front of during his deposition. Q. Now, what other things would you point out that you feel were unfair treatment or discriminatory treatment? Mr. Savage, object to the form. The witness, in IA 46, Assistant State Attorney Dunn had told Pitcher and I about the Project Mayhem phone call and what was transpiring. She also told us that she had conversations with Inspector Maxwell and Patrick McCullough, the General Counsel, about Project Mayhem. Her concern was that Project Mayhem was going to negatively impact the criminal case. And at one point she asked both Maxwell and McCullough to toll the investigation because she felt that if McCullough and Maxwell came to us and asked us to toll the IA, which we have a right to do under Florida state statute, that we would do that so it wouldn't negatively impact the criminal investigation. And to my knowledge no one has ever responded to anything involving Project Mayhem. They haven't acknowledged it. Maxwell denied it during her deposition and said she never even knew of it. By Mr. Mastromarco, Jr., Q. But are you aware that the sheriff was aware of that? Mr. Savage, object to form. The witness, yes. By Mr. Mastromarco, Jr., Q. How do you know the sheriff was aware of it? A. Because there were conversations about the case in whole and then his text message to Sweeney indicated that he was very aware that Carol was trying to dismantle the case against her client. Q. All right. And we made that email, I think, for the texts? A. Yes. Q. There was a text message that we made an exhibit, I believe it was at Caputo's deposition. A. Correct. Q. All right. And that was marked as an exhibit, was it not? A. Yes. Q. All right. And there was the word that Ms. Higgins was attempting to, quote, dismantle the criminal case, that was a discussion between the sheriff and his captain Sweeney? A. Correct. Q. What other things would you point to that you believe are discriminatory? Mr. Savage, object to the form. The witness, I take a look at when it came time for the IA 46, I'm aware that you had sent a letter to Internal Affairs telling them about the jail phone calls and requesting that Dunn and Maxwell be interviewed because they had knowledge of the jail phone calls, and that was sent before I was fired. By Mr. Mastromarco, Jr., Q. The jailed phone calls, A. Project Mayhem. Q. Project Mayhem, okay. A. And there was no attempt by the sheriff's office to interview Dunn, interview Maxwell or listen to jailed phone calls despite the fact that we requested that before. Q. All right. Is there some rule they are supposed to interview witnesses material witnesses in a case? Mr. Savage, object to form. The witness, yes. Mr. Mastromarco, Jr., go ahead. The witness, Florida State Statute 112 says they have to interview all identifiable witnesses and gather all the information. By Mr. Mastromarco, Jr., Q. What other things would you focus on? Mr. Savage, object to form. The witness, on December 18th, one day before my predetermination hearing, Sheriff Ramsey was on the Morning Magazine radio show and he began discussing the case. And before he's even heard from me during that radio program, he says the sheriff's office does not tolerate those types of comments. I just can't defend this. And this is the day before my predetermination hearing, so I knew he already made up his mind to fire me. There was no doubt in my mind based on his comment on the radio. By Mr. Mastromarco, Jr., Q. And that wasn't something that was supposed to be out there, right? Mr. Savage, object to form. The witness, no. By Mr. Mastromarco, Jr., Q. Would that kind of information be disclosing information in violation of Statute 112? Mr. Savage, object to form. The witness, right. The investigation had not been closed. It was still open so he should not have been talking about it. By Mr. Mastromarco, Jr., Q. What else would you point to or focus at? Mr. Savage, object to form. The witness, I am genuinely concerned that the sheriff's office knew that the recording between Malone and I was a telephone conversation and that they knew it was an open mic and that they knew that conversation had been illegally obtained and they didn't do anything with that. In fact, he used that open microphone and that recording as justification along with the public perception that it created for my termination. So there was no attempt from the sheriff's office to stop any of this from snowballing. I was never allowed to talk about it. So the comments made by Higgins, Genai, Tucker and the press, and the sheriff, by Mr. Mastromarco, Jr., Q. And the sheriff at the radio, A. And the sheriff at the station were all being said without me being in a position to respond to any of it because I was under an internal affairs investigation and was ordered not to discuss anything. Q. Were you contacted by any, media agencies during the course of this investigation where they wanted you to comment? A. Yes. Tim O'Hara from the Citizen, as did Hannah Knowles from the Washington Post. Q. What did Ms. Knowles tell you? A. Told me that Kara Higgins had said that I ignored her client's due process. I tried to implicate her client, and that Knowles told me that she had received an audio tape from Higgins with comments about the neo-Nazi and she wanted me to respond. Q. So she told you that Higgins sent her the tape? A. She said that she had the audio tape. How she got that I'm not certain. She said she had the audio tape and listened to it and wanted me to comment on Higgins' comments about implicating her client and ignoring his due process rights. Q. Did this get, by the way, when did this get so bad that Judge Jones had to interfere? A. Yes. Q. Tell us about that. A. I was voicing my concerns to the state about what was being said about me in the newspaper and worried about how it was going to impact the criminal case. The straw that broke the camel's back, the infamous Disney picture. Franklin Tucker posted on his Facebook page, "It looks like Phelps' girlfriend has her finger up her ass." So I got a hold of Christine Poist and I said this has got to stop. This nonsense commentary about me, my character, and what I'm doing in my personal life and professional life needs to stop. And Christine agreed, and then they started pulling media stuff, news articles, social media stuff, YouTube channels, free Franklin Tucker Facebook pages, and put all that together in an order to Judge Jones to issue a protective order to stop the extrajudicial prejudicial comments from occurring. And Jones ruled in the state's favor and told all the attorneys to abide by the Florida rules of professional conduct and that no one was to be making extrajudicial prejudicial comments. Q. Was that rule violated here? Mr. Savage, object to form. The witness, yes. By Mr. Mastromarco, Jr., Q. When did they violate it? Who violated it? A. The order came out in May of 2020 and in November of 2020 Tucker and Gina did an interview with the New York Post and they talked about the case. That was taken to Judge Jones. He said that they did violate, but he wasn't going to do a show cause because he didn't want any more publicity in the case. And so it happened, but there was no action by the court taken. Q. All right. What other things would you focus on? Mr. Savage, object to form. The witness, I talked briefly about the culture within the sheriff's office. Sheriff Ramsey had had sexually intimate relationships with female subordinates, Tricia Mulligan, phonetic, and Sheila Swindle, phonetic. It was known that he was involved with Lisette Quintero. Just recently, by Mr. Mastromarco, Jr., Q. By the way, was there a quid pro quo going on from what you could see? Mr. Savage, object to form. The witness, there was concern voiced to me by Director Donna Moore from Human Resources about Quintero's pay. Quintero moved into major crimes as a year-and-a-half deputy. By Mr. Mastromarco, Jr., Q. I'm sorry? A. Within a year-and-a-half of being in patrol she got moved into major crimes. And that is unheard of, somebody with a year-and-a-half and she's in the major crimes position. And then a position opened up in internal affairs. And internal affairs inspectors are considered a detective, so they automatically get a 5% pay increase. Well, Quintero got the 5% and according to Director Moore she also got a 10% pay increase. Director Moore was upset and told me because in the past only the Director of Human Resources got that 10%. The Director of Finance, the Bureau Chief of Administration got that 10%, and the Inspector General, who would have been Quintero's boss, had the 10%. At no time did anybody under the inspector's level get the 10% pay raise. And Director Moore was mad that Quintero was receiving the same amount of money she wasn't an executive director. And Moore explained to me that that money comes out of the high-intensity drug trafficking area money. It was federal money. And she was angry over the fact that Quintero got that pay raise. Q. What about Mr. Fisher or Sergeant Fisher? I'm not sure if he was a sergeant. A. He was a sergeant at the time. And there was a position in professional standards that was a lieutenant's position, and when it was vacated by the existing lieutenant, Sheriff Ramsey downgraded that position to sergeant, which allowed Quintero to be eligible for that promotion. Now, in the past if the existing sergeants are qualified for a sergeant's position, they are selected over promoting somebody to a sergeant. Well, there were existing sergeants and Jay Fisher was one of them that put in for this promotion. He didn't get it. Quintero was selected over Fisher despite the fact he had double the years of seniority and Quintero was promoted. Fisher immediately filed a discrimination complaint. Q. Who was the attorney for Mr. Fisher? A. I believe he ended up using somebody out of Miami, but I think there was initial contact with Darren Horan. Q. Is Horan the former partner of Ms. Higgins? A. Yes. Q. Okay. Go ahead. A. So he ended up using an attorney out of Miami and they did a public records request of a barrage about her pay and everything else going on. And it created quite the controversy in the agency, to the point where Quintero declined the promotion, she turned it down. And one of the existing sergeants who had sought the promotion was then given the promotion in return. And when that sergeant left that position, Ramsey upgraded it back to a lieutenant's position. Q. Did Quintero make any comments, that you are aware of, about Ramsey and her having to step down from that position? Mr. Savage, object to form. The witness, on the day she declined the promotion, Inspector Maxwell talked with me and she told me that Quintero came back to the office and said that she was going to have to use the fur-lined handcuffs on Ramsey tonight so he could make up to her having to turn down the promotion. And Maxwell was very upset that Quintero was openly bragging about that in the office. By Mr. Mastromarco, Jr., Q. All right. You had mentioned to Mr. Savage, one do believe he was questioning you at the time, concerning this, homophobic type, or that, the sheriff had demonstrated. Can you tell us what that was all about? Mr. Savage, object to form. The witness, when he called me into his office, it was about comments that were made outside of work. By Mr. Mastro Marco, Jr., Q. This was, where were the comments made? A. At the Florida Law Enforcement Gays and Lesbians Conference, it was held at the Grand Tree Resort. Q. Were you there? A. Yes. Q. All right. And was your significant other there? A. Yes. Q. And at the time, well, let me ask you, was Ramsey there? A. Yes. Q. All right. What did Ramsey say to you and how did this become an issue? A. He brought me into his office the day after the event. There was a hospitality event and that night the comments were made. And he brings me in the office first thing in the morning and he was extremely angry. He first said, I'm going to ask you about something that was said. And he said, did you have a conversation with somebody about me being gay? And I said yes, I did. Oh, so you are not going to lie about that? I said no. I had the conversation. I was asked by men at that conference if you were gay. And he said, well, what was the rest of the conversation? And I told him, they wanted your number. He became very angry. I'm not gay. I've never been gay and you shouldn't engage in that conversation. And I said, I didn't tell them you were gay. I told them I didn't think you were. And they laughed at me and told me, boy, for a gay woman your gaydar is broke, that guy is gay. So I told him what his conversation was and he got angrier and angrier about the conversation. And he adamantly denied being gay. Then he said to me, you should have stopped it. I said, they don't work for me. It was off duty. None of those people work for me. I walked away from it. What more did you want me to do? You should have stopped it. And he said, and you better get your girlfriend under control or you are not going to like what's said. So I apologized to him and I walked out of the office knowing don't ever say anything to the sheriff about him being gay because it was a very angry reaction. Q. All right. What other things would you focus on? Mr. Savage, object to form. The witness, this whole situation, November 14th I get a text message saying bad things have been said in the blue paper and by Kara Higgins. So he's finally acknowledging that Kara Higgins is saying bad things about me. And he tells me, we are going to support you. We support you and we hope to clear your name. So he's telling me that November 14th. I was repeatedly told by Caputo and Sibilia that I was not being demoted and I was not being fired. Patrick McCullough assured me that I was not being demoted, that I was not being fired. Those have never been topics of conversation, that it wasn't about that. Caputo told me, stop stressing over the complaints. In the meeting we had on November 19th Caputo and Sibilia and I asked Caputo, am I going to get fired over this? I don't like where this is going. And he told me, stop stressing about this. You are not getting demoted, you are not getting fired. Let these complaints work their way through. Higgins has a right to file complaints. We just have to let everything work through it. And then he said, and the major tells me that they are not that big of a deal. And the major agreed with him. And then the colonel said, Major, isn't one of those getting tossed out this week? And the major said, yes, the timesheet one. I told you not to make that NIA to begin with. And I said, so I don't need to worry? They said no. And then on December 4th when they made their final decision to remove me from supervision of major crimes and narcotics, they again had the status, this is only temporary. The major told me, you can go back to major crimes after things settle down. You are not being demoted, you are not being fired. Caputo said the same thing. And the major even said to me, honey, if I left suddenly today you would be the captain that I would recommend to be me, to be the next major. Stop stressing about this. And I was reassured I was not going to be fired. I had a conversation with Patrick McCullough on December 2nd, 2 days before that. And he assured me I was a valuable member of the sheriff's office, that I wasn't being demoted, that I wasn't being fired, they've never been topics of conversation. That we had to let things work through the system. So I'm being told all this. On December 11th the sheriff gets on the radio and emphasizes I have due process rights, I'm going to be interviewed, he has to hear my side of the story. He has to gather all the facts before he can make a final decision, before he can do the right thing. Higgins gets on the radio at 5 o'clock that afternoon and says that not making a decision based on one complaint is outrageous. She's going to conduct her investigation into the sheriff's office. 2 days later I am fired. Despite all the assurances I was not getting demoted, not getting fired, they were going to clear my name, they had my back, it wasn't going to result in anything. Q. So do you think that or do you believe that the reasons they gave were mere pretexts for discrimination? A. Yes. I truly believe that all the public commentary had undue influence on the sheriff, who is a political animal. I believe Higgins' threat to conduct an investigation into the sheriff's office caused him great concern, and I think all of this stuff together caused it piled on itself to where it was readily clear I was being discriminated against. The males weren't being treated the same way. The straight white guys weren't being treated the same way. I've been singled out of the herd, and I was going to be fired despite the fact that I hadn't been interviewed. I hadn't been, never given a chance to tell my side of the story. Q. Do you believe that your gender and gender preference played a role in being the sacrificial lamb? A. Yes. The environment within the sheriff's office is heterosexually charged. You can't be somebody that is cut from a herd if you are a gay woman because you don't play on their team. I was told things like you don't lose your wife, you lose your turn. Q. Let's talk for a minute about the picture, okay? They played down the pictures in the questioning to you. The picture of Ramsey with Inspector Maxwell, wasn't she the inspector that said, well, I'm not going to interview her because Holroyd told me not to? A. Yes. Q. And he's got a whip and he's sitting with his back arched on the chair. You remember that? A. Yes. Mr. Savage, object to form. The witness, yes, I do. By Mr. Mastromarco, Jr., Q. All right. And he's got two, apparently according to Crane, the two women on either side, you remember them? A. Yes. They were in bikinis crawling around on the stage. Q. Right. And they were burlesque dancers. You remember him telling us that? A. According to Crane he said they were professional burlesque dancers. Q. Yeah. Okay. Is that the kind of atmosphere that he created? A. Yes. Yes. It was his involvement with the subordinates. Captain Thompson got involved with a female subordinate at work. He was not demoted, not fired, not disciplined. He was merely transferred to a different patrol station. And my belief is because the same as the fish rots from its head, if the sheriff is going to do it, why can't the rest of us do it? He was just transferred from one patrol station to get away from the woman that he was sexually involved with. So he would no longer supervise her. Q. Let me ask you this, Holroyd said that there was a policy that command officers were not supposed to be seeing or dating, I should say, or having affairs with subordinates? A. No. I think she said we don't have a no-frat policy. There is not anything specifically in writing that you can't. Q. Oh, okay. I didn't hear her say that, but anyway, so in any event, what other things would you point to we haven't discussed so far? Mr. Savage, object to the form. The witness, there was no attempt by the sheriff's office to investigate anything about the open mic, no attempt. We asked Caputo, what did you do about it? Nothing. So they know this phone conversation was surreptitiously recorded and it was released and then released to media outlets, and yet despite my concern, nothing was ever investigated as to who turned it on, who left it on, who turned it off, what happened with it. By Mr. Mastromarco, Jr., Q. What is investigative strategy? Mr. Savage, object to form. The witness, the investigative strategy that we have a ruse? By Mr. Mastromarco, Jr., Q. The investigative strategy as to you all, you know, sitting in a room and deciding how you are going to approach something, is there such a thing like that that's called investigative strategy? A. Yes. And there's a policy at the sheriff's office that allows us, if there's a recording on that we know about when discussing investigative strategy, we have the right to turn the recording off so investigative strategies do not become part of public venue, because the public doesn't understand what we are doing. So you get what happened to me. The public is weighing in on, oh, she committed Fourth Amendment rights violations and she's corrupt and she's criminal, she's illegal, she needs to be fired. They don't have the context, and that's why you are allowed the recording to be turned off when people are discussing investigative strategies. Q. Are recordings supposed to be made in that area at all? A. No, there is no audio, Mr. Savage, object to form. By Mr. Mastromarco, Jr., Q. Explain to me why you say no? A. No. There's no audio recordings anywhere in the sheriff's office unless you are being interviewed by Internal Affairs. And then even Internal Affairs tells you, you know, you are being recorded and you know the recording device is on. So they acknowledge that there is a recording device on. Q. So whether it was by telephone or otherwise, alright, it's not supposed to be recorded? Mr. Savage, object to form. The witness, correct. By Mr. Mastromarco, Jr., Q. So what other things do you have, you want to point to? Mr. Savage, object to form. The witness, in the December 4th meeting with Caputo and Sibilia, when they told me the final decision had been made by Ramsey to remove me from major crimes and narcotics. I told them how unfair the decision was. And I believe I was being treated differently than Captain Hiller, who's a male, and they wanted to know what I thought was unfair about it. And I said to Sibilia, you gave Hiller 2 direct orders to have his sergeants start attending these Monday morning meetings, and twice he ignored your direct order. And I turned to Caputo and said, and the same guy ignored 2 direct orders from you to have his sergeants attend these Monday morning meetings. So Hiller can have 4 blatant instances of insubordination and yet remain in his command position, but you have a concern about cases and I get removed with one conversation in January and now I'm being removed from all of it. I told them this is just not fair. And that's when I also asked Caputo what he was going to do with Sibilia. If the buck stops where the buck stops and Sibilia is supervising me too. And I thought it was really unfair because when Sibilia first talked to me in January, there were over 60 cases in that audit that he had concerns with and then it dropped down to 12. By Mr. Mastro Marco, Jr., Q. All right. So let me ask you, as far as other things that, tell me about them, all right, as far as what you think was discriminatory and unfair. Mr. Savage, object to form. The witness, I think that Higgins, Genai and Tucker acted with deliberate malice to make certain that I was publicly destroyed. And that's what's happened to me, I've been publicly destroyed. I lost my primary job at the sheriff's office and they cited the public perception as why. I've lost my teaching jobs because of that. They acted with deliberate malice. Project Mayhem outlined that they would discredit me. They did more than discredit me. I am sitting here as a 61-year-old woman with 37 years of law enforcement experience and a PhD, and could I get a job? Sir, yes. Do I really want to go make $10 at Publix? Probably not. By Mr. Mastro Marco, Jr., Q. Let me ask you this, do you believe that the Sheriff's Department violated your rights under the Section 112? Mr. Savage, object to form. The witness, absolutely. Mr. Savage, can you please slow down, Ms. Phelps, just so I could get an objection in? I don't want to talk over you. Sorry. The witness, sorry, Luke. I'm sorry. Mr. Savage, thank you. By Mr. Mastro Marco, Jr., Q. Without going into all the different violations, you believe that those violations are evidence of discrimination against you? A. Yes. Mr. Savage, object to form. The witness, yes. If they broke the rules in order to get enough information and their evidence to fire me. If they would have maintained, followed the rules, followed procedural rules outlined in Chapter 20, outlined in the Florida State Statute, one of the things I forgot about. One of those investigations took 246 days to investigate and close. The state statute says within 180. And if you don't have it done you can't tender discipline. So I've been fired from the agency and I get a letter from the sheriff's office telling me I am sustained for neglect of duty, 246 days after a complaint was made. So they are violating the statute and their own general orders. By Mr. Mastro Marco, Jr., Q. What about the ruse itself? When you read Inspector Maxwell's report and you read what Malone said, all right, concerning him directly, I believe he was interviewed. Was it your understanding based on what was in that report they knew full well what you were doing? A Deputy Lee Malone said he knew exactly the role that I was trying to get him to play. Danielle Malone knew the why. He said it was to obscure why he was being stopped so he absolutely would not know he was a murder suspect. Q. So you testified earlier that you believed that this whole idea that, oh, we were just doing this to determine who was on the tape, is an after-the-fact pretext because they couldn't prove it in the investigation? Mr. Savage, object to form. The witness, yes. By Mr. Mastro Marco, Jr., Q. Are ruses something that are used routinely by the Sheriff's Department in Monroe County? A. Yes. Q. And you heard Caputo play Sergeant Schultz's phonetic role like I don't know, I don't see anything, I don't know what you are talking about. You remember that testimony? A. I do. Q. He didn't even know that the Sheriff's Department used female detectives or deputies to act as prostitutes? A. Correct. Q. Is that something that happened often? A. Yes. We would use females as prostitutes. We sent men into massage parlors to see if the massage parlors is legitimate. We've had people pose as gun buyers, pagan motorcycle gang members, human traffickers. We bought a child. A woman sold a child to one of our detectives. We've had them buy drugs, sell drugs, pretend they were children to lure pedophiles into chat rooms and then in-person meetings. Ruses are used all the time in law enforcement. Q. That should be known by Colonel, second in command, Caputo, right? A. It should be, yes. Q. And also Sibilia that went off on a rant. Do you remember his deposition? Mr. Savage, object to form. The witness, yes, I do. Mr. Mastro Marco, Jr. Nothing further. Mr. Savage, just a few questions, Ms. Phelps. Redirect examination, by Mr. Savage, Q. You mentioned David Lares, which you described as his conduct in May of 2017. Do you recall that testimony to your counsel? A. Yes. Q. Okay. Did you partake in any of the alleged investigations that took place into his conduct? A. No, I did not. Q. Do you have any direct knowledge of anybody investigating David Lares and their determinations as a result of those investigations? A. Yes. During the testimony of both Maxwell and Holroyd they said no investigations had come through the Internal Affairs Office. Q. Ma'am, the question was, do you have any direct knowledge? Not knowledge you heard from somebody else. Do you have any direct knowledge of who might have investigated, what their determinations might have been? Mr. Mastromarco, Jr. Well, again, I don't know what. I'm going to object as to what is meant by direct knowledge because 801 D 2b allows in such evidence by testimony of co-workers. Mr. Savage, can you please stop with the speaking objections? You can object to form. Mr. Mastromarco, Jr. It's admissible evidence. Go ahead. Mr. Savage, stop with the speaking objections, please. By Mr. Savage, Q. Do you have direct personal knowledge that anybody investigated those claims and if they did, what their findings were? Mr. Mastromarco, Jr. Objection as to what is meant by, quote, personal knowledge. Go ahead. Mr. Savage, answer the question, please. The witness, no. By Mr. Savage, Q. Okay. What was David Laris's rank in May of 2017? A. He was a sergeant. Q. What was he assigned to? A. Patrol. Q. Okay. He didn't work, he wasn't head of major crimes? A. No. Q. Okay. You said earlier, shifting gears into what you talked about with respect to Ramsey on the radio on December 18, 2019. Do you recall that testimony to your counsel? A. Yes. Q. Okay. You said that he said those things before the investigation was closed. Do you recall saying that? A. If I said that I misspoke. It was before the predetermination hearing. Q. Okay. A. The investigation was closed, but it was before the predetermination hearing. If I said that, I misspoke. Q. Okay, thank you. You, I believe, characterized or made a statement to the effect that the sheriff's office knew that the hot mic recording was illegal. Did you say that? A. Yes. Q. Okay. What evidence do you have that the sheriff's office knew that the recording itself was illegal? A. The investigative summary discusses it as a telephone conversation between Malone and I. Q. Right. That's what it says in the investigative summary. But what evidence do you have that somebody at the sheriff's office knew for a fact that that recording is an illegal recording, as you characterized it? A. Because in the state of Florida, Q. No, ma'am. I'm not asking for that. What evidence do you have? Your interpretation of the statute is not what I'm asking for. I'm saying, do you have any facts, personal knowledge that somebody at the sheriff's office was, like, that's an illegal recording, we can't use it? A. Malone was never asked about consent, nor was I. Q. Okay. But the question I have is, do you have any direct knowledge that anybody at the sheriff's office knew it was illegal? A. No. Q. Okay. You mentioned sexually intimate relationships that the sheriff allegedly had with subordinate officers. Do you remember that conversation with your counsel? A. Yes. Q. Okay. Do you have any personal knowledge that the sheriff was ever engaged in a sexually intimate relationship with a co-worker? Mr. Mastromarco, Jr., same objection as to personal knowledge. The witness, just the rumor that I heard and commentary from Maxwell to me about the fur-lined handcuffs. By Mr. Savage, Q. Okay. So no direct knowledge, you don't have any knowledge, you never saw him engage in a sexual relationship with subordinate officers? A. No, I did not. Q. Only rumors, right? A. Yes. Q. Okay. You mentioned that Quintero, MCU promotion, internal affairs investigator promotion, you recall that? A. I do. Q. What evidence do you have that the scenario that you described was a result of any actions taken directly by Sheriff Ramsey? A. That somebody less qualified than Quintero was not. Quintero was less qualified than other existing sergeants who were promoted. Q. The question was, what evidence do you have that Sheriff Ramsey took any direct action with respect to that? A. I don't. Q. Okay. And you said J. Fisher, do you believe he's more qualified than Quintero? A. Yes. Q. J. Fisher was a courthouse deputy, correct? A. No, a sergeant. Q. But he was, everybody is a deputy sheriff, so his rank was sergeant, but he was in the courthouse, right? A. That's correct. Q. Was there for the majority of his career? A. No. He worked in patrol. He was the training director. Then he was at the courthouse. Q. How long was he at the courthouse at the time of this Quintero situation? A. I don't know. Q. Okay. How many years? A. I don't know. Q. Was it more than 5? A. I don't know. Q. Okay. I'm testing your knowledge, though. If you don't know, that's fine. I don't want you to get testy with me. It's fine. Mr. Mastromarco, Jr., wait a minute, you've asked her about the 4th or 5th time now. Did you know? The witness, no, I don't know. Mr. Mastromarco, Jr., did you know? Mr. Savage, Mr. Mastromarco, please refrain from speaking objections. Thank you. Mr. Mastro Marco, Jr., please refrain from harassing the witness. Mr. Savage, I'm not harassing the witness and your with characterization is a little bit pale this afternoon. By Mr. Savage, Q. You said that Mr. Fisher filed, I guess you said a discrimination claim. Is that correct? A. Yes. He filed a complaint with Human Resources. Q. Okay. Do you know what the outcome of that complaint was? A. I know that every year on his evaluation that I read, because he was a member that worked for me, he would check the box that he had filed a complaint and it had not been resolved according to, I think it's chapter 56 of our general orders. And he would do that every year on the bottom of this eval. So the last time I saw his eval the box was checked and said it hadn't been resolved. So that's my personal knowledge of what happened with that complaint. Q. So all you know is what he checked on the box on that evaluation form? A. Correct. Q. Okay. So you have no personal knowledge of whether HR investigated, whether he had a lawsuit, whether he had claims. Just what he checked on that box, right? Mr. Mastro Marco, Jr., objection as to the form of the question. The witness, I know that he checked the box every year. By Mr. Savage, Q. When was this scenario? What year? A. I don't know. Q. You don't know. You seem to know a lot of details, but you don't know when. Mr. Mastro Marco, Jr., we are not answering that silly question. Mr. Savage, I haven't asked it yet. Please stop speaking, Mr. Mastro Marco, Jr., you are starting off wrong. By Mr. Savage, Q. Do you know when Ms. Quintero was allegedly promoted and then declined? A. It would have been in the time frame of, like, 2016 to 2018. The paperwork at the sheriff's office will show exactly the date she was promoted and then her paperwork will show the day she declined the promotion. So I don't want to guess as to years. It was within the last 5. Q. Okay. It had nothing, it was not anywhere around the time that you were terminated, right? A. It was before I was terminated. Q. At least a year before you were terminated, right? A. I don't know for certain. Q. Okay. You said that there were multiple statements by people at the agency that were going to support you. You don't need to worry, you are a valuable member of the sheriff's office, and this was on or around November 14th of 2019. Do you recall saying that? A. There was some on November 14th, the text message from the sheriff. November 19th in a meeting with Sibilia and Caputo. December 2nd in a meeting I had with Patrick McCullough. And December 14th in another meeting that I had with Sibilia and Caputo. Q. Okay. So the answer is yes, those things were said about you? A. Yes. Q. By various members of the agency? A. Yes. Q. High-ranking members of the agency, in fact? A. Correct. Q. And it's your contention here in this lawsuit that they said those things just to cover up the fact that they were going to fire you because of your sex and your sexual orientation? A. Yes. Q. Okay. In your lawsuit, and I guess even here today in your testimony, you haven't said once that somebody at the sheriff's office intentionally recorded your conversation with Lee Malone. Is that true? A. I said I didn't know if it was intentional. I don't know if it was accidental or intentional. Q. Well, you don't know, I'm sorry. Go ahead. A. I don't know. Q. You don't know, you have no evidence of anybody intentionally recording you? Mr. Mastro Marco, Jr., same objection, asked and answered. The witness, I've already answered the question, sir. I don't know. By Mr. Savage, Q. Okay. So you don't know, but I'm asking you a separate question. Do you have any evidence that would suggest that it was intentional? Mr. Mastro Marco, Jr., objection as to the form of your question. The witness, I don't have any evidence to say it wasn't intentionally recorded. I don't know if it was an accident or intentional. That's all I can tell you. Mr. Savage, no further questions. Mr. Catanzaro, I just have a couple. Recross-examination, by Mr. Catanzaro, Q. Ms. Phelps, the rank and file, are they part of the Police Benevolent Association? A. Some of them are. The PBA represents some of the members, yes. Q. How many members are there in the department? A. In the total agency? Q. Yeah. A. The last sworn strength that I was aware was like 557. Q. Okay. And is the PBA the representative body? I mean, do they represent the majority of the officers? Do you know, are they the collective negotiations organization for the rank and file? A. There's 557 employees of the sheriff's office, they are not all members of the PBA, maybe a third of those are. Q. 550 aren't all law enforcement, right? A. That's correct, some of those are not sworn people, they are civilians. Q. Have you ever been in the contract negotiations for contracts or anything? A. Yes. Q. Okay. Is the PBA the representative body for the employees? I'm trying to get a time frame down because the PBA was definitively, yes, the PBA at the time of my situation at the sheriff's office was the collective bargaining unit. Q. And are you aware that they sent a letter to the sheriff indicating that they believed that you should be removed from all of your positions? A. Yes. I'm aware of the letter. Q. Okay. And that's the body that represents a majority of the sworn law enforcement officers, correct? Mr. Mastromarco, Jr., same objection as to foundation. The witness, I don't know the number, so I don't know if it's fair to say majority. By Mr. Catanzaro, Q. And they asked that you be removed from training and having any other contact with them. Is that right? Mr. Mastromarco, Jr., same objection. The witness, that's what the letter said, yes. By Mr. Catanzaro, Q. That was sent to the sheriff based upon your actions in the Treehouse murder case, right? Mr. Mastromarco, Jr. same objection. The witness, I'm not going to say that. It was based upon the perceptions of what had, sir, that's not, rephrase the question, because I don't even know why you keep going with this. By Mr. Catanzaro, Q. Did the union not ask for your removal based upon the Treehouse murder investigation? Mr. Mastromarco, Jr. I'm going to object again as to form and foundation. The witness, I have to look at the letter again to see what they referenced, sir. I don't know the particulars in the letter without looking at it. Again, I don't even know if they referenced specifically the Treehouse murder. I can't say. I don't remember. Mr. Catanzaro, I'll show it to you. The witness, thank you. Mr. Savage, are you going to mark this, Mark? Mr. Catanzaro, yes, exhibit, what's the next number? Mr. Savage, 7. The PBA letter was marked for identification as Plaintiff's Exhibit 7. The witness, right. There's no mention of the Treehouse murder in this letter. By Mr. Catanzaro, Q. But the ongoing issue regarding Captain Penny Phelps didn't arise out of the Treehouse murder? Mr. Mastromarco, Jr. same objection as to argumentative and trying to get her to agree to something that she can't have foundation. The witness, I don't know what they are talking about with the ongoing issue in the investigation. Which one of them? I don't know what they are talking about here. By Mr. Catanzaro, Q. And as a result of whatever they were talking about, they wanted you to be removed from training and supervision of their rank and file? Mr. Mastromarco, Jr., same objection. The witness, that's what the letter says. By Mr. Catanzaro, Q. And this letter was sent to Sheriff Ramsey on December 12, 2019? A. Correct. Q. And when did they terminate you? A. December 13, 2019. Mr. Catanzaro, that's all. Mr. Savage, just one more follow-up. I neglected to mention it. By Mr. Savage, Q. You mentioned Brooks Bateman, I believe, Ms. Phelps? A. I did. Q. You said he was a member of the Aviation Division? A. He was the Director of Aviation, correct. Q. Was he a civilian? A. No, he was a police officer. Q. He was a police officer. A. He was a sworn police officer who was a pilot. Q. Okay. When was he, quote, unquote, escorted off the premises? A. 2015 to 2017, in that time frame. Q. Okay. So several years before your termination? A. 2 to 3 years before my termination, maybe 4. Q. Okay. Do you know why he was escorted off the property? A. I don't know the particulars of the investigation. Q. Okay. And you are for a fact certain that he was paid his sick leave payout? A. Yes. Q. Okay. How do you know that? A. Because I requested a public records request and found that he got sick payout. Q. Okay. Do you know the reasons behind? Did that records request reveal why he got it? A. I don't know. I don't know if there was a reason why. I have to look at the paperwork I have. Q. You don't recall here today though, right? A. No, I don't. Mr. Savage, no further questions. Mr. Mastromarco, Jr., everybody done then? Mr. Savage, I think so. Mr. Catanzaro, I am. Mr. Savage, I am too. Mr. Mastromarco, Jr., great. We are going to read it before. Court reporter, please provide us with a copy. The deposition was concluded at 5:20 p.m. Certificate of oath.
Yeah. Sometimes I get so mad, there's no controlling me. My thoughts get so bad, I'm like, I might grab a bat, I don't know. My wrath, my blood boils over like, oh God, here goes. I lost all feeling from my head to my toes.